Tabling of documents, dépôt des documents, the Honourable Parliamentary Secretary to the Minister of Aboriginal Affairs.
Monsieur le Président, en conformité avec...
Mr. Speaker, in accordance with Standing Order 22, I have the honor to table in both official languages
2011-2012, the 2009-2010 and 2010-2011 annual reports of the Yukon Land Claims and Self-Government Agreements, the West Bank First Nation Self-Government Agreement Annual Report on Implementation 2010-2011, and the 2011-2012 Tawasin First Nation Annual Implementation Report.
The Honourable Parliamentary Secretary to the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, pursuant to Standing Order 36.8, I have the honour to table in both official languages the government's responses to 12 petitions.
Is the Honourable Member for Winnipeg North rising to table a document?
No, Mr. Speaker, I was actually rising on a privilege matter, if this be the appropriate time for me to...
Yes, the Chair does have notice of several questions of privilege, and as I usually do, I was planning on taking them after routine proceedings. Tabling of documents, dépôt de documents. Dépôt de projet de loi émanant du gouvernement.
Introduction of government bills.
Déclaration de ministre.
Statements by ministers.
Interparliamentary delegations. Presenting reports from committees. Presenting reports from committees? No. Oh, there we are. The Honourable Member for Lambton, Kent, Middlesex.
Thank you. Thank you, Mr. Speaker, and I have the honour and present in both official languages the first report of the Standing Committee of Agriculture and Agri-Food in relation to its study of the Canada-European Comprehensive Economic Trade Agreement, recognized as CETA, and the effects of it on the Canadian agriculture sector. Pursuant to Standing Order 109 of the House of Commons, the committee requests that the government table a comprehensive response to this report.
Introduction of private members' bills. Mr. Fletcher, seconded by Ms. Perot, moves for leave to introduce a bill entitled An Act to Amend the Criminal Code, Physician-Assisted Death. This motion is deemed adopted. The Honourable Member for Charleswood St. James, Assiniboia.
Thank you, Mr. Speaker. I am honored to have the opportunity to present what I think will be a historic piece of legislation. This legislation will amend the criminal code to allow physicians to assist individuals at the end of life. It is a bill that will empower individuals, competent adults, to make the best decisions for themselves, while at the same time protecting society's most vulnerable individuals.
Monsieur, what's that? Oh, yes. Monsieur Fletcher, appuyé par Madame Perot.
Mr. Fletcher, seconded by Ms. Perot, moves that the bill be read a first time and printed. The motion is deemed adopted. When will the bill be read a second time?
Mr. Fletcher, seconded by Ms. Perot, moves for leave to introduce a bill entitled An Act to Establish the Canadian Commission on Physician-Assisted Death. This motion is deemed adopted. The Honourable Member for Charleswood St. James, Assiniboia.
Thank you, Mr. Speaker. Given the profound impact that the previous bill that was just introduced, amending the criminal code to allow for physician-assisted death, it is felt that an act to establish the Canadian Commission on Physician-Assisted Death would allow for the collection of data such as vital statistics, sex, education, types of illnesses that would fall under the previous bill, and also create a commission that could provide suggestions and recommendations to the government or to colleges of physicians and surgeons as time goes on. Thank you, Mr. Speaker.
Mr. Fletcher, seconded by Ms. Perot, moves that the bill be now read a first time and be printed. This motion is deemed adopted.
First reading of this bill. Première lecture de ce projet de loi.
When shall the bill be read a second time? At the next sitting of the House. First reading of Senate public bills. Motions. Motion. The Honourable Member for Wild Rose.
Mr. Speaker, I would seek the unanimous consent of the House for the following motion. That the Standing Committee on Procedure and House Affairs be instructed to consider the matter of accusations of the official opposition's improper use of House of Commons resources for partisan purposes, and that the Leader of the Opposition be ordered to appear as a witness at a televised meeting of the committee to be held no later than May 16, 2014.
Does the Honourable Member have the unanimous consent of the House for this motion? No. There's no consent. Motions. Motion. The Honourable Minister for the Status of Women.
Mr. Speaker, I move pursuant to Standing Order 51.1 and seconded by the PS to the House Leader that the Standing Committee on Procedure and House Affairs be instructed to consider the matter of accusations of the official opposition's improper use of House of Commons resources for partisan purposes, and that the Leader of the Opposition be ordered to appear as a witness at a televised meeting of the committee to be held no later than May the 16th, 2014. 56.1. Seconded by the PS to the House Leader.
Ms. Leach, seconded by Mr. Lekuski, moves pursuant to Standing Order 56.11A. That the Standing Committee on Procedure and House Affairs be instructed to consider the matter of accusations of the official opposition's improper use of House of Commons resources for partisan purposes, and that the Leader of the Opposition be ordered to appear as a witness at a televised meeting of the committee to be held no later than May 16, 2014. Will those members who object to the motion please rise in their places? Fewer than 25 members having risen, the motion is adopted. First reading of Senate public bills. Oh, sorry, I already did that. Presenting petitions. Présentation des pétitions. The Honourable Member for Thunder Bay, Rainy River.
Thank you very much, Mr. Speaker. I have a petition where the petitioners call upon the Government of Canada to recognize animals as sentient beings that can feel pain and move animal cruelty crimes from the property section of the Criminal Code and strengthen the language of federal animal cruelty law in order to close loopholes that allow abusers to escape penalty. Thank you, Mr. Speaker.
Presenting petitions. The Honourable Member for Kitchener-Conestoga.
Thank you, Mr. Speaker. Mr. Speaker, I have the honour to present petitions signed by a number of residents from the Waterloo region. Petitioners are calling on the Minister of Health and the House of Commons to pass Bill C-356, an act respecting a national strategy for dementia. Thank you, Mr. Speaker.
The Honourable Member for Winnipeg North.
Yes, thank you, Mr. Speaker. Today I rise on a petition from many people in Winnipeg North that are concerned about health care in Canada, and they're calling upon the government to ensure that the Canada's Health Act and improve accountability on health care services that are in fact being delivered. Obviously very much concerned about the health care accord and how important it is that the federal government renegotiate and have a new health care pact for the next decade. Thank you, Mr. Speaker.
The Honourable Member for Glengarry Prescott Russell.
Thank you very much, Mr. Speaker. I have here two petitions from Canadians who recognize the inherent rights of farmers to save, reuse, select, exchange, and sell seeds, and they're calling upon Parliament to enshrine in legislation the inalienable rights of farmers and Canadians to save, reuse, select, exchange, and sell seeds. Thank you, Mr. Speaker.
Presenting petitions. The Honourable Member for Algoma, Manitoulin, Kapuskasing.
Thank you, Mr. Speaker, and I'm pleased to rise on behalf of Canadian citizens from Sault Ste. Marie, Richards Landing, Echo Bay, Bruce Mine, Searchmont, Thessalon, and Wawa on a petition. They're concerned that the train is about to leave their community, And they're asking the government to reinstate the federal funding that allowed for the operations of the Algoma Central Railway. They indicate how difficult this will be on their communities, on their homes, and particularly on the business, especially the tourism business. So, before the train leaves the station, they would like this government to act on assisting with the funding at least for another year. And they would greatly appreciate the support of the Conservative government as opposed to seeing job loss in the riding in Northern Ontario. Thank you.
The Honourable Deputy Drummond.
The Honourable Member for Drummond. Thank you, Mr. Speaker. I rise today to table dozens of petitions with regard to cuts to Via Rail, as my colleague has just said. My citizens in Drummond are concerned with these cuts. In fact, last year, the rail service was automated, and service is less adequate, especially for seniors and those with reduced mobility. Therefore, petitioners are calling on the Government of Canada to put an end to the cuts to Via Rail as included in the 2013-2014 budget, and they are asking the government to reinstate services at the Drummondville train station.
Avalon.
Thank you very much, Mr. Speaker. I rise to present a petition from several hundred residents of Chapel Arm, in my riding, who are very upset about the closure and the reduced postal office hours. And they are calling upon the Government of Canada and Canada Post to maintain and expand and improve postal services and cease any proposal to reduce hours and diminish services to the residents of Chapel Arm in Newfoundland and Labrador. Thank you.
The Honourable Member for Lambton, Kent, Middlesex.
Thank you, Mr. Speaker. And I have petitions in my hand to acknowledge the current impaired driving laws that are too lenient in the interest of public safety. They're asking to see tougher laws and implementation of a new mandatory minimum sentences for impaired driving causing death. We also want the Criminal Code of Canada to change to redefine the offence of impaired driving causing death as vehicular manslaughter. Thank you, Mr. Speaker.
The Honourable Member for Vancouver Quadra.
Speaker, and I'm honoured to table a petition from the UBC School of Nursing students, UBC being in the riding of Vancouver Quadra, and the students wish to bring to the attention of the House their deep concern about the expiry of the 2004 Health Accord in March 2014. They note that Ottawa has already cut funding to the Health Council of Canada, which is funded solely at the federal level and oversees the promises outlined in the Health Accord to ensure they're upheld. So the nurses from UBC call on the House of Commons to reconsider the dismantling of the Health Council of Canada and to agree to a 2014 Health Accord, thus renewing government's commitment to a sustainable and universal health care system. And Mr. Speaker, with your permission, I have a second petition. This petition is from the about fair electoral representation, and it is constituents of Vancouver Quadra, and they are calling on the House of Commons to immediately undertake public consultations across Canada to amend the Canada Elections Act to ensure that voters can cast equal and effective votes, to be represented fairly in Parliament, that they are governed by a fairly elected Parliament, and that they live under legitimate laws approved by a majority of elected parliamentarians representing a majority of voters. So these are members of my constituency that are concerned about our winner-take-all voting system that we currently have in Canada.
Présentation des pétitions.
Presenting of petitions, the Honourable Member for Pierrefonds-Dollard. Thank you, Mr. Speaker.
Canadian permanent residents who came to Canada as temporary foreign workers or international students. The petitioners call upon the House of Commons to consider amending the Canadian Citizenship Act to recognize non-permanent residency time to be counted towards the citizenship residency requirement. Thank you, Mr. Speaker.
Presenting petitions, présentation des pétitions. Questions on the order paper. The Honourable Parliamentary Secretary to the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, question Q302 will be answered today. Furthermore, Mr. Speaker, if a revised response to question Q192, originally tabled on March 24, 2014, could be made in order for a return, this return would be tabled immediately.
This is the pledge of the House that question number 192 be made an order for revised return and that it be tabled immediately. Agreed? Agreed and so ordered. The Honourable Parliamentary Secretary.
Thank you. Lastly, Mr. Speaker, I ask that the remaining questions be allowed to stand.
Is that agreed? Agreed and so ordered. The Chair has notice of several questions of privilege, and I will take them in which the order I received the notice. So I'll go first to the Honourable Member for Avalon.
Thank you very much, Mr. Speaker. I rise on a question of privilege under provisions of Standing Orders 48, alleging obstruction by the Minister of the Atlantic Canada Opportunities Agency, HoC, as per notice that I've provided to you. I will be asking you, Mr. Speaker, to make a prima facie case finding that a breach of privilege has occurred concerning a response to an order paper question which was tabled in this House. Specifically, the Minister has changed the process and now intentionally interfered to obstruct the release of information pertinent to my writing and therefore impeding my abilities to perform my duties. Mr. Speaker, some other questions of privilege have been raised in this House concerning order paper questions, have been deemed to be a question of the accuracy of the answer of the question. Mr. Speaker, I agree that you are not able to determine the accuracy of the answers to order paper questions, and I would not raise a question of privilege to do so. I understand that these historical cases did not constitute a prima facie case breach of privilege. However, Mr. Speaker, the breach of privilege that I'm raising today does not in any question the accuracy of the answer provided by the Minister of HoC, as I did not receive an answer that provided the requested information. Unfortunately, I have to rise with this question of willingness of the Minister to provide important information from his department. All members know, as outlined in the House of Commons Procedures and Practice, a question placed on the order paper by a member to seek answers from a department pertaining to public affairs. And the context of my question was such to see what projects HoC had approved in the riding of Avalon. Mr. Speaker, it is important that I briefly present the facts that led to this breach of privilege, as it is important to understand that this is not a question of accuracy. It is indeed a question of why the Minister was willing to provide answers to the questions in the past, but now refuses to provide questions to the same question. Again, Mr. Speaker, this is not a question of accuracy, but concerning the willingness of the Minister to cooperate and provide an answer. Mr. Speaker, I place a past order paper question concerning projects funded in part or in full for my riding through HoC. On each occasion, the Minister provided a detailed list of all approved projects within the riding. The information provided included a detailed list including project description, location, applicant, approval dates, and funding levels. And the information was provided as such. Mr. Speaker, this brings me to the question of privilege concerning a response to the most recent order paper, Q176, where I asked for a list of projects that HoC funded in my riding for a more recent time period. Unfortunately, the answer did not provide the information that was previously provided by simply stating HoC doesn't track projects by riding. Mr. Speaker, this is a different change in the direction of the department, and I feel it's wrong that the Minister has provided this answer to the House. In the past, I've obtained the requested information from the department, and now the Minister has become secretive and refuses to provide information. Mr. Speaker, it is most relevant to understand that order paper questions have always been accepted parliamentary privilege for all members of this House to receive answers to important questions on public affairs. Mr. Speaker, the Minister for HoC has unfortunately obstructed this long-standing privilege to receive such answers, and my work as a parliamentarian has been infringed upon. Mr. Speaker, the question I asked in 2010 was answered and the information provided. Unfortunately, we now have a Minister that has intentionally interfered with my ability to obtain the same information for a later period. It is wrong, and we need to ensure that parliamentary rights are protected, and I ask you to review these facts to ensure we are not heading down a path whereby ministers get to decide when they provide answers to these important questions. I would conclude and quote Mangot's Parliamentary Privilege in Canada, page 239. Untruthful, equivocating, provocating, insulting, and trifling actions have been held in the UK to be contemptuous, as has the refusal to answer questions. Mr. Speaker, if you do find a prima facie case of privilege, I'm prepared to move the appropriate motion. Thank you.
On the same question, the Honourable Government House Leader.
Very quickly, I will want to acquaint myself further with the facts and have a further response to you, but I do want to point out that although the member protests greatly that there was no response, in fact, there was a response to his question, and he is unhappy that the response is not in the detail and does not provide the information that he would like. And I will point out that at Chapter 11, page 522 of the Big Green Book, it reads as follows: there are no provisions in the rules for the Speaker to review government responses to questions. Nonetheless, on several occasions, members have raised questions in the privilege regarding the accuracy of information contained in responses to questions. In none of these cases was the matter found to be a prima facie breach of privilege. The Speaker has ruled that it is not the role of the Chair to determine whether or not the contents of documents tabled in the House are accurate, nor to assess the likelihood of an honourable member knowing whether the facts contained in a document are correct. Again, he did receive a response. His problem is that the response is not as detailed as he might have received on another occasion, or that the information isn't what he would have liked to have, but that is really a debate over the adequacy of the response, not the fact of whether or not there was a response. And we will respond after we have a few more details as well.
On the same question, the Honourable Opposition House Leader.
Thank you very much, Mr. Speaker. In the past, you have already studied this matter, and it is not the quality of the answers that is lacking, but it is not necessarily up to you to rule on the quality of the answers of the government. So we will probably have things to add. So I just want to say that we'll be coming back to this matter. Thank you.
To further submissions on this question, the Honourable Member for Charlottetown has also advised me of a question of privilege, and I'll hear him now.
Thank you, Mr. Speaker. I rise on a question of privilege pursuant to Standing Order 48 to allege that the Attorney General of Canada and Justice Minister misled this House yesterday during question period. Mr. Speaker, we cannot accept a situation where the Chief Legal Officer, the Attorney General of Canada, would rise in his place and in response to a direct question put to the Minister misleads the House by making statements that are demonstrably untrue. Here are the facts. In January of this year, I submitted, pursuant to the standing orders, a written question that reads as follows. With regard to Section 33 of the Canadian Charter of Rights and Freedoms, A, what is the current policy of the government, particularly the Department of Justice, about the use or invocation of Section 33? And B, since 2006, how many times has the government directed, suggested, contemplated, or requested an analysis, examination, or consideration from departmental officials within the Department of Justice, the Privy Council Office, or any government department about the possible use of Section 33? End quote. The written response, signed by the Attorney General himself, stated, and I quote, the Department of Justice, A, the Department of Justice has no policy on the use or invocation of Section 33 of the Canadian Charter of Rights and Freedoms, commonly referred to as the Notwithstanding Clause. To date, Parliament has not made a legislative declaration pursuant to Section 33, although certain provincial legislatures have done so. That's the full response, Mr. Speaker. There was no response to the B part of the question. Mr. Speaker, that was the Attorney General's response he provided to the House of Commons on Monday, March 24th, 2014, 3 days ago. 2 days later, yesterday, Wednesday, March 26th, there was a question and answer exchange between me and the Attorney General during question period. I posed the following question, and I quote, Mr. Speaker, the Minister of Justice has refused to answer my written question about whether he or any of his political staff have ordered justice officials to review the use of the notwithstanding clause to overrule Supreme Court decisions. The courts have slapped down the Conservative legislation on sentencing, fine surcharges, prostitution, their unconstitutional judicial appointment, and, lest we forget, this minister fought veterans in court and lost. Will the minister tell this House when did he or his staff first order departmental officials to assess the use of the notwithstanding clause? The relevant portion of his response was, and I quote, "Mr. Speaker, I have no idea why this member is insisting on government examining the use of the notwithstanding clause unless it is based on the fact that it was his government, his party, that were the only ones to ever use it. Maybe the member has a propensity for the use of the notwithstanding clause." The answer went on to describe the situation with regards to veterans, not particularly pertinent to the point that I seek to make, Mr. Speaker. Mr. Speaker, the House relies on members and ministers of the Crown to speak the truth, and arguably this burden rests in a heavier way upon the Attorney General of Canada, the chief legal officer for the country and an officer of the court. It cannot be tolerated by this House to have the Attorney General stating without equivocation on Monday, and I quote, "To date, Parliament has not made a legislative declaration pursuant to Section 33, and then the Attorney General, for what must be assumed to be partisan purposes, to directly contradict himself by saying 2 days later, in response to a question about the notwithstanding clause, the following, and I quote, "I have no idea why this member is insisting on the government examining the use of the notwithstanding clause unless it is based on the fact that it was his government, his party, that were the only ones who ever used it." Mr. Speaker, we have before the House two statements made by the same minister directly in conflict with each other. It cannot be said that this was an error because one statement had been made some time ago, thus attributing it to poor memory. And I sincerely hope that this is not a situation where the minister doesn't know the facts regarding the history of the use of the notwithstanding clause. Two directly contradictory statements were made in the House within a period of 48 hours. And this is not inconsequential, Mr. Speaker. To make matters worse, the Attorney General rose sometime later on an attempted point of order in order to clarify his conflicting statement. He apparently sought to clarify his statement in response to a previous point of order from the honourable member for Mount Royal, who I should note clearly and factually indicated that a Liberal government had never invoked the notwithstanding clause, nor had there been any evidentiary basis to suggest that there was a threat to do so. Here is what the Attorney General stated as he attempted to clarify his remarks, and I quote, "Mr. Speaker, for clarity, I wish to ensure that my answer did not imply that the Liberal government of the day invoked, which is the word that the member used, the notwithstanding clause, but threatened to use it." Mr. Speaker, the Attorney General, in attempting to clarify his remarks, further misled the House. The Attorney General effectively doubled down by suggesting that his answer to me during question period did not imply something that we know from the record he had stated clearly as a point of fact. Again, Mr. Speaker, the record will show that the Attorney General told the House one thing on Monday, something entirely different on Wednesday in response to a question during question period, and then further misled by suggesting that that isn't what he said. That he further misled by saying that he didn't say what he said. Mr. Speaker, this is no minor matter, and this is not the first time that this House has been confronted with conflicting statements from a Minister of the Crown. You will recall, Mr. Speaker, former Conservative Minister for International Cooperation, Bev Oda, who repeatedly told the House of Commons she knew nothing about the matter of who had inserted the now famous "not" on a cabinet document that was meant to approve funding for Kairos. The infamous "not" had the effect of killing funding for Kairos. That minister then repeatedly told the House that she has no knowledge as to who inserted the famous knot, only to disclose sometime later, when confronted with evidence, pointed to the fact that she not only had knowledge of the infamous knot, but she in fact had ordered its insertion. On a point of privilege raised by my colleague, the honourable member from Scarborough-Guildwood, Speaker Milliken determined that indeed there was a prima facie case to suggest that the then Minister of International Cooperation had misled the House. More recently, we had the situation of the member from Mississauga-Streetsville, who stood accused of knowingly misleading the House with a statement in relation to the so-called Fair Elections Act. In that instance, the member from Mississauga-Streetsville told this House that he had witnessed voter fraud during the 2011 election. The member made that false claim as a way to provide some credibility to the so-called Fair Elections Act. He retracted that statement after a significant period of time had lapsed, and only when his claim was proven to be false. In your ruling, Mr. Speaker, you quoted a previous decision rendered on May 7, 2012, in which you outlined the test needed to be applied that would give rise to a prima facie point to a member misleading the House. You said, and I quote, 1, it must be proven that the statement was misleading. 2, it must be established that the member making the statement knew at the time that the statement was incorrect. And 3, that in making the statement, the member intended to mislead the House. Point number 1. To prove that the statement is misleading, in the case before you, Mr. Speaker, one need only examine the legislative record. The legislative record is very clear. The answer that the minister gave to the written question on Monday is accurate. No government of Canada, no Liberal government, no Conservative government, no government of Canada has ever invoked the notwithstanding clause. That can be discerned from the legislative record. 2, it must be established that the member making the statement knew at the time the statement was incorrect. Well, he certainly knew on Monday when he signed the document that was tabled in the House that indicated the correct state of affairs. And 3, that in making the statement, the member intended to mislead the House. There are only 2 explanations for his intentions. Number 1, he didn't know, or number 2, he did but attempted to mislead. Mr. Speaker, I find it difficult to imagine that a parliamentarian of his experience, someone who sits in the Cabinet, didn't know the true state of affairs. There's only one possible explanation left. Mr. Speaker, I will be asking you to review the record and to review the statements made by the Attorney General. I submit that the statements made by the Attorney General contain all the elements you outlined in your previous ruling. I believe that upon review, you will find that it is a clear case that the Attorney General deliberately attempted to mislead the House by way of his statement, or in this case, a series of statements that he knew or ought to have known those statements to the House were either false or an attempt to mislead. We expect people to speak the truth, not to play loose with statements that are purporting to be statements of fact. Indeed, to deliberately mislead the House is a clear contempt of Parliament and must be addressed. This is particularly problematic in that these misleading statements were made by the Attorney General of Canada. And, Mr. Speaker, if you find there is a prima facie breach of privilege in this case, I am prepared to move the appropriate motion. Thank you, Mr. Speaker.
On the same point, the Honourable Minister of Justice.
Thank you very much, Mr. Speaker. And I would certainly rebut the presumption that the Honourable Member from Charlottetown is presenting to the House that I have deliberately misled this House in any way. In fact, Mr. Speaker, as he himself in his presentation has reminded the House, is that I rose at the first opportunity in an effort, as is clearly reflected in Hansard, to qualify or clarify what was said, and I quote, "I wish to ensure that my answer did not imply that the Liberal government of the day," and I used the word invoked, repeating the words that were put on the record by the member from Mount Royal, who rose on the initial point of order yesterday and was actually ruled out of order on a point of order by the Speaker. But in fact, my answer goes on to say, with respect to invoke, which is the word that the member used, the notwithstanding clause, but threatened to use it. Members may recall that the former Prime Minister Paul Martin, certainly the member for Mount Royal, and at that time I was interrupted by the Speaker, not yourself, another Speaker, the Chair, reminded that I was not, in his view, permitted to continue with my answer, with my response. I then again tried to complete my statement on the record and was prevented to do so by the Chair. So, Mr. Speaker, what I was referring to, obviously, in that clarification was the use of the notwithstanding clause at that time was the threatened use, the political use, which was clearly the case in 2004. And I'm quoting now from a CBC report that says Prime Minister Paul Martin says he would use the Constitution's notwithstanding clause if the Supreme Court rules that churches must perform gay marriages. It was in that context. And he went on to say, when asked by a reporter whether he would use the notwithstanding clause, and he said, I quote, "Oh, yes, I would." Mr. Speaker, that was the reference that I sought to clarify when I rose in this chamber yesterday. Mr. Speaker, that clause, as you know, is in the Constitution by virtue of the Liberal government of the day. The member opposite is somehow trying to imply, both through his question to the department, which was answered, as he mentioned, Mr. Speaker, he referenced the fact that he had sought information from the Department of Justice with respect to Section 33 of the Charter of Canadian Rights and Freedoms. What is the current policy of the government, particularly the Department of Justice, about the use or invocation of Section 33? The answer that he received is quite clear. The Department of Justice has no policy on the use or invocation of Section 33 of the Canadian Charter of Rights and Freedoms, commonly referred to as the notwithstanding clause. He then opines and complains that there wasn't an answer to the second part of his question, which goes on to say, how many times has the government directed, suggested, complained, contemplated, requested analysis, examined, consideration? Well, if there is no policy, Mr. Speaker, why would the government or the Department of Justice then respond to the second part about how many times it was used or contemplated use? So he can't have it both ways. He can't say how many times has the government contemplated using it. He's told that there is no policy in this regard, and then now seems to suggest somehow that there was an incomplete answer given to him by the department. The clarification that I sought yesterday, the clarification today, is the use, the political use, the threatened use of a government in this country was a Liberal government of the day, Mr. Speaker. It was not the current government. It was not this minister. It was a government which was a party of which the member opposite is a member. I would suggest that that clarification was provided in earnest yesterday. That was in response to the attempted question of privilege raised by the member's colleague, the member from Mount Royal. I rose at the earliest possible opportunity to provide that clarification. There was no deliberate use, and I specifically said that I did not use the word invoked, and that is a key word that the member from Mount Royal tried to attribute to me in his attempted point of order yesterday. So, Mr. Speaker, I hope that that provides necessary explanation for you to make the proper ruling, which is to find against the member from Charlottetown.
On the same question, the honourable member for Burnaby, New Westminster.
Monsieur le Président, on a beaucoup de difficultés avec le manque.
Mr. Speaker, I have a lot of difficulty with this government's attitude. I've said it many times. This is an issue that interests us a great deal as well, and we will come back to the issue a little later on, and we reserve the right to speak at that point in time. Thank you.
Honourable member for Charlottetown.
Mr. Speaker, I just want to come back to this specific answer that was given in question period yesterday and this further attempt at clarification. The minister yesterday stated as a fact, and he used that word, as a fact, that it was, he said his government, meaning a Liberal government, were the only ones who ever used it. So he stated that as a fact. This isn't an implication, and this is with the greatest of respect, Mr. Speaker, an attempt to obfuscate or confuse. He stated as a fact something which he has, even in his response today, indicated that he knows not to be true.
I thank the honourable members for raising this matter, and as the Minister of Justice pointed out, this was deemed to be a dispute as to the facts yesterday by the chair occupant. After listening to the debate over whether or not the definition of the word used or how that would be applied, it seems to me that this is a dispute as to the facts, and one member's interpretation of the word over another, not something that would rise to the threshold of a question of privilege. So I'm going to make that determination at this point after listening to and after examining the transcripts of yesterday. The chair also has notice for the member for Winnipeg North on a question of privilege.
Yes, thank you, Mr. Speaker. I, too, rise this morning because I am concerned in terms of the member from Edmonton Centre and statements that he made back on March the 24th, just earlier this week, Mr. Speaker. And maybe to make it very clear, on that day we were actually debating Bill C-23, which was the Fair Elections Act, and that's the government's term, Fair Elections Act, I must say, Mr. Speaker, when the member from Edmonton Centre, I believe, deliberately intended to mislead the House. And I do not say that lightly, Mr. Speaker, because that is a form of contempt of the House. And what I would like to do is refer to a ruling that you just recently made, Mr. Speaker, a ruling dealing with another member. In fact, it was the member from Mississauga-Streetsville that just recently made a statement. And if I could first go to what it is that that member stated, Mississauga-Streetsville, and then your comments as to why it was important that we be very careful with what we said. So I'm going to refer to your ruling from just the other day, if I may, Mr. Speaker. And you'll recall, the member from Mississauga-Streetsville stated, and he would have stated this originally back on February 6th, I have actually witnessed other people picking up the voter cards, going to campaign office of other whatever candidate they support, and handing out these voter cards to other individuals, who then walk into voting stations with friends with vouch for them with no ID. Well, Mr. Speaker, you articulated a ruling in which many of us in the chamber actually supported quite vividly, Mr. Speaker, because we believe that you were right in your assessment. And this is, in essence, what it is that you had stated, Mr. Speaker. This incident highlights the importance of accuracy and truthfulness in our deliberations. All members bear a responsibility, individually and collectively, to select the words they use very carefully and to be ever mindful of the serious consequences that can result when this responsibility is forgotten. In calling on the chair to arrive at the finding of a prima facie, in this case, the Honourable House Leader of the Official Opposition cited my ruling of May 7, 2012, where at page 7650 of the debates, I reminded the House that before finding that a member had deliberately misled the House, 3 conditions had to be met. And then you stated those 3 conditions, Mr. Speaker. 1, it must be proven that the statement was misleading. 2, it must be established that the member making the statement knew at the time that the statement was incorrect. And 3, that making the statement, the member intended to mislead the House. Well, Mr. Speaker, I would really want to emphasize what it is that we were debating at the time. That was, once again, much like on your ruling, it was on Bill C-23. It is an extremely important piece of legislation, and as you know, Mr. Speaker, it is exceptionally controversial. Exceptionally controversial. And what has happened is that we've had very emotional debates on both sides of the House. But it is expected that when an individual participates in that debate, that they are not going to in any way try to intentionally or deliberately mislead. And this is what I believe has happened here, Mr. Speaker. Let me go right to the quote of what it is the member from Edmonton Centre actually stated. But keep in mind, Mr. Speaker, the debate on that day was all about vouching, and the government's position on vouching is that we should not allow vouching. And that is what it is that they were trying to espouse throughout that day, Mr. Speaker. And here is what the member stated, and this can be found on page 3778, March 24. In the 2006 election, I was called personally and offered hundreds of voter cards that had been left in apartment buildings and so on. Like an idiot, I said, no, we don't do that sort of thing. I should have said, yes, come on down, and had the police waiting. Well, Mr. Speaker, it is very obvious that the member from Edmonton Centre recognized instantly that something was really wrong with that phone call. And with hindsight, felt that it was an illegal thing that had occurred because he believed that the police should have been contacted on the matter. To the best of my knowledge, I don't believe that the police were contacted, and I hope that the member will, in fact, address that particular issue. But more importantly, Mr. Speaker, since this statement, we have found out that those voter cards that we are debating today were not being used back in 2006, and this is coming from Elections Canada, Mr. Speaker. And the reason why, Mr. Speaker, that the member was focused on the voting cards was because he was trying to discredit the idea of Canadians being able to be vouched for. And I think that is of critical importance, Mr. Speaker. You know, on page 65 of Erskine's and May's parliamentary privilege, it is defined as the sum of peculiar rights enjoyed by each House collectively and by members of each House individually, without which they could not discharge their functions. I was here Monday when I heard the member make the statement, Mr. Speaker, and there is no doubt in my mind that by making that statement, his intent was to try to give the House the impression that vouching and illegal activities were in fact taking place and that vouching was wrong. Now, Mr. Speaker, I do believe that if we review some of the statements that were being put forward, Mr. Speaker, by the member at the time and contradicted by potential media reports, Mr. Speaker, one was CBC, I've read through Hill Times, and others that are there, Mr. Speaker, that it seems to contradict what it is that the member from Edmonton Centre was trying to leave in terms of members of the House on March the 25th to believe. So I would suggest to you, Mr. Speaker, that it would in fact be appropriate, and I look forward to the member from Edmonton Centre's contribution to this particular issue. But having said that, I will ask that you find that there are grounds that exist, that this is prima facie contempt of Parliament, at which point I will be prepared to move a motion to have the matter referred to an appropriate committee for further study. Thank you, Mr. Speaker.
And the honourable member for Edmonton Centre.
Very much, Mr. Speaker, and I listened with obvious interest. My honourable friend gives me far too much credit for Machiavellian intrigue. It had nothing to do with trying to mislead anybody. It was simply stating a fact, and I don't recall him being in my office that day during the campaign in 2006, nor him listening in on phone calls. He can choose to believe the phone call happened or not. That's up to him. That does not constitute a case of trying to mislead anybody about anything. It was simply stating a fact. With respect to the voter identification cards, they indeed did exist in 2006. They were used, but they were not authorized to be used as a primary or sole form of identification. But they were certainly there. Now, what Elections Canada allows to happen, whether it's voter ID cards or vouching or whatever, what they say, yeah, say, no, they were not allowed to be used, and vouching was only supposed to be 1 for 1. That doesn't mean that people aren't trying to get around those regulations. Mr. Speaker, human nature being what it is, people will always try to game a system, and people will always try to do that for advantage. In the heat of an election, as the member well knows, yeah, I got the phone call, and yes, in retrospect, I should have invited him down. I should have had the police waiting, and so on. You're in the heat of an election. You don't have time, frankly, to deal with that kind of nonsense. Just put it aside and move on to the election. There was no attempt to mislead anything, Mr. Speaker. It was simply stating a fact. I got a phone call. That was the request. Voter cards did exist in that election, not to be used as primary ID. So I wasn't misleading anybody about anything. And I do appreciate him thinking that I'm smart enough to be that Machiavellian, but it's just simply nonsense, Mr. Speaker.
Will Government House Leader.
Thank you very much, Mr. Speaker. I'd like to elaborate a little bit further, because what we are essentially having here raised under the point of order is actually a debate as to the issue that's in the legislation. There are some very important facts, though, that have been omitted from the submission. And the first fact that was omitted from the submission is that regardless, the wording was used very carefully, that cards like this were not used by Election Canada for identification at the time. The implication being that there were no such cards. There were voter information cards sent out by Elections Canada to electors at that time. They did receive them, hence the phone call that the honourable member received. And having been Minister of Democratic Reform in the period after 2006, I can tell you the reason why Elections Canada can say with certainty they were not authorized for use as identification is because we had not yet passed into law the requirement to show identification when you vote. So, of course, they were not used for a provision that did not yet exist in the law. So the fact that they weren't used for that purpose is kind of a red herring and entirely irrelevant. Everybody knows what the practice was in those days. There was no requirement that you showed up with voter identification, no requirement that you show identification. And what most people did was walk in, take the card they had received at their home, present it, say, I'm here to vote. There was no inquiry into whether that was who they were or not, but the election official simply accepted it, and you voted on that basis. And that's why the action of which the honourable member from Edmonton Centre was referring was one where somebody was saying, hey, we know a way that you can probably achieve fraud here, and the reason we know you can do this is because anybody who in an apartment threw away their card is unlikely to bother showing up to vote. So a good chance someone else can show up in their name presenting the card and do so. So when you look at all those facts, it's quite clear that nothing the honourable member from Edmonton Centre said was incorrect or misleading in any way. In fact, if someone is misleading right now, it's the individual who's trying to raise the point of order, the point of privilege. He's the one who's misleading the House because he's implying that there were voter identification provisions that didn't exist in the law at the time, and he's implying that the Elections Canada didn't send out such cards, which they did do at that time. So I would say that this is an open-shut case. There is no question of privilege here to be presented. This is a very, very different matter than what was raised earlier in the House.
On the same point, the honourable member for Dartmouth Cole Harbour.
Thank you, Mr. Speaker. And I listened with great interest to the point being raised by the member from Winnipeg North. And while there may be some merit to it, I would like to, on behalf of the official opposition, indicate that we reserve the opportunity to comment at a later point in time. We just haven't had the opportunity to consider the merits in some detail.
I do understand the honourable member's desire to weigh in on this, but allow me to save him the trouble after listening to the statements by the member for Winnipeg North and the response from the member for Edmonton Centre. There certainly isn't anything before the chair as to any kind of evidence that the member knowingly said anything that he did not, that he knew at the time not to be true, that he had, it seems to be a dispute as to what may or may not have happened in the 2006 election, but certainly nothing that would indicate to the chair that the member has knowingly misled the House. Members are free to have this kind of debate when the bill is back in the House and that committee, but I don't think it should be brought onto the floor as the debate continued under the guise of a question of privilege, because there certainly isn't anything that I've heard that would raise to that level. So Let's move on to orders of the day. Order du jour.
Government orders, government bills, comments.
The Offshore Health and Safety Act.
There being no motions at report stage, the House will now proceed without debate to the putting of the question on the motion to concur in the bill at report stage. Ms. Leach for Mr. Rickford, seconded by Mr. Alexander, moves that Bill C-5, an act to amend the Canada-Newfoundland Atlantic Accord Implementation Act, the Canada-Nova Scotia Offshore Petroleum Resources Accord Implementation Act, and other acts, and to provide for certain other measures as amended, be concurred in at report stage. Is it the pleasure of the House to adopt the motion? Agreed? When shall the bill be read a third time? Right now? Ms. Leach for Mr. Rickford, seconded by Mr. Alexander, moves that Bill C-5, an act to amend the Canada-Newfoundland Atlantic Accord Implementation Act, the Canada-Nova Scotia Offshore Petroleum Resources Accord Implementation Act, and other acts, and to provide for certain other measures, be now read a third time and do pass. Debate. The Honourable Minister of Labour.
Thank you very much, Mr. Speaker.
I'm very proud to add my voice to support this worthy legislation.
Our government has been crystal clear about when it comes to energy development is that the public health and safety and environmental protection are paramount. This is the very essence of reasonable resource development. There's no question we are determined to create high-quality jobs, economic growth, and long-term prosperity for all Canadians. And the energy sector has certainly delivered that to Atlantic Canadians in recent years. Since the oil and gas industry began operating in Newfoundland and Labrador offshore in the late 1960s, the region's economy has been transformed. In 2010, the industry generated wages, salaries, and benefits worth $291 million in the province of Newfoundland alone. Not only does the sector clearly make a major contribution to the livelihoods of workers, it improves the standard of living of all residents in the region. And there is also no debate that we recognize that it would be irresponsible to promote development without the assurance of the health and safety of our citizens and the protection of our environment being fully addressed. That is precisely why Bill C-5 is designated to. It will better safeguard Atlantic offshore oil and gas workers. Mr. Speaker, the Canadian Association of Petroleum Producers reports that over 5,000 individuals are currently employed in the oil and gas industry in Newfoundland and Labrador, and almost 1,000 more work in Nova Scotia's petroleum sector. And the potential is great for even more jobs and economic growth in the near future. Recent offshore oil and gas discoveries are bringing a new wave of activity into the Atlantic provinces. All the more reason, then, for Bill C-5. Workers in the industry need to be protected, given the dangerous conditions associated frequently with their jobs. Under the Canada Labour Code, workers are protected from hazards in the workplace, including having the fundamental right to refuse dangerous work. As the tragic March 2009 crash of Cougar Flight 491, ferrying oil workers to offshore rigs, and the catastrophic sinking of the Ocean Ranger oil rig in 1982 underscored, worker safety must be job number one. I can assure the House that our government is committed to ensuring the health and safety of Canadian workers and the protection of the environment. And that is why we're introducing this new regime for Atlantic offshore workplaces. Avant de présenter.
Before outlining these improvements in detail, let me first explain where the federal government fits into this picture.
Speaker, the Government of Canada shares responsibility for the management of the offshore with the governments of Nova Scotia and the Government of Newfoundland and Labrador. These responsibilities are laid out in bilateral accords with each province. The Canada-Nova Scotia Offshore Petroleum Resource Accord Implementation Act and the Canada-Newfoundland Atlantic Accord Implementation Act. Canada's Atlantic offshore oil and gas industry is regulated by the Canada-Nova Scotia Offshore Petroleum Board, as well as the Canada, Newfoundland, and Labrador Offshore Petroleum Board. These boards ensure that operators and drilling contractors comply with the requirements of their respective implementation acts and exercise due diligence to prevent spills in Canada's offshore. Mr. Speaker, the Atlantic Accords have been in place since the 1980s and no longer sufficient to reflect contemporary requirements and require modernization. The Labour Program, along with representatives of Natural Resources Canada, provincial energy and labour departments, and the province's offshore petroleum boards have identified and agreed to key areas for improvement. First, the legislation places authority for the occupational health and safety within the Accord Acts. Once adopted, this legislation will establish an occupational health and safety framework within the Atlantic Accord Acts. The
new regime would apply both to worker safety on-site at an offshore rig, as well as to workers in transit to or from offshore platforms.
Apply both to worker safety on-site at an offshore rig, as well as workers in transit or from an offshore platform. It would be jointly overseen by the Minister of Natural Resources Canada and provincial occupational health and safety ministers for Nova Scotia and Newfoundland Labrador.
It would be enforced by their individual offshore petroleum boards.
Verifying the companies have adequate plans in place to protect their employees from and to avoid dangers. This includes everything from ensuring the safe handling of hazardous materials or proper procedures related to operating equipment and facility management. Using audit and inspections, we would confirm that all applicable health and safety requirements are met and demand correction if deficiencies are found. As well, the boards would be granted increased authorities such as enforcement powers for occupational health and safety officers.
These include the powers of inspection and investigation, warrant provisions, and creative sentencing measures in case of dangerous situations.
Inspection and investigations, warrant provisions, and creative sentencing measures in case of dangerous situations. Under Bill C-5, the Minister of Labour would provide ongoing federal labour expertise, such as the development of regulations, the issuance of directives to the boards, and the recommendations and the appointments of special officers.
Special officers would be appointed to avoid a serious, imminent risk to the health and safety of offshore workers.
Following the joint approval and appointments by the pertinent provincial ministers and Minister of Natural Resources Canada, following a recommendation by the Minister of Labour. Along with the Minister of Natural Resources, the Minister of Labour would also co-appoint 6 members of a 13-member advisory council to be made up of employers, employees, and the 2 levels of government. The council will provide a forum for exchange of ideas about occupational health and safety issues to ensure the effectiveness of this legislation. Bill C-5 also introduces consequential amendments to Part 2 of the Canada Labour Code. In the event of an accident, the bill would extend the time limit to launch a prosecution from 1 to 2 years, consistent with the occupational health and safety legislations in many provinces. The Minister of Labour would also have the right to disclose information to the public regarding occupational health and safety. The amendments also give the Minister of Labour the authority to share information with federal and provincial government departments, as well as international organizations, if the Minister deems it to be in the interest of the occupational health and safety or in the public's interest overall. This would make it easier to share information during the coroner's inquest or a provincial prosecution. I want to be clear, however, that personal information would continue to be protected. Mr. Speaker, I should point out several minor amendments to the legislation since it's been debated in the second reading. Most are technical in nature, such as putting in the word Canada in the title of the regulations and renumbering the subtexts of the Act that were incorrectly numbered. Some were needed to harmonize federal and provincial legislation. For instance, we had to replace the Provincial Occupational Health and Safety Act in Nova Scotia with the correct new name of their Labour Board Act, and since the provinces amended their legislation recently. Federal and provincial legislation must obviously mirror each other. Several amendments were required as a result of Bill C-4, the Budget Implementation Act 2, and changes to Part 2 of the Canada Labour Code. The changes proposed under the Canada Labour Code make coordination amendments, and the Minister of Labour now replaces the terms of Health and Safety Officer or Regional Health and Safety Officer to reflect the Minister's authority to delegate powers and duties and functions previously conferred to health and safety officers. Comprenez-moi bien?
Let me be clear. Through the delegation process, decisions will continue to be made by health and safety officers with the necessary expertise.
Clear, through the delegation process, decisions will continue to be made by health and safety officers with the necessary expertise. Coordination is required around the protections within the code regarding the ministers given testimony in civil proceedings, and these amendments, now referred to civil and administrative proceedings, will include arbitration hearings. Mr. Speaker, the improvements I've outlined respond to input received on extensive consultations in 2010 and 2011. The province's industry and employee groups have all expressed strong support for the changes we have proposed. We've done so because they recognize that they will ensure that Canada's offshore industries operate safely and in the highest environmental standards. Bill C-5 will create a modern occupational health and safety regime that is relevant and responsive to today's offshore oil and gas realities. And most importantly, it will provide robust protection for Canada's oil and gas workers, ensuring their safety and health in the workplace. Thousands of Atlantic Canadian workers are looking to us to ensure their well-being and continued prosperity. So I urge all parties to support this bill and make these amendments the law of the land. Thank you very much.
Questions and comments? Question et commentaire. The honourable member for St. John's East.
Thank you, Mr. Speaker. And let me say, first of all, that we are supporting this legislation, but there's one serious problem with it that I wish to raise. We have the Minister mentioned the Cougar helicopter crash, and of course there was an inquiry following that by former Justice Wells as the lead commissioner, who made what he called his most important recommendation, number 29, that there ought to be an independent offshore safety regulator. Now, the Minister mentioned that the accords were bilateral agreements. The Newfoundland government firmly and strongly supported that recommendation, yet the government failed to agree. Not only did it fail to agree to that, it also failed to agree to an amendment proposed by the NDP members in committee to have a 5-year review of that provision to see how the Act is operating and to reconsider that request. Why did the government refuse to do that?
Minister of Labour.
Thanks very much. And as has been mentioned before, our government will continue to work with the province of Newfoundland and Labrador with respect to the safety of these offshore areas. Commissioner Wells actually was very clear at the Natural Resources Committee in December when he said he was pleased with our offshore health and safety legislation. He was also very clear that good will come out of the government's adoption of his recommendations. And so I just encourage the opposition members opposite, please read through the transcripts and and be informed with respect to specifically what was said at committee.
Questions and comments? The honourable member for London North Centre.
Thank you, Mr. Speaker. And I'd like to thank the Minister of Labour for her comments. I know that in my riding of London North Centre, jobs and safety are very important to my constituents. And just recently, I was happy to attend an announcement with GDLS and the Minister of International Trade. It was one of the largest contracts in the history of Canada that would employ over 3,000 people. And I know in the minister's speech she mentioned that we need better safeguards, workers need protected, and that safety is number one, and that's very important. And I'd like to ask the minister to explain how important is offshore oil and gas industry in Canada, and what would be the most effective change in Bill C-5. Thank you.
The honourable Minister of Labour.
Well, thank you very much. I'd like to thank the member from London North Centre for her question and really focusing on jobs. This is a huge component part of what we're trying to achieve here. You know, whether it be the almost 5,000 individuals in Newfoundland and Labrador or the over 1,000 individuals in Nova Scotia, this has a direct impact on them, and making sure that we're growing the oil and gas economy in Atlantic Canada, I think, is enriching not only directly to those employees, but also to the spin-off benefits to the individuals that are beneficiaries of this. Specifically with respect to these accords, health and safety of all Canadian workers is paramount. If individuals cannot attend work and know that they're in a safe environment where they can conduct their course of work and know that they're safe throughout the entire day, that they can return to their families in the evenings, quite frankly, with their lives and all their fingers and toes. I think it makes it very challenging to be productive at work. And so the direction of these accords is, A, to make sure that those workers that are there on oil and gas rigs in Atlantic Canada know that they're safe and that they can have a productive day. And secondly, that the industry overall is safe so that we can continue to grow the industry and create more jobs in Atlantic Canada.
That's so important.
Questions and comments? Question commentaire. The honourable member for Avalon.
Thank you very much, Mr. Speaker. And in the minister's speech, he referred to the Ocean Ranger disaster. And following that particular disaster, Chief Justice Hickman had a royal commission on the Ocean Ranger. There are still some outstanding recommendations from Chief Justice Hickman's report of almost 20 years ago. So my question is, what did the government, in putting this bill together, have a look of any of the recommendations of Chief Alec Hickman's Royal Commission on the Ocean Ranger disaster?
Honourable Minister of Labour.
Thank you very much. I thank the member for his question. With respect to this specific report, I would have to ask my officials, since I do not have a note with respect to that, but what I will say is extensive consultations have taken place since 2003, updated in 2010 and 2011. As I mentioned in my notes, employers, employees, governments have all been consulted and are very supportive of what's going forward, and we will continue to update the regulations associated with this in order to make sure that we are meeting the standards of the day. And so I appreciate the member's comments, and I'm quite happy to get back to him with respect to a specific answer on it.
Questions and comments? Question commentaire. Honorable Député.
The honourable member for Pierrefonds-Dollard. Thank you, Mr. Speaker. I find it strange that the minister refuses to answer a very simple question. I will try to express it in a very simple way. Why not have included the recommendation 29 of the Wells report, into Bill C-5? Very simple question. Can she provide an answer?
Well, as I mentioned before, I think I answered this question, which was Mr. Wells was very clear that he, as stating at the Natural Resources Committee in December, that he's pleased with the offshore health and safety legislation that currently exists.
Questions and comments? Question commentaire. The honourable member for Kitchener-Conestoga.
Well, thank you, Mr. Speaker. I want to thank the minister for outlining carefully the aspect of Bill C-5 that deals primarily with the occupational health and safety issues. She's also responded earlier to a question regarding the number of workers who benefit from this oil and gas production on offshore rigs. And I think many times Canadians probably think more of the oil sands in places where we more logically would think that that's where all the oil is coming from. But I wonder if the minister would have any input on the percentage of oil that the Canadians rely on when it comes to the offshore oil and gas development. I think it's important to realize not only the impact on jobs and opportunities for Canadians, but the energy needs that Canadians have. It's important that we have, first of all, good, safe regulations to protect our workers, but it's also important that we have access to good quality oil products. Thank you, Mr. Speaker.
The Honourable Minister of Labour.
Well, I thank the member from Kitchener-Conestoga for his question. And having grown up in part of the country which is known for being the focal point of oil refining and development in the country in northern Alberta and Fort McMurray, I'm delighted also to know that many of the individuals who are part of growing Canada's economy are Atlantic Canadians, and the offshore contributes significantly to our nation's production, including 35% of Canada's total light crude production and close to 10% of Canada's total crude production in 2010. You know, these are substantive numbers. These are driving the economies of Newfoundland and Labrador, as well as contributing to Nova Scotia's economy. So the statistics are very clear. You know, these activities represent 30% of Newfoundland and Labrador's GDP for 2010, and roughly 3% of Nova Scotia's GDP on average at the same time frame, and directly employ over 5,100 Canadians. You know, the oil and gas sector in Atlantic Canada is growing. That's great for Canadians. It's great for Atlantic Canadians, and it's great for individuals to know that they're contributing so substantially to the Canadian economy. but making sure that there's jobs at home that are supporting thousands of Atlantic Canadians.
Questions and comments? We have time for one more short question. The honourable member for Dartmouth Cole Harbour.
Thank you, Mr. Speaker. The issue of the independent regulator is one that we've raised a number of times, and as my colleague from St. John's East said, it was an important recommendation in Commissioner Wells's report. Now, he did say at committee, and we have supported this bill because it's an improvement over the current situation. Nonetheless, it is something that needs to be addressed. And so at committee, NDP moved an amendment to ask for a review after 5 years, a ministerial review of the effectiveness of these changes within 5 years. I would like to ask the Minister, Mr. Speaker, given the fact that the Commissioner has indicated that while the bill is an improvement, it may not answer everything. There may be a need to address and make revisions at a later point in time. Given the fact that the independent regulator is a position that has been adopted by other nations that are doing similar work, why would she not be willing to support, and her government not be willing to support an amendment that would allow for the minister to do a review within 5 years to ensure, because let's remember, what we're trying to do is ensure that the safety of the men and women who work in this industry and also the question of environmental disasters are fully protected.
The Honourable Minister of Labour.
Well, thank you very much for the question. I appreciate it. And as I mentioned before, I think the committee testimony was quite clear. But the regulatory process, it has begun. We are continuing the development of regulations following the passage of the bill. And provisions within the proposed amendments require that the regulations be completed within the next 5 years, and we're continuing to receive input. So I think that whether it be the government or others, we're always open to constructive input that provides opportunities to improve the health and safety of Canadians. And if the opposition members or other Canadians have recommendations that we should be considering, I encourage you to send them to me.
Resuming debate, reprise de débat, the honourable member for St. John's East.
Thank you, Mr. Speaker. I'm pleased to have an opportunity to speak at third reading on Bill C-5, an important piece of legislation for the Newfoundland and Labrador and the Nova Scotia offshore petroleum industries, which are extremely important not only to Newfoundland and Labrador and Nova Scotia, but also to Canada, as has been pointed out by previous speakers. The industry produces, as was said, 35% of Canadian light crude production, a significant contributor to our oil industry, and has made a significant difference to the economy of Newfoundland and Labrador, and we're proud of the very strong industry that we have and the contribution that it makes to our workforce and to our industry, to our universities and education systems, as well as the lives of people who are able to earn a very good living from this development. So it's been a positive experience, but as we also know, the work in the offshore is inherently dangerous. We've had very sad reminders of that in the past. The Ocean Ranger disaster was mentioned in February of 1982. 84 offshore workers were drowned in a serious disaster of a rig sinking in the exploration of the offshore in Newfoundland, and of course most recently the Cougar helicopter crash in 2009 with the loss of life of 17 individuals. There was another helicopter crash in the late 80s. So we do know that we have serious industry with a lot of opportunity for injury as well as loss of life, as we have sadly seen. And that's what this bill is about. This bill is putting in place a safety regime in legislation believe it or not, for the first time in the offshore. What we have had up until now is a set of draft regulations. Almost hard to believe, Mr. Speaker, that the entire offshore in Newfoundland and Labrador and Nova Scotia was operated under a set of draft regulations, under some theory that if you had the draft regulations, of course the employers, the industry players, the companies would of course follow them as if they were guidelines. But there was no enforcement mechanism. The only enforcement mechanism was to put a stop work order on the rig, which was, you know, an all or nothing situation. So you couldn't actually go and inspect and find someone who violated a provision and use those rules to make an improvement, to issue a fine, and use the same regulatory process that is used on shore in offshore, in health and safety to ensure compliance with the rules that are there. I have some experience with offshore workers, Mr. Speaker. In my life as a lawyer, I represented Newfoundland and Labrador offshore oil workers in their efforts to obtain union representation and recognition, and they in fact became the first offshore oil workers in North America to achieve collective bargaining. And of course, important aspects of collective bargaining include wages and working conditions, but there was also an extreme interest in the process of safety committees, how the safety was being managed by these companies and by the employer, and the desire for employees and their organizations, elected organizations, to participate fully in this process. And we've seen as well a very significant delay in even the implementation of significant recommendations that came, for example, from the Ocean Ranger disaster. One of them was that there should be stationed in the area closest to the offshore an emergency helicopter available on up to 45 minutes' notice. That wasn't implemented, Mr. Speaker. That recommendation was made in 1985. It was not implemented. In fact, it didn't become implemented until the last year or so, after Justice Wells stated that he wanted this to happen and happen immediately. We now have a standby helicopter at St. John's available to wheels up in 20 minutes any time a helicopter is in the air transporting workers back and forth to the oil platforms and drilling platforms. And that's something that it took 20 years, 30 years to get put in place. This legislation itself, the negotiations about this legislation have been going on for 13 years. It's astonishing, Mr. Speaker. You know, when the minister says that this is a top priority, job one is offshore health, is workers' health and safety, it's shocking the delays that have taken place and the length of time that has taken to get these regulations in place. And that's something that, of course, the workers are quite concerned about and have been for many years. In fact, we still have concerns, and the workers have concerns about the use of night flights for helicopters. Former Justice Wells, during the course of the helicopter inquiry, issued an interim recommendation that there be no more night flights. Evidence had been presented to the helicopter inquiry that the ability to rescue people at night was significantly more difficult, that the rate of loss of life when a helicopter ditches at night is some 65% higher, 70% higher than if the ditching happens in the daylight. As a result of his recommendation, the CNL-OPB stopped night flights. The companies are now seeking to return to night flights, and there's very strong opposition to that from many quarters, including the workers and the workers' representatives. So we still see ongoing issues and ongoing problems, but I want to reiterate that we support this legislation because it was, in fact, pushed by the workers' representatives that were involved both in the offshore directly and also with the Federations of Labour in Newfoundland and Labrador and in Nova Scotia. They participated in these negotiations. They worked to ensure that the same kinds of safety regimes that exist on land in terms of the right of a worker to refuse unsafe work, the right of participation in health and safety committees, that these are now parallel in the offshore to what applies on land. Believe it or not, that is an achievement. And so it's not a surprise that people support this legislation, because it is an advance over what is there today. The regulations will be in place, they will be enforceable, there will be a system for that, and there will be a more rigorous involvement of worker representatives in health and safety committees. So that is a success. That is a success. So we support it. We have supported it through committee. We did want improvements. And I'll just give you an example of the kind of evidence that the committee heard the committee heard from witnesses, and I'd like to quote you from the presentation by Lana Payne, who's the Atlantic Director for Unifor at the moment, but was for a number of years the President of the Newfoundland and Labrador Federation of Labour. And she, in her testimony before the committee, said, "We are pleased that we finally have this safety regime for workers of the offshore oil industry. But we do believe that a standalone, powerful, and independent safety and environmental authority is not only necessary, but essential in advancing safety in the Newfoundland and Labrador offshore oil and gas industry." That was her testimony before the committee on December the 9th of last year. And that echoes the recommendation of Mr. Justice Wells, recommendation number 29, and he characterized it as his most important recommendation. And he did that based on his study of regimes in other countries as well, the United Kingdom, Australia, Norway, and even the United States has recognized the necessity of having a separate regime so that health and safety of offshore workers is dealt with separately than the regulation of the industry, which involves quite a lot of collaborative work and back and forth. And the concern, of course, is what Mr. Justice Wells called regulatory capture. It's a phrase used to describe what can happen if the regulator becomes very close to the industry that is regulating and ends up not being able to be independent and provide the priority and the sole priority of looking after the health and safety of workers. So that's why these recommendations was made, and that's why these countries that have mature oil and gas regimes, such as Norway, such as the UK and the North Sea, have that. They have adopted it as a result of learning that it was necessary in order to make sure that we had a powerful, as Lana Payne said, a powerful. Her phrase was very eloquent, Mr. Speaker. She said a powerful, standalone, powerful, independent safety and environmental authority. And that is what's required. The Newfoundland government supported that recommendation. If we've got a truly bilateral event here, we wonder, and we haven't been given an explanation by the Minister as to why the Government of Canada has said no. Why have they said no? They haven't provided any rationale here in the Minister's speech today, despite 2 questions, or was it 3, to the Minister asking why that was. Mr. Justice Wells still supports his recommendation. He still supports his recommendation. The Government of Newfoundland is very adamant that it wants to see a standalone offshore safety body that can handle safety and health issues. And we would add to that environmental as well as a standalone part of that, as Lana Payne had pointed out too. So we do have reservations, obviously, about this, and we thought that at least the government would recognize, if it wasn't going to adopt the recommendation number 29 and put in place a standalone regime, that they would accept an amendment. And I'll read the amendment, Mr. Speaker, so that the amendment was that the Minister of Natural Resources must cause to be laid before each House of Parliament, not later than 5 years after this Act comes into force, a report on the operation and implementation of this Act, including whether an independent offshore area regulator is desirable. Now that, Mr. Speaker, would require this effort, this notion of the independent safety regulator to be foremost in the minds of the government as we go forward, and and see in 5 years, report to Parliament. What can you tell us about the operation of this Act in light of the recommendation for an independent regulator? Can you show us that it's operated well without that, or have you been able to conclude that an offshore separate regulator is available? That was an important effort, Mr. Speaker, that we thought, from the point of view of government operations, particularly in light of the strong recommendation that had come forward and the support of the Newfoundland, the strong support of the Newfoundland government, the partner in this, that we would see agreement at least on that. But no, Mr. Speaker, it got very short shrift at the committee from the government members without really any effort to justify why they weren't accepting that. But that's not unusual from this government, Mr. Speaker. It's not unusual for us to go to committee with cogent arguments, with witness support, with experts and expertise. Time and again, this happens in committees with this government. And this, it's not always been like that, Mr. Speaker. I was here with another government, a progressive conservative government, back in the 1980s. And we had committee meetings. We offered suggestions. We made amendments. The amendments were debated. Some were accepted. Some were rejected. There was a somewhat more collegial, shall we say, effort than we have with this government in committee. So anything that they propose has to be perfect. This must be perfect. Now, of course, it's perfect until they realize they've made some mistakes, and then they bring in a bunch of amendments themselves, like they did in this case. I think there was 10 that they brought forward at the end of the day. Oh, we got to fix this, 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 and this. But if anybody else makes a suggestion, no, it's perfect as it is. We don't need to change anything because, of course, we wouldn't bring anything forward if it wasn't right and proper. It's an unfortunate attitude that we have, Mr. Speaker, and it represents a little bit of, I don't know whether it's paranoia or immaturity or lack of confidence or whatever, or just sheer pig-headedness. But this government doesn't seem to recognize that any good suggestions can come from any other location other than their side of the House, or maybe from the PMO, because maybe all suggestions must flow from the PMO instead of members opposite even listening to what's said in the committee, accepting that the arguments make sense, and agreeing that things may need to be amended slightly to make the legislation better. And I think that's the theory of debate and amendments. You make an amendment to improve the legislation, not to change it so that it does something different than it was intended. Obviously, the intention of the legislation, if you have an amendment that goes against the intention of the legislation to begin with, it's ruled out of order. It's not in order to do that. The only amendments acceptable in the parliamentary procedure are ones that are within the scope of the bill and are offered by way of improvement to better achieve the purposes of the legislation. In this case, the purpose of the legislation is clearly to have an offshore health and safety regime that reflects the needs of the people who are in the industry and the industry itself, in having a robust safety regime that ensures that all the workers are safe, that the operation can be done properly, as the Minister mentioned, both on site and also in transit back and forth to the oil platforms and rigs. And has been pointed out, there's three rigs in operation right now. There's another one in the works. Should be operating by 2017. The Hebron-Ben Nevis field, which is further out, some 400 kilometers offshore, a very grave distance. Helicopters are flying out there obviously not in too inclement weather, but in all sorts of conditions, sea conditions that would make it very difficult to ditch an aircraft if that becomes necessary. And in this case, they're flying in helicopters which the helicopter that's being used is the only helicopter of its class that doesn't have the capability of operating with a 30-minute run-dry capability. Now, that's when the main gearbox loses oil. The requirement is that it be able to operate for 30 minutes with a total loss of oil in the main gearbox. And that's there for significant safety reasons. We have it in military helicopters. In fact, some of them will run dry for an hour or more, but the minimum standard is 30 minutes. Sikorsky, when they designed this helicopter, got an exemption. They got an exemption on the basis that this would never happen, or the chance of it happening was so remote. I think they said it would be 1 in 10 million hours. Well, in the first 100,000 hours, flying hours of this helicopter type, it happened twice. Once in Australia in the summer of 2008. Fortunately, it was over land, and they could land quickly enough to avoid a disaster. And then in March of 2009, tragically, in the offshore of Newfoundland. Unfortunately, again, the documentation for this aircraft suggested that they did have 30-minute run-dry capability, and the helicopter pilots were heading for land in the expectation that they would have 30 minutes to get there. They had less than 12 minutes, Mr. Speaker, and the helicopter seized up and crash-landed into the ocean, causing the loss of 17 of the 18 people on board. Miraculously, one person actually survived that crash. I see that my time is approaching 1 minute left, so I will clue up by saying that, yes, as was said, this is a significant step forward. We have now, or we will have now, an enforceable regime for safety and health in the offshore, a right to refuse unsafe work, a participation in health and safety committees, and hopefully a good regime that will work. Unfortunately, we don't have the independent safety regulator that was both recommended by Commissioner Wells, supported by the government and people of Newfoundland and Labrador and the offshore workers themselves. And unfortunately, we don't even have a commitment to review that by the government in 5 years' time. But we do support the legislation. Thank you, Mr. Speaker.
Questions and comments? Question et commentaire. The honourable member for Avalon.
Thank you very much, Mr. Speaker, and thank the member for St. John's East for his intervention, and acknowledging that he's been around this file on the offshore for some time. So I'm going to lean on him for his knowledge and his expertise in this matter to follow up on a question that I tried to ask the minister regarding the Ocean Ranger. And Chief Justice Alex Hickman's commission had some 136 recommendations to improve the offshore oil. The government has only implemented 90 of those 136. It leaves 46 recommendations unfulfilled from that particular inquiry. So my question is, has any of those 46 that the member knows of has made its way into this legislation to improve the offshore off of Newfoundland, Labrador, and Nova Scotia? Again, we've talked about the other inquiry, and there's 2 recommendations left out. But I'm kind of curious about the Ocean Ranger one. Has any of those 46 that have been left undone, have they made it its way into this legislation at all?
The honourable member for St. John's East.
Well, thank you, Mr. Speaker. And I want to thank the member for Avalon for the question. Yes, I have been involved for a long time. In fact, I did participate in the Ocean Ranger inquiry when it was launched in 1982 as a young new lawyer in St. John's in Newfoundland and Labrador, and it was a great deal of effort and anxiety went into trying to come up with these recommendations. Unfortunately, as pointed out, the one that shockingly was not implemented of having a rescue helicopter available wasn't implemented until after the Cougar helicopter crashed, more than 25 years after the recommendations were made. I don't have a compendium of the actual lists of all of the recommendations that are there. Clearly, the Ocean Ranger recommendation is now in place, not thanks to this legislation, but thanks to the recommendation of Mr. former Justice Wells, that we have that helicopter there for search and rescue purposes. But there are still outstanding recommendations, as the honourable member has pointed out, and they should be attended to. Evacuation system is one that's been worked on over the years. I don't think we've got the right system yet, and there's still other recommendations that need to be looked at.
Questions and comments? Question est commentaire. L'honorable député.
The honourable member for Trois-Rivières. Thank you, Mr. Speaker. Obviously, we are supporting this bill because we want to support the health and safety of workers. We are behind them. But it's a bit sad that there has to be a problem before we deal with situations, and it's not always the case, but often. In the bill that we are studying today, and what I'd like to ask my colleague is the following. Despite the significant steps that are being made in the right direction, are we not still facing an ideological mind block of this government? They are always on the side of the private sector. We've seen that in the rail industry. The most important recommendation made by Judge Wells is not found in this bill, and that was the intention to appoint an independent safety regulator that would ensure their safety.
Johns East.
Thank you, Mr. Speaker. And I want to thank my colleague for his question, particularly for his observation about how this government has been working in respect to recommendations, particularly of a health and safety nature. Safety costs money, Mr. Speaker, and we've seen the resistance by industry to advances that cost money because they obviously don't want to spend money where they don't have to. So it does require a government that's vigorous in insisting that things happen that need to happen for the sake of offshore, for worker safety. We see some of that here. We don't see it going far enough. The night flights offshore are a good example. Why do you need night flights? Well, so that we can operate the helicopters more, the same number of helicopters, for a greater period of time. The alternative, have more helicopters. If you had an extra helicopter, you wouldn't have to fly at night. But extra helicopters cost money. You have to have crew. You have to have that. So there's a trade-off being urged between worker safety and cost. We would prefer, clearly, to come down on the side of worker safety. And if night flights are more dangerous, then we should be able to insist that there be more helicopters in place. If helicopters that have a run-dry capability of 30 minutes are available, then they should be used, not ones that don't have that capability. So they may cost more money, there may be a cost in replacing them, but the value of the lives and safety of workers has to take precedence over that. And we don't see that kind of attitude coming from this government.
Questions and comments? Question et commentaire. The honourable member for Victoria.
Appreciated the intervention by my friend from St. John's East. And you spoke, I thought, very eloquently about your working committee and the fact that there was no statutory...
I'd remind the member for Victoria to direct his comments to the chair, not to other members.
Mr. Speaker. Through you, the member from St. John's East made I think, a very eloquent statement about the nature of the work at committee in this particular matter, and the fact that the government rejected the notion of a 5-year review. Having worked on committees in which that 5-year process has been required, such as under the Access to Information Act and the Privacy Act, and having seen a progressive conservative government at that point have a unanimous committee report with recommendations, I saw firsthand the utility of such a statutory review. My question is twofold, through you, Mr. Speaker. Given that this bill requires agreement with the two provinces at issue, Nova Scotia and Newfoundland and Labrador, would they be acceptable? Would they find acceptable such a statutory review after a 5-year period? And I would like to also know why the government would reject the notion of a 5-year review in these circumstances.
The honourable member for St. John's East.
Thank you, Mr. Speaker. Well, I appreciate my learned friend and colleague from Victoria's intervention and compliment for my speech, but I think he knows that I can't answer why they would reject it, other than to speculate. But there appears to be an unfortunate lack of collegiality at committees. Committees, we do posture, obviously, politicians do, especially in the House of Commons. But in committees, you would expect to have a greater level of collegiality. I think in some committees there are. I'm looking over at a prominent member of the Fisheries Committee, which does have collegiality as an operating principle over many years. But when it comes to dealing with legislation, we don't see that collegiality that should exist to improve and make things happen. That was a reasonable, I wouldn't call it a compromise. We weren't going to get what we wanted, but it should have been able to put that on the radar of the government or the next government, because it may not be this government. We're hoping it won't be this government, but it may. But whatever government is in place, it will be on the radar of that government that this should be looked at, and the bureaucracy and those involved would look forward to this happening in 5 years' time and be able to prepare to deal with that. It's very unfortunate. That's all I can say. I don't know why. It's just accept the stubbornness that whatever is in the legislation that they put there, that's all they want to do.
Resuming debate, reprise de débat, the honourable member for Halifax West.
Thanks very much, Mr. Speaker. I'm pleased to rise and speak on this Bill C-5. Mr. Speaker, this is the second day this week when the House debated legislation which impacts activities in our offshore sector, which to those of us in Atlantic Canada, like my colleague, the member for St. John's East, who just spoke, and the member for Avalon, who asked him a question, is very important. It's very important to our economy. It's very important to the people who work in the offshore sector, who benefit from that. And of course, it's very important that they are safe in the work they do and in traveling to and from the offshore platforms. Because, of course, the offshore sector can be a dangerous place. I know there are many measures taken to make it as safe as possible, but it's tough work, it can be dangerous work, and we've seen unfortunate proof of that over the years. And the fact is that there are brave men and women out there working, performing very challenging work every day. Et d'assurer que ces gens...
To ensure that people remain safe, that they be in a safe situation, and that they can get home to their families. That has to be a very important priority for all of us. And with respect to Bill C-5 is a step in the right direction. However, I would hope that the government will listen to the experts. For example, as was the case with C-22, which we discussed on Tuesday, they did not do so in that case. They did not listen to the experts. And as to C-5, they should do so in this case.
The House was debating second reading of Bill C-5. The member from Burnaby Douglas asked if I thought the legislation went far enough in addressing the concerns of the Wells Royal Commission. Well, I didn't. And I don't. One concern I had with Bill C-5 was that it didn't adopt Recommendation 29 of the Wells Commission report, which flowed from a terrible helicopter crash off Newfoundland, which has already been discussed a bit this morning. My hope was that when the bill went to committee, that there would be consideration given to an amendment to adopt Recommendation 29, which called for a separate organization to look at the question of workers' health and safety, an organization solely dedicated to that absolutely vital task. Now, Commissioner Wells testified at the committee last fall that he, quote, felt that an independent safety authority was the best choice, unquote. Commissioner Wells went on to add that he didn't think everyone would agree to his recommendation. It's reasonable. So he included a fallback position, which was to create a separate safety division within the Canada, Newfoundland, and Labrador Offshore Petroleum Board. And of course, this legislation would also apply, Mr. Speaker, to the Canada, Nova Scotia Offshore Petroleum Board. While the fallback position was adopted, in my view, it falls short of what is needed. And yet, it's yet another missed opportunity by this neo-conservative government. Unfortunately, Bill C-5 was reported back to the House of Commons with only a few technical amendments which correct inaccurate wording in a number of clauses. But it was also very unfortunate, Mr. Speaker, in my view, that the Conservatives on the committee wouldn't support efforts to provide greater clarity on the word danger in the Act. And that word is particularly important, and the meaning of it is particularly important on this kind of legislation. Under this legislation, certain terms such as danger are not defined in this bill. Instead, they remain to be defined by federal regulation on the recommendation of the Minister of Natural Resources and the Minister of Labour, and with approval of provincial ministers. Now, Mr. Speaker, I introduced in committee an amendment, proposed amendment, calling for consultations with the provinces and with key stakeholders on the definition of dangerous work, something we'd heard about as being important. I felt, in fact, that it coincided with what we heard in committee, with testimony we heard about the importance of consulting on this question of the word danger, which is critical for all parts of the offshore oil and gas industry and to the men and women who work in our offshore. So while this legislation does push the yardsticks, and while it's a move in the right direction, it could have been better. It could have been strengthened. It should have been amended. As legislators, that's our job. It is our job to examine these carefully and look for ways to improve them, to hear the evidence, to hear the experts, to actually reflect on that, that expert evidence and testimony and make the changes that are appropriate. We're not simply here to do whatever the kids in short pants in the Prime Minister's office tell us or order us to do, or order the Conservatives on that side to do, obviously. We're often asked to strike a careful balance between economic success in the oil and gas sector, the rights of employees, and, of course, environmental concerns. Bill C-5 is one of the many tools to achieve this balance. And I believe the Canadian Parliament, of course including us here in this House of Commons, ought to strive to set an example to the rest of the world by clearly indicating that we value human capital at least as much as the wealth we derive from our natural resources. And that's why the Liberal Party has supported this bill. C-5 will, in fact, effectively solve the issue of jurisdiction surrounding occupational health and safety in Canada's offshore oil and gas industry, which wasn't clear until now, as it was clearly became very clear during the after the terrible helicopter accident off Newfoundland, when it wasn't clear which level of government had responsibility and jurisdiction. This will solve that issue, and that's important. And that's an important step forward, which has taken over 10 years to realize. This legislation will also create a streamlined process for rectifying health and safety issues and to assign responsibility. And that's important because we don't want to have any doubt about jurisdiction, of course, if there's an accident in the offshore. It's an issue of the utmost importance is our capacity to respond to an accident or spill in the offshore. But that, of course, is a debate for another day, and I hope we'll have opportunities to do that. This legislation is focused on the right to a safe workplace. It's an important right and a right that all Canadians must enjoy. Many of us as Canadians, and certainly those of us as members of Parliament, have a very safe work environment and are very fortunate in the kind of work we do. And for the most part, it's indoor work, you might say. And a lot of it's desk work, and sometimes it's standing up work, but it sure isn't the kind of conditions that some workers across this country face by any means. Especially, you can think of that especially if you go outside today on a cold day like this, or if you consider the folks in Atlantic Canada. I can look across as my colleague from New Brunswick. We consider our families back home and other families in Atlantic Canada who are digging out from a terrible storm and still experiencing terrible winds, and some of them being out of power. and the folks from the power companies, for example, and the snowplow drivers and others who are out there working to get things back to normal, we sure should feel pretty fortunate to be working in a place like this and the kinds of jobs that we have. Évidemment,
obviously,
though a safe workplace is not the reality for all Canadians, governments have worked with stakeholder groups in the past to improve conditions faced by Canadians in their places of employment. Cela, évidemment,
obviously, this is incredibly important work. Bill C-5 is an example of these efforts. In this case, they are the efforts of the provincial and federal levels working together. We don't see enough of that. This is something this government is not normally noted for, to work together with the provincial levels of government. But it's our collective responsibility, whether as a legislative body, employers or employees, or as a society as a whole, to ensure that the right to a safe work environment is respected.
It's absolutely vital, Mr. Speaker. The conditions for employees on offshore drilling rig projects should be comparable to those on land-based projects. There's no question that a drilling rig, maybe that's a Freudian slip. I don't know, Mr. Speaker, when I mentioned a wig, right? But there's no question that a drilling rig, whether offshore or onshore, can be a very dangerous environment. I think employees and their families can be confident that what is proposed in Bill C-5, as far as it goes, would improve the health and safety regimes of our offshore oil and gas projects. Members of our party believe we still need to ensure that the separation of health and safety concerns from those of production and economic viability occur. Justice Wells made it very clear in much more eloquent language than I. We recognize that these two issues are very different things, but that one trumps the other, that health and safety comes first. We need to make sure that when necessary, those health and safety concerns are paramount, as they ought to be. Bill C-5 should guarantee that the proposed Chief Safety Officer has powerful methods of inquiry to hold operators to account. A regime of self-regulation, in our view, would be insufficient. I've already said that we don't think the Chief Safety Officer approach necessarily ideal. There are other things that Commissioner Wells recommended, but since that's what we're going with, let's try to make it as strong as possible. The Chief Safety Officer must not be influenced in decision-making by concerns of economic viability or by political pressure. Obviously, that should be obvious. This individual must be a champion of a healthy and safe environment for all employees who work in our offshore oil and gas industry and any of those kinds of projects. This bill has survived changes in governing parties at both the federal and provincial levels. It's received clear provincial support, and legislatures in both Nova Scotia and Newfoundland and Labrador have given Bill C-5's mirror legislation assent in short order. By supporting Bill C-5, we have the opportunity to improve upon legislation that has already met some of the concerns of the provinces. If we take into account all the elements of employee health and safety, the original offshore accords, and Bill C-5 itself in those bills, this could provide the model for future negotiations between the federal government and other provinces, like Quebec, for example, that are looking to develop their oil and gas sectors. Let me conclude, Mr. Speaker, by noting that while Bill C-5 is a step forward, we should recognize that more work needs to be done, and hopefully we won't have to wait another decade for that to occur. It's not new to Canadians that our country places great economic impact on the development of natural resources. Forest products, natural gas, hydroelectricity, and oil and gas are cornerstones of our export market and contribute immensely is the creation of jobs. Something that's, of course, we believe is very important. We want Canadians to have the good quality of life that comes with jobs and opportunity. But let's make sure those resources are developed in a responsible and sustainable way, and let's recognize that occupational health and safety must be paramount. Thank you, Mr. Speaker.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Natural Resources.
Thank you very much, Mr. Speaker, and I thank my honourable member for his comments on this very important piece of legislation. I would like to reinforce the points that he has made that both provinces have already given royal assent to their respective bills to enact these changes. They have been waiting patiently for Bill C-5 to pass through our Parliament for the new regime to come into force. And so I just want to confirm what I thought I heard the member say, that he and his colleagues will definitely allow for this legislation to finally come into force so that workers will not have to spend another day without the safety measures that Bill C-5 will bring.
The Honourable Member for Halifax West.
Thank you very much, Mr. Speaker, and I thank the Honourable Parliamentary Secretary for her question. I know that she heard my speech, and she heard that I do have some concerns about amendments that weren't adopted by the committee and that weren't supported by her party. But as I said, we think this legislation is important because it is a step in the right direction. It moves the ball forward, even if it isn't as good as we would like, and therefore we're supporting this bill. We don't have any intention to slow it down. Now, I should point out, of course, that the Conservative government certainly has the means to move legislation faster than it has moved this legislation. And there hasn't been a week go by that I can recall in which we haven't seen at least one motion of time allocation or closure by this Conservative government. I mean, I don't know if they used it 7,000 times, but I know it was well over 50, even by last fall, it seems to me they've used it, and they've used those measures far more than any other government in the history of this country. So for them to talk about bills not moving fast enough is a little rich, Mr. Speaker, but I appreciate the question.
Questions and comments. The Honourable Member for Trois-Rivières. Thank you, Mr. Speaker. I carefully listened to my colleague's speech, and I have a question. Even though I'm not an expert in the area of offshore extraction, 10 years to get to this bill, which we're debating today, seems quite long. I don't want to simplify or oversimplify the complexity of this matter, but this is my question. Would it not have been possible, because again, this process started in 2001 when the Liberals were in power, would it not have been possible to put in place this independent committee which Judge Wells recommended at recommendation 29? Thank you very much, Mr. Speaker, and I would like to thank my honourable colleague for his question. I was not involved in natural resources in the period in question, but I know that after a certain amount of time, the federal and provincial governments discussed these issues. However, it does strike me as being quite strange that it took 10 years to get to where we are. I know that there are many issues at stake when it comes to discussions between the federal government and the province. So I do understand that this process could have taken 3 or 4 years, but 10 years, I think that's extremely long. So I don't understand. Is it because governments came and went? I don't know.
Questions and comments? The Honourable Member for Dartmouth Cole Harbour.
Thank you, Mr. Speaker, and I appreciate, as always, the member from Halifax West comments and the perspective he brings to issues like this. He spent some time sitting on the other side, and so perhaps he can lend a little bit of this perspective to this particular issue. One of the things I'm concerned about, they just talked about the fact that it took 13 years for the governments, provincial and federal, to finally come together and bring this bill forward, which is an awful delay. Number one, but number two, at the same time that there, there is steps being made, progress being made to strengthen health and safety rules as they relate to offshore development work, would he not agree that it is likewise a serious deficiency in our ability to protect workers on the offshore, that this government is continuing to hack and slash away at search and rescue capabilities, and that if, and God forbid there is ever any need, that we simply have a shortage of search and rescue capabilities, and perhaps he could comment on that issue.
The honourable member for Halifax West.
Thank you, Mr. Speaker, and I thank my honourable colleague from Dartmouth Cole Harbour for his question. You know, first of all, my understanding is that governments have been in discussion for 10 years on this legislation, and that, in fact, we've seen it brought forward, the same bill brought forward a few times now. So it's surprising to me that the Conservative government hasn't moved more quickly or hasn't brought it forward in a more expeditious fashion to get it done, and it could have done that a number of times over the last 8 years now that they've been in government. Why it's only 10 years, as I understand it, that there was discussions been going on. I'm not sure why it wasn't sooner than that, but that's my understanding, my recollection. But on the question of search and rescue, you know, people that I know who have some knowledge of search and rescue across the country have been very concerned about this government's attitude towards this area, whether it is in the offshore, whether it's in our north, whether it's on either of the coasts and throughout the country. We haven't seen the kind of interest. We've seen cutbacks to search and rescue. You know, we have a lot of people in Newfoundland and Labrador who are very concerned about the lack of effective search and rescue equipment in that region and throughout the country. So, Mr. Speaker, you know, my honourable colleague has raised what I think is a very important point.
Questions and comments? Resuming debate. The honourable. Questions and comments. The honourable member for Avalon.
Thank you very much, Mr. Speaker. I'd like to ask my colleague a question who attended the committee hearings. There's been a lot of discussion around recommendation number 29 and the recommendation that was made by Chief Justice Wells in his inquiry, and the government's acknowledging that they're not putting this in this particular bill. So my question is, the recommendation 29 by the Chief Justice, was his stance at the committee that this was still an important recommendation?
The honourable member for Halifax West.
Thank you very much, Mr. Chairman. I thank my colleague from Avalon for his question. Commissioner Wells certainly made it clear that he believed this was an important recommendation. He talked about the circumstances of his report. I thought he was a very impressive witness, and I think many of us in the committee, in view of the work he did on that commission, felt a certain deference to his opinions. And but nevertheless, the government has chosen not to adopt recommendation 29. I think that's unfortunate, and I think that we really ought to be seriously looking in the future at separating that function of health and safety. So I hope the government will. I mean, obviously they're not going to reconsider now that we're at third reading of the bill. But I hope that they will at least reflect on this question and look for ways to improve it in the future.
Questions and comments? Short question, the honourable member for Dartmouth Cole Harbour.
Thank you, Mr. Speaker, and I wanted to maybe go a little further on this whole question about how long it took to get to this stage, because you know we've had unfortunately a number of disasters in our region that we can point to, and there seems to be a pattern of delay before we implement the kind of legislation, the kind of rules and enforcement regulations that need to be in place in order to ensure that these things don't happen. And I wondered if the member who spoke from Halifax, my colleague from Nova Scotia, from Halifax West, would perhaps indicate to me what steps he took and his government took when they were on the opposite side in order to correct these problems?
The honourable member for Halifax West, short answer, please.
Well, Mr. Speaker, I know that the other parties like to engage in going back 10 years and so forth, and talking about what the Liberal government did at that time. It is quite a while ago now, and so it's interesting that they continue to do that, but I'm glad that it's a good sign when they try to throw barbs in our direction and challenge us on things. They're certainly paying attention and must be concerned about our party. The fact is that you go back that long, I can tell you that I was very engaged, particularly as the Minister of Fisheries and Oceans, with concerns about matters of search and rescue and the Coast Guard, and very strongly supported measures to improve the situation for our Coast Guard. In fact, announced funding for new Coast Guard vessels, which it took quite a while for the government following us to actually bring to fruition. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Tibik-Mactaquac.
Thank you very much, Mr. Speaker, and I appreciate the opportunity to follow some of my colleagues in the debate on C5. And having been a member of the Natural Resources Committee for 8 years, this was sort of, and now left the Natural Resources Committee, this was the last major piece of work I had the opportunity to work on with my colleagues from all parties. And unfortunately, I didn't. I had moved prior to getting to the clause by clause, which would have been interesting too. But nonetheless, it was got a chance to listen to a lot of the testimony that was before committee, and we had some great witnesses, and I thought we had a very cordial discussion and a lot of good feedback on that. And it was a good committee experience. Mr. Speaker, today what I'd like to do is just highlight, and what I'm going to talk about today is the importance of the offshore, just spend a few moments on that. What I'd like to do is then talk about what led to C5 and why C5 is important. Then basically what some of the major things the bill does, and then some of the comments from Justice Wells that I'd like to talk about as well. The natural resources, certainly we know, and a lot of people have said in the testimony earlier today, and some of the comments that have been made here, the importance of natural resources to our country, and specifically the East Coast. And as my colleague from Halifax West just pointed out a minute ago, we have a lot of people working on the offshore, and the potential for expansion of that resource opportunity on the offshore not only helps the folks in Newfoundland, Labrador, and Nova Scotia, but also PEI and New Brunswick, whether it be providing services or whether it be our laborers actually going there. And in some cases, it's a lot better trip for some of our families to be able to go to an East Coast situation as opposed to traveling west. For that reason, we want to continue to ensure that Canada's natural resource sectors remain open to investment that is market-oriented and in the long-term interest of Canadians. And we will ensure that the jobs, opportunities, and economic growth created by our natural wealth are available to all Canadians. In the Atlantic offshore, this wealth is chiefly in the energy sector, particularly oil and natural gas. The strength of Canada's energy sector is well established, but as strong as Canada's energy sector is today, it offers even greater potential for the future. Mr. Speaker, Canadians living in Atlantic Canada already know what a difference a strong energy industry can make to communities and the quality of life. Offshore oil and gas has literally transformed the economy of Newfoundland and Labrador, for example. In 2011, the energy sector in Newfoundland and Labrador employed nearly 5,000 people and accounted for roughly one-third of provincial nominal GDP. And between 1997 and 2013, the province collected about $7.8 billion in statutory royalties from offshore oil and gas. And now as we begin 2014, the future is even brighter. The offshore energy sector, Newfoundland, Labrador, and Nova Scotia is still growing, and the industry continues to invest billions of dollars in new energy projects. Mr. Speaker, our government supports energy infrastructure projects that will create jobs and generate economic growth for Canadians. But it will do so only if these projects can be proven safe for Canadians and only after we have the proper reviews. Our commitment to responsible resource development is made for environmental reasons as well as economic ones. Our plan ensures stronger protection by introducing tough new financial penalties for companies that do not comply with environmental regulations and establish new measures to strengthen Canada's world-class pipeline and marine safety regimes. But we have to remember that one of the major regulatory items is to protect people through a rigorous offshore safety regime. And that is why we introduced Bill C-5, to ensure that offshore industries can carry out their activities safely. And I'd just like to read into the record some testimony from Mr. Jeff Labonte, who is the Director General of Energy Safety and the Security Branch for the Department of Natural Resources, where he said, the work in the legislative package before Parliament got underway almost a dozen years ago. It was following an accident in Nova Scotia in which a worker in a workplace was killed. In that particular accident, the Accord Acts originally separated operational safety, the operations of the technical units, and things that are happening in the offshore, which was embedded in the Accord Acts, and occupational health and safety, which is a separate area which fell under provincial jurisdiction. So all of a sudden we had a gray area here where it was hard to determine who was actually responsible and what would happen and who would actually regulate this going forward. So that led to a 12-year process and led to our Bill C-5, which a bill is approximately 260 to 270 pages, of which members who were on the committee and actually went through the review know that roughly 200 of those pages was taking exactly occupational health and safety regulations and actually our law and putting them into the Accord Acts. So really what it was to do was to mirror the legislation between the provinces and the federal government. And we want these offshore industries to abide by the most stringent standards. And we need to identify and clarify, and that was the reason that we did that. And interesting enough, some of the comments that were made earlier was, why did this take so long? Good question. Started in 2002 as a 12-year process, and of course I think a lot of us understand in this House, even if we've only been here a short period of time, that sometimes it can take a while to get these federal provincial things negotiated. But what ended up happening is it went through a period until about 2007, and then there was a realization at that point in time that there needed to be further work on the governance aspects of the bill. So then it had to go back, and obviously there was a lot of iterations between the provinces and the federal government in order to make sure that we were able to continue to make sure that this legislation was mirrored properly. So those things took some time, and then obviously we had some governmental issues with respect to the minority governments that happened during those times. But really what was done is now the provinces, and under, I believe it was an NDP government in Nova Scotia, actually passed the legislation through, and the PC government in Newfoundland. And now they wait for us to do our process for Bill C-5. The Accord Acts already provide the regulatory cornerstone for all oil and gas activities in the Atlantic offshore. They give the independent regulators, which are the two offshore boards that we've been talking about this morning, the legal authority to regulate oil and gas activities on behalf of the governments of Canada, of Nova Scotia, and Newfoundland and Labrador. They clearly establish the health and safety within the Accord Acts. For the essential matters of occupational health and safety and operational safety in the offshore, Bill C-5 fully clarifies the roles and responsibilities of all concerned parties, governments, regulators, employers, and workers. The legislation also has other practical benefits that it gives new powers to the offshore inspectors to further enhance safety. For example, inspectors will now be authorized to inspect anything, take samples, and meet privately with individuals. Further, inspectors will now have the power to conduct compliance audits on the vessels used to transport workers and for the workers themselves. If they have any safety concerns with Bill C-5, allows them to refuse to be transported to the offshore sites. And I just want to speak to the Chief Safety Officer power. And I was particularly strengthened because in my experience in construction projects that I had before coming into to this area, it was always my understanding whenever I went to a construction site that the Chief Safety Officer had the full ability to shut a site down. They could do that carte blanche. And that's really the independence. And even though those safety officers actually reported to project managers, they actually really had a higher calling and a higher power. And this safety officer, and I'm referring to some of the testimony again from Mr. Labonte, where he said, the final area that I will cover is that of the Chief Safety Officer. First, to ensure that safety considerations are always represented, the legislation proposes that the position of the Chief Safety Officer can never be held by the CEO of the board. In addition, a Chief Safety Officer would have to review and provide written recommendations related to safety on all operational authorizations. This would formalize a process that both boards have already been following and is a practice of ensuring that safety is a priority. Chief Safety Officers would also be granted the power to allow regulatory substitutions. And as everybody knows, when we start talking about these regulatory substitutions, technology moves very fast in the offshore environment, any type of environment that we're talking about. So what this does is allows, for example, a Chief Safety Officer can say if a new piece of equipment comes out which is actually going to make workers safer, they have the actual ability to authorize an approval to substitute that for something that is already out there. So those are important things to make sure that our workers are safe, that this legislation keeps up and the regulation keeps up. During his appearance in the Natural Resources Committee in December, Justice Wells spoke about the legislation in which he said, "Somebody has worked hard, more than one person, I suspect, in this bill. I know that's been under consideration for a number of years. Quite honestly, I think it's a good job, and I think it will help to formalize some of the concepts that people knowledgeable about the industry and the regulatory people have thought about for some time. To see it enshrined, I hope to see it enshrined, in legislation is a good thing. A couple of things impress me most. One is that the bill talks about and mandates the involvement of workers in the processes of safety. That was something that was important to me during the 2 years and 3 or 4 months that I was the inquiry commissioner. Mr. Speaker, Justice Wells was very clear in the committee when he was pleased with the offshore health and safety legislation. He was also clear that good has come out of the government's adoption of his recommendations. And we also talked at committee quite at length with the two individuals, Mr. Scott Tessier, who's the chair and CEO of the Canada, Newfoundland and Labrador Offshore Petroleum Board, and Mr. Stuart Pinks, who's the CEO of the Canada, Nova Scotia Offshore Petroleum Board. So we had a significant opportunity to question those folks, and in fact one of them was actually a former Chief Safety Officer who would now become the CEO. And when I asked him, I said, what are the qualifications of these Chief Safety Officers? What are the kinds of things that they do? And how, what is the process? And he said to me, like, he had been the Chief Safety Officer for a number of years, and there's a very, very strict selection process which goes into the CEO, or Chief Safety Officer. And from that standpoint, they are often long-tenured employees who stay with these boards for very long periods of time and build up the institutional knowledge to be able to continue to do their job effectively. Some of the other things they talked about was under current privacy implementation or requirements, they're not allowed to publish certain types of things when it comes to safety. Now, with this legislation, when it comes to safety, they will be able to publish this for the public. And a lot of it was said before about it's not just the actual workers who are on that site, it's their families. And we always need to be concerned about their families as well, and the families being able to see the safety considerations and be able to see that everything is safe and what is actually happening is important to the families as well. Justice Wells and the two CEOs also talked about safety forums, which have actually started now. And they had just conducted the fifth of these safety forums. And there a tremendous amount of feedback that they actually received from the workers, who now, in part of this legislation, which is very important, is the three major things that they have, is they have the right to know, they have the right to participate in the discussions, and they have the right to refuse dangerous work. All important aspects for these workers, and these safety forums allow for these types of discussions to happen and the appropriate actions to take place. And I talked previously about the safety equipment as well and the substitution. So a lot of good feedback, and I do recognize that the Unifor representative talked about the safety regulator, and I'm sure someone will ask me that question, I'm sure during the questions and comments. But in summary, Mr. Speaker, there's no doubt C5 will significantly enhance worker safety in the offshore by creating a much more transparent safety regime with clear responsibilities for all involved. Our government, as well as our provincial partners, and that's what I want to emphasize, this was a partnership because this legislation had to be mirrored at the federal and provincial level. And it's going to give us a much more modern, efficient, and stringent offshore safety regime in the world, one that is supported by strong laws and standards that are second to none. Mr. Speaker, as government is committed to freer trade and to maintaining an open marketplace that welcomes investment. We're committed to providing a regulatory regime that's predictable for major projects that is fair, transparent, and predictable, and we are committed to enhancing Canadians' competitiveness in the economic sectors. Mr. Speaker, I really encourage and I'm really happy and pleased to see that our members from the opposite side are going to be supporting this bill, because this represents an important and I think a big move of the yardsticks forward in terms of offshore health and safety for our workers and for the well-being of some of their families. And I really appreciate the support for that, and hopefully we'll be able to get this passed quickly. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Dartmouth Cole Harbour.
Thank you, Mr. Speaker. I appreciated the speech by my colleague opposite. I know he approaches issues like this in a very conscientious manner, and he spoke at some length, I think, about the trying to justify why it took so long for this legislation to finally hit the floor here. And I don't think there's any question that it is complicated, needing to mesh together the provincial jurisdictions as well as the offshore regulations, so authorities. But that also goes to, I think, the justification for the NDP amendment that was introduced in the committee, that it has taken us a long time to get this legislation through, that a lot of work has been done to try to make sure that it covers everything off. We've noted some weaknesses, one of them being the independent regulator and so on. But as always the case, there's going to need to be some revisions. And so that's why the NDP introduced its motion amendment to try to see that the minister would conduct a review of the bill within 5 years. And I would like to ask the member, Mr. Speaker, if he would not agree that, in fact, given the complexity of this matter, if we shouldn't have tried to...
Order. Just if all honourable members would cooperate with the chair during questions and comments, when a signal is given to wrap up a question or an answer, it would be appreciated if that could happen. The honourable member for Tobik-Mactaquac.
Well, thank you very much, Mr. Chair, and I thank my colleague opposite for the question, and it's a good question, and the root of the answer to that lies in that process that took place between the federal and provincial governments over a period of 12 years. As I indicated, it came to 2007, and then all of a sudden, all the parties realized, the governance piece of this needs to be improved, so both levels of government had to work together to actually do that. Both provincial governments actually passed their legislation, so therefore what would have had to happen is their legislation would have had to change as well on this. So they would have had to gone back to the drawing board. That's my understanding of the process that happened there. So as a result, it was important to make sure there was no major change to that legislation that would happen, that would introduce something that would have to go back and change the mirror legislation in the provinces. So therein lies the answer to that question.
Questions and comments? The honourable member for Medicine Hat.
Thank you, Mr. Speaker, and I'd like to thank my colleague for his speech today. And Mr. Speaker, development of offshore resources is a priority, and it must be done safely. And so I believe this legislation will ensure that that safety takes place. And I would like the member from Mactaquac to actually elaborate on this for me. Thank you, Mr. Speaker.
The honourable member for Tobik-Mactaquac.
Well, thank you very much, Mr. Chair, and I thank my honourable member because he got the Mactaquac right. Very good. There's not a whole lot to do the first time. Thank you. Anyway, thank you much, Mr. Speaker, and thank you to my colleague for his question. It's a good one because basically what this did is it fills a gap in a gray area that was happening in this legislation where there's really an operational responsibility for safety under the Accords, but the occupational health and safety side was not covered at all in this. So then when the person was tragically killed, it was much difficulty at the time assigning responsibility. So what this does, by mirroring this legislation, it adopts a very stringent occupational health and safety, which I commented, almost 200 pages of it are the very detailed occupational health and safety aspects which are brought into the federal and into the Accord Acts. And when one reads through that, it's just phenomenal, the amount of occupational health and safety committees, the powers of the boards, the power of the safety officers to actually go in and actually even stop work. So it's tremendous, and plus with the worker's ability to refuse dangerous work. But the other side of it, it also covers the transportation to the actual off-rig platforms, which is the piece that was actually missing before.
Questions and comments? The Honourable Member for Timmins James Bay.
Mr. Speaker, and I listened with great interest to my honourable colleague's analysis of this legislation. The one thing I'm concerned of is that in Phase 1 of the inquiry report of Justice Wells, he said about recommendation 29 that I believe this recommendation that follows will be the most important in this entire report. And that's, of course, calling for the new independent and standalone safety regulator be established to regulate safety in the offshore. And that wasn't done. And since Justice Wells said that that was the most important recommendation, I'd like to ask my honourable colleague why they didn't follow through on that recommendation.
The Honourable Member for Tobik-Mactaquac.
Well, thank you very much. I want to thank my colleague for his question. And actually, when Justice Wells had 29 recommendations in his report, and actually 29 is not an all-encompassing recommendation. In fact, actually, recommendation 29 was broken into two sections. It was an A and B section. And as we heard in testimony from Justice Wells, when he actually went through this, he talked about things that thought a separate safety authority was a good thing, but I was perceptive enough to realize that not everybody might agree, and I hold no grudge about that. Therefore, I put in the second thing, Canada's offshores, Newfoundland and Nova Scotia, is actually small compared to other areas. So he thought that this was a good position for us. He broke 29 into two components, so you can't look at 29 as an all-encompassing recommendation and take it as its whole because there were two competing parts. So in fact, in his recommendations, as we heard from the CEOs, 16 of the 29 recommendations have been implemented, 12 are in the process to be implemented, and 29B will be implemented. Thank you.
Questions and comments? The Honourable Member for Davenport.
Mr. Speaker, we see with this agreement a progressive and a comprehensive collaboration between the federal government and provincial jurisdictions, and we see the results of that when the federal government works with other jurisdictions to solve some of the very, very important issues that we have before us here. And I'd like the honourable member to comment on that, on the importance of the federal government working with the provinces and sitting down and rolling up the sleeves and dealing with the issues at hand collaboratively with the provinces.
The Honourable Member for Tobik-Mactaquac.
Thank you very much, and thank you to my colleague for his question. And from what I can say, and for New Brunswick, and I know that our minister from New Brunswick, minister responsible for New Brunswick, has forged a great relationship with the province of New Brunswick and is working well with them in all aspects with respect to projects and everything else. And from that standpoint, I don't see that as being an issue. I mean, we just worked very diligently on coming to a conclusion on the job grant, for example. And that happened. We're signing agreements on the infrastructure agreements. Those are things that are coming together. This is another example of how the provinces and the federal government came together with respect to a very difficult and very comprehensive and very complex piece of legislation, hence why it was important to make sure that we didn't get too carried away on amendments and make sure that we have to send each party back to the table again to actually redo their legislative process.
Questions and comments? The Honourable Member for Victoria.
Thank you, Mr. Speaker, and I, through you, thank the member opposite for a very thoughtful presentation. My question to the member is, I understand that there were recommendations made at committee or consideration at committee stage for a 5-year review of this legislation to see whether or not it could be improved in light of experience and in light of the fact that recommendation 29 of Mr. Justice Wells' report was rejected. So my question through you is, why would the government not accept the need, as is found in so many other statutes in federal legislation, for a 5-year review required for in statute?
The honourable member for Tebeke-Mactaquac.
Thank you very much, Mr. Chair. And I think I might have answered that before, but just I'll elaborate more on it again, is that as part of this whole process, these were mirrored legislation that had to go through between the parties. The provinces had already passed theirs. So what this would have led to would have been actually sending them back through an iterative process to actually change it. So that's part of the process. I haven't gone through 12 years and then set a process from 02 to 07 and then a bunch of other changes from governance from 07 to now got us to where we are. I know for a fact, though, but I will elaborate that the federal government and the provinces are still in discussions about the future of this, because the Atlantic offshore is actually small compared to the other jurisdictions which have a central regulator. And as Justice Wells said, you know, when you get to the point where maybe you're on the Arctic offshore and the Western offshore, there might be some more discussions which would have to take place on that.
Resuming debate, the honourable member for Dartmouth-Cole Harbour.
Thank you, Mr. Speaker, and I'm pleased to have the opportunity to weigh in on this important issue again. I had the opportunity to speak at second reading, and I indicated at that time my support for this legislation and for the measures. I was pleased that the two levels of government, the two provinces and the federal government, were finally able to reach agreement. The province of Newfoundland and Labrador and the province of Nova Scotia passed mirror legislation, and the federal government is now following suit. And I did want to focus my presentation today on sort of where we go next. And I wanted to do that, Mr. Speaker, because it's all well and good and extremely important that we get the best piece of legislation we can to serve the purposes that that are laid out in the legislation. But if we don't have the enforcement, if we don't have the political will to make it happen, then frankly we'll go back to the day when the decades when the offshore on the East Coast was covered by draft regulations, by something we see far too often as it relates to private industry, in particular in fields that are so dangerous, and that is the whole practice of voluntary compliance, that governments expect the companies, the individuals involved in any particular industry to be safe, to be careful, to not put workers at risk. But, Mr. Speaker, you and I know that private sector entities, frankly public sector entities as well, but private sector entities do risk analysis at every opportunity, Mr. Speaker, before they put in any constraints on their practices whatsoever, before they introduce any, in this case, safety measures or the use of safety equipment. They will do a very careful analysis on what are the chances that anything's going to happen, that there's going to be problems, that there is a risk that there will be a loss of limb and life. And frankly, even at that point, what is the exposure of that company to liability? That's how it works. That's why it's so important for governments to take their responsibility seriously, to protect those people who are not protected, whether that be the citizens, whether that be customers, whether that be clients, whether that be workers. The people that, in this case, in the Ocean Ranger, the 84 people who lost their lives, in the case of Cougar Helicopter, the 17 people who lost their lives, Mr. Speaker, nobody represented them. Nobody went to the effort to make sure that there were constraints on the private sector companies that controlled what was going to happen to them when those workers were at their job, were carrying out their responsibilities. That's why it's incumbent upon us to not only pass legislation to prevent those kinds of things, but to also ensure that that legislation is enforced, to ensure that there's the political will in place, Mr. Speaker, and frankly to ensure that there's that not only is there enforcement, but that people that contravene, that there's provisions in the legislation to ensure that people that contravene or companies that contravene provisions of the legislation are held accountable. For a second, let me say that we had a terrible tragedy in Nova Scotia in 1992 where 26 miners lost their lives. And there was a Royal Commission held, Mr. Speaker, that made a number of recommendations. It led to Bill C-45 that was passed in this House in, I believe, 2004. And it was done so, and it's called the Westray Bill, and it was done to assign corporate responsibility, to hold decision makers in the company responsible for the results of bad decisions or decisions that led to the loss of life. And yet, since 2004, Mr. Speaker, since 22 years since that disaster happened, there's been a couple of charges, but absolutely no convictions. So that underlines my point that, we need to have the legislation. We need to make sure it's laid out what the responsibilities are. We need to have the enforcement. We also need to make sure that people are held accountable. And ultimately, it all comes down to political will. I wanted to say, Mr. Speaker, that this legislation is only part. We're only going part way. We're only beginning to move in the right direction to ensure that there's a proper regime of health and safety in the industry and regulation as it relates particularly to industry. That our responsibility does not end here. That we need to ensure that as development continues, that we work harder to make sure that the people that work in this environment are protected, and that the environment itself is protected, Mr. Speaker. I want to refer, if I might, to Lana Payne, the Atlantic Director of Unifor, who testified in the Natural Resources Committee, and she said that Canada is still far behind other industrialized oil economies such as Norway, United Kingdom, Australia, United States in having powerful standalone authority in charge of safety and the environment. And that we need to do more to make sure that those standards, Mr. Speaker, the member who spoke before me, he said, we don't have a standalone, he seemed to suggest, we don't have a standalone regulator here, we don't need it. It's a small jurisdiction. It's smaller than the Arctic or the West Coast or maybe some of these other countries. Well, tell that to the 82 families that were affected by the deaths when the Ocean Ranger went down. Tell that to the 17 families of the workers who lost their lives when Cougar helicopter went down, Mr. Speaker. If there's industry, if there's development going to be conducted off of the coast of our country, then we need to ensure that we have proper protections in place as they do in other countries. We haven't done enough. We need to do better. And, Mr. Speaker, on behalf of the New Democratic Party, let me say that we will do everything in our power to ensure that this country does a better job in this area. It's important that the federal government continue to work with the provinces and the offshore boards in this area. There's no doubt about that. I wish that they had have considered the amendment that our members in the Natural Resources Committee introduced. That was an amendment that would see that there be a review after 5 years by the minister on whether this bill was accomplishing, not only accomplishing what it sets out to accomplish, but whether, in fact, the government is doing what I said, which is showing the political will to enforce it and to hold those people accountable. That is something that happens in other legislation. It's not new, and it recognizes that things change, and that, as try as we might, we may miss provisions that maybe we should have picked up, or when it comes to implementing the legislation, we run into difficulties. And that by ensuring there's a 5-year review, we don't go out 10 years, we don't go out 13 more years, we don't go out, Mr. Speaker, into the future and not do our due diligence in making sure that this happened. I want to, if I may, refer to the intervention by my friend Dr. Susan Dodd, who wrote the book *The Ocean Ranger: Remaking the Promise of Oil*. Susan lost her brother when the Ocean Ranger went down, and Mr. Speaker, I spoke at some length about Susan's work in this area when I spoke at second reading, and let me say again how much I value her opinion, the exhaustive research that she engaged in order to prepare her book. She said before committee, Mr. Speaker, she rightly identified the failure to regulate leads not only to the loss of life and the destruction of the environment, but also to the public's losing confidence in the legitimacy of government. When we see disasters such as the Ocean Ranger, such as Westray that I referred to, the explosion of the coal mine in Pictou County in 1992, the Deepwater Horizon disaster, these events are also political disasters, Mr. Speaker, because people ask the question appropriately, why is it that regulations were not existent or not strong enough to ensure? Why, Mr. Speaker, why were there weaknesses in the system, and why were they not addressed years before? Too often changes to health and safety come about as a reaction to an event rather than as a preventative measure. And I would suggest that this needs to be changed. And when I was preparing for these remarks, I went back and looked at the Westray example. I was a member of the legislature back in 1992 when that disaster happened, and within the next day or so, I sat with families in Stellarton who were trying to understand the magnitude of the disaster and whether or not their loved one may still be alive, because in the initial days in that disaster, it was a rescue effort. But, we had a commission. We had a commission of inquiry that didn't really begin until I believe it was 1998, or tabled its report in 1998. 74 recommendations, and Section 73 led to Bill C-45, and that was what I talked about the need to hold decision makers accountable, because what they found in the Westray situation was that there were decisions made or decisions not made that directly led to that explosion and to those losses of life, the loss of those lives. And so what everyone recognized is that those people who had responsibility for making those decisions and didn't make those decisions, or made decisions understanding that a result of those decisions could be a disaster, could be an explosion, which happened, that those people need to be held accountable. And that's what led to Bill C-45. But here we are 22 years later, And we still haven't we still haven't been able to do that. We still haven't held people accountable, Mr. Speaker, for these kinds of workplace disasters. And that's why I worry very much about, our sense of satisfaction when we pass a piece of legislation like this that, we've been at it 13 years, we've worked with the other jurisdictions, and we got it. We got it. And that it passes through this House, and it goes off, and it finally receives royal assent, and we've done our job. And that's just the beginning, is the point that I'm trying to make, Mr. Speaker. It's simply just the beginning, and we need to do so much more to make sure that that we fulfill our responsibilities of representing the people of this country. So, but let me, and let me make it clear that I certainly don't have all the answers on how it is that we protect workers in the offshore industry or we protect our environment, and that's why I feel compelled as an individual MP and a member of this House to say that we need to be ever vigilant and make sure that we are always listening and make sure that we're always paying attention so that we can ensure that the right thing is done and that we correct our mistakes and that we move quickly, because we're responsible to representing not only in this case people that work in that industry. We're also responsible for the environment in the event of oil spills, because we've got as my colleague from St. John's East said, there will be a third rig in operation in 2017, even farther off the coast of Newfoundland. They're exploring off of the coast of Nova Scotia, in the Gulf. It may be an inevitability that there will be further development of these resources, but we cannot proceed without ensuring that we are protecting the people that work in the industry and that we're protecting the environment, because, Mr. Speaker, once those disasters happen, those lives are lost, and that environment is damaged mainly in many cases forever. So let me make a couple of suggestions. One is that I would call on this government and any government to support the recommendation that has gone to before Transport Canada to ensure that all airplanes and helicopters that are used for search and rescue and to transport workers to and from the oil rigs must have the capability to operate for an hour after they have no oil or run dry. That has been a recommendation. In fact, it was, I believe, 30 minutes. And that recommendation has still not been put, even after it was determined that that's one of the problems that led to the disaster with the Cougar helicopter. That still hasn't been implemented, Mr. Speaker, and I think it's extremely important that we ensure that regulation is put into place, and we know that this is a fairly standard requirement for helicopters that operate off the coast to give them time to land safely. Secondly, the government needs to reverse its cuts to search and rescue and make sure that our search and rescue teams, our SARS teams, have the equipment necessary and in working order in order to carry out their missions as quick as possible. These are life and death situations that these people are responding to in Atlantic Canada and around our coasts, and it's too often the case that search and rescue missions are hampered because our dated equipment is not functioning or the teams are unable to arrive in a timely manner. Mr. Speaker, I think it's important that I also make a plug for the environment in this respect. As I've already said, once again, Canada is lagging behind. While the government has recently introduced legislation to increase oil and gas spill liability to $1 billion. This amount pales in comparison to the actual costs of a spill, cleanup, and the impact to our environment and local economies. Mr. Speaker, as I wrap up, you indicate that my time has come to a conclusion. There is still a lot of work to be done to strengthen the safety of the offshore industry for our workers and for our environment. While Bill C-5 is a step in the right direction, I think that it's incumbent upon the government to continue to work with the provinces, the stakeholders in industry to prevent future disasters. Thank you.
Questions and comments? Honourable Parliamentary Secretary to the Minister of Natural Resources.
Thank you very much, Mr. Speaker. Both provinces have already given royal assent to their respective bills to enact these changes, as has been noted, and they are waiting patiently for Bill C-5 to pass through the House of Commons and come into force. Justice Wells appeared at the Natural Resources Committee and said he was pleased with the legislation, and I quote, "Somebody has worked hard. More than one person, I suspect, on this bill. I know that it's been under construction for a number of years. Quite honestly, I think it's a good job, and I think it will help to formalize some of the concepts that people knowledgeable about the industry and the regulatory people have thought about for some time. But to see it enshrined, or hope to see it enshrined in legislation, is a good thing." And I guess my question for the member opposite is, did he read the transcript of that meeting, and does he have any comments to make?
The Honourable Member for Dartmouth Cole Harbour.
Thank you, Mr. Speaker. I will say that Commissioner Wells made compelling testimony at the committee. There's no doubt he worked hard to bring forward important regulations, which led to the compilation of this piece of legislation. He was also pushed on his recommendation 29, which called for an independent regulator, because of the fact that he was suggesting, and he has suggested that, well, you know, this bill is a good step forward, and yes, it doesn't have a single regulator in it, but it's a good step forward nonetheless. He did acknowledge that the single regulator recommendation that he made, which is in existence in other oil-producing nations, Mr. Speaker, is extremely important, and it's not something that should be forgotten.
Questions and comments? The Honourable Member Timmins James Bay.
Thank you, Mr. Speaker. I listened with great interest to my honourable colleague, and of course, bringing us back to the terrible tragedy of Westray, coming from a mining community. Our families were certainly very, very struck with that. And I remember being in Stobie Mine one time, and there was a safety sign on the wall, and the miner said to me, "They only ever put that after someone loses an arm or after someone dies, that all the safety recommendations come after tragedies," which is why I'd like to ask my honourable colleague our concern about the importance of maintaining the full complement for search and rescue offshore, because we can't afford to think, well, maybe it won't happen. These things do happen, and you need to have the full force of law, and you need to have the search and rescue capacity. And this was certainly something that I think Justice Wells was talking about, and the need to have an independent board set up. And yet this government seems to show no interest in that. I'd like to ask my honourable colleague, given the fact that the Minister of Natural Resources of Newfoundland said, while discussions have been ongoing with the federal government on the implementation of Recommendation 29, the federal government has not indicated any interest in establishing a separate safety agency.
The Honourable Member for Dartmouth Cole Harbour.
Thank you, Mr. Speaker. And you know, the member's absolutely right. That, you know, we've seen search and rescue capability reduced under this government, offices closed, you know, offices cut back, the capacity, our equipment is limited, and in other words, our ability to respond is a serious problem. It was interesting that during Dr. Dodd's testimony at committee, she made an interesting reference. She said that she was recounting a conversation she'd had with John Crosby, former Lieutenant Governor of Newfoundland, and certainly a longstanding member of this House, when he said to her, and she quoted, "We still don't know how to get those men off those rigs." And that goes to the whole question of a safety regime, but that more importantly goes to the resources that we put to search and rescue. Mr. Speaker, we're not doing a good job in that respect.
Questions and comments? Resuming debate, the honourable member for Surrey North.
Thank you, Mr. Speaker. Mr. Speaker, I rise today on behalf of my constituents from Surrey North to speak to Bill C-5, the Offshore Health and Safety Act. Mr. Speaker, this bill is an accumulation of over 12 years of negotiations that started back in 2001 between the federal government and the provincial governments of Nova Scotia, Newfoundland, and Labrador. Now, as we all know, Mr. Speaker, no bill is perfect. This bill is certainly not perfect, but 13 years later, this bill is well past due, and I'm currently glad to see that this important step is taken forward. It is far past time that this legislation, this legislated offshore safety regime be put into place. Mr. Speaker, all workers, whether they work onshore in our communities or offshore, deserve to work in a safe environment and to have their rights protected. This bill places overall responsibility for occupational health and safety on the operator. This means that the employer is responsible for implementation and coordination, although employees are still expected to take all reasonable measures to comply with occupational health and safety measures. There are basically three principles in this bill, Mr. Speaker. First, the offshore occupational health and safety laws must provide workers with protection at least as good as those which exist for onshore workers. And second, protection of employee rights. And third, support for an occupational health and safety culture that recognizes the shared responsibilities in the workplace. These basic principles address protections that should be available to all workers. It is a shame that offshore workers have had to wait this long for these protections to be afforded to them. Mr. Speaker, it comes as no shock to me that the Conservatives waited this long to bring this legislation to the House. This is not the first time that we have seen the Conservatives drag its feet and delay long overdue legislation. However, having finally reached the point where we can give these offshore workers the protection they deserve, this bill represents a very necessary improvement to the current offshore health and safety regime by finally placing safety practices into legislation. My colleagues and I have been calling for this, my NDP colleagues, and I have been calling for this type of strengthened regime for several years, and we are proud to support Bill C at this stage. Now, Mr. Speaker, I mentioned earlier that this bill is not perfect, and I would like to explain my comments to that. The glaring deficiency in this bill is the federal government's refusal to implement Recommendation 29 of Wells Inquiry. The Wells Inquiry took place after the March 2009 crash of a helicopter approximately 30 nautical miles from St. John's that left 17 dead and 1 lone survivor. The Recommendation 29 of this inquiry demanded the creation. Mr. Speaker, the recommendation that was Recommendation 29, and Wells, before he made the recommendation, and he made this point very clear, and I'm going to quote him what he said, and this is a quote from him. He said that, I believe that the recommendation which follows this explanatory note will be the most important in this entire report. So this is a direct quote from the author of this inquiry who made this recommendation, and he pointed out Recommendation 29 was the most important of all of the recommendations, and here's what it said. It basically, Recommendation 29 of this inquiry demanded that the creation of new, independent, and standalone safety regulator. An alternative option was also recommended in this report. However, unfortunately, Mr. Speaker, Bill C-5 fails to establish either of these options. It seems that this government is not committed to establishing this necessary reform and closing the gap that remains. On this side of the House, Mr. Speaker, we are committed to working with Nova Scotian government and Newfoundland and Labrador government to further strengthen health and safety by working towards the creation of an independent, standalone safety regulator as recommended by the Wells Inquiry. As Canadians, Mr. Speaker, we should strive to set an example for the rest of the world. We should be leaders on global stage. However, time and time again, Mr. Speaker, I'm faced with examples that show that we are not keeping up with the global best practices. This was apparent. I made a speech yesterday, just the other day, when we debated Bill C-22, and Canada is not keeping pace with international standards that are being set for nuclear and offshore gas liability. And here, Mr. Speaker, let me give you an example of what I talked about yesterday, how we're not keeping pace with the international standards and how we're not even making the polluters pay themselves. Yesterday I talked about my son and my daughter about the liability issues that were in Bill C-22. Apparently, the current liability for offshore gas disasters or oil or nuclear disaster is about $375 million, and now we're upping it to $1 billion. And we've seen the disasters that have taken place in Japan, the nuclear disaster, and also we've seen the disaster in the Gulf of Mexico. And recently we've had the 25th year anniversary of the Valdez oil spill on the West Coast, where I'm from, Mr. Speaker. And we know for a fact that $250 billion is the rough estimate now, the cost of the disaster in Japan, and it's into tens of billions of dollars in the Gulf of Mexico, and again tens of billions of dollars in for the Valdez disaster in the Pacific Ocean off of BC. And my point here is that we're increasing the liability for liabilities for these disasters to $1 billion for these corporations or people that are producing these gas and oil, and also private industry that is operating our nuclear plants and stuff. So I asked, I'm using an analogy from my own home. $1 billion is not enough to clean up the mess that's caused by hundreds of billions of dollars. So corporations, in other words, are getting a free ride. If there's a disaster, guess who's going to be held holding the bag? It'll be the taxpayers. It'll be Canadians that'll be held liable for the rest of the cleanup. So again, Mr. Speaker, we're not looking at other countries, what standards are out there. And one of we can look at other countries, Germany, European countries, which have a substantially higher liability for these issues. And I used an example yesterday of my kids. My son is 7 years old, and he makes a mess, and he doesn't want to clean it up. He cleans a little bit of it, actually. And then the rest of it, he wants his sister to clean it up. And the sister comes up to me and says, well, no, it's his mess. He should clean it up, Mr. Speaker. And I explained that to my wife, explained that to my son, and that is his mess that he needs to clean up. He can't pass on his mess to somebody else. And that's what we are doing. And we're not looking at other standards. That's what we're doing in regards to the liability issues in regards to nuclear disasters, whether it's oil or gas. So certainly we need to look at other governments across our partners south of the border, and also other nations to look at ways of improving that. And that's the case in this particular situation, where one of the major recommendations is to have an independent regulator, as Wells has pointed out, a new independent and standalone safety regulator. And we need to look at what other countries are doing for best practices, and we haven't done our job here. And that was one of the recommendations that Wells Inquiry had recommended, and it clearly, again, it pointed out that this was the most important most important recommendation, again, this was ignored by the Conservatives. And countries like the UK, Australia, Norway, the United States all recognized the value of an independent shore regulator and have taken steps to put this into action, Mr. Speaker. And why should the Canadians' offshore and gas industry and Canadian workers be treated any differently? That's my question to this government. Why should they be treated any differently from some of our partners around the world, whether it's Europe or south of the border from here? Mr. Speaker, instead of setting an example, being leaders, Canadians being leaders in a particular area, and other countries to follow, we are lagging behind. It's time that we reverse this trend. And I'll give you another example, Mr. Speaker. We are world leaders when it comes to elections. When it comes to conducting elections, we are world leaders. We're viewed as a model for other countries to implement. And we learn from each other. We learn from other countries. We use some of their best practices, and they use some of our best practices. And I'm very proud. I'm very proud as a Canadian that our election systems model are used worldwide to put in place to conduct fair elections. And what are we doing in this country? We've had top three, the elections commissioner, the Elections Canada people. We've had Newfield testified in the committee that the changes that are being brought forward by the Conservatives in the Unfair Elections Act are not actually strengthening our current election system. In fact, it's going to disenfranchise hundreds of thousands of Canadians. And that's not an example that we want to set, Mr. Speaker. So we want to go in the right direction. The right direction is to improve the systems that we have in place and ensure not only democratic values are protected, but ensure that our workers, our offshore workers are protected, that they have the same safety level as workers have onshore. And that's a very disturbing trend that we are witnessing from this government. We need to improve on safety of our workers. We need to improve safety as well as safety of onshore and onshore workers. And Mr. Speaker, I'm going to come back to that. Not only does this bill not provide an independent, standalone safety regulator or an autonomous safety division within the petroleum boards, our efforts to provide for a review of bill in 5 years were voted down by the Conservatives in the committee stage. This, yet again, demonstrates the Conservatives' lack of interest in further strengthening this bill. Allowing for a review of this bill in 5 years' time would have provided an opportunity to re-evaluate whether an independent safety regulator is needed. So even if they didn't put in the safety regulator in the first place, we asked in the committee stage, say, well, let's review this after 5 years, and maybe you guys will come around to or will find evidence to ensure that we do need an independent safety regulator. And when we talk about evidence, Mr. Speaker, it's very clear that science and facts, when we talk about science and facts, they don't really figure into the Conservative equation. That whether it's environment, whether it's, well, take a look at jobs. Just the other day, Kijiji. This government is using Kijiji facts to inflate the number of jobs that are being created in this country. Mr. Speaker, let me tell you, Kijiji is a website. I've never actually used it. And I looked it up today and I said, what is this Kijiji thing? I'll go find out. And Mr. Speaker, I looked it up and there's, actually I've got it right here, Mr. Speaker. No, I don't have it. But I looked it up and it's a website for people to exchange, trade household goods. In fact, you can even buy a used tie on Kijiji. You can buy used shoes. And there's other things that are traded on this particular site. So the fact of the matter that this government, I know they're allergic to facts when it comes to research facts, but they actually use Kijiji of all the websites to inflate the numbers they have for their, the number of jobs that are available for this country. So I know, Mr. Speaker, it's these kinds of things that makes you suspicious of what other facts they're going to bring in. I know I've talked about the Unfair Elections Act, and they talk about, there's been many irregularities. We need to strengthen our Elections Canada Act. We need to make it fair. And there's 50,000 irregularities. Well, Mr. Speaker, when you ask these guys, when you ask the government, they say, well, how many people were charged with fraudulently using voter identification cards? How many people were charged in the last, I don't know, since Confederation, of people for voter fraud? Zero. They can't come up with any examples. It's just, they do have examples. They make up. I know the member from Mississauga, Streetsville, he brought up some facts, which he had to retract because they were false. They were false. And that's the kind of facts and figures they make up, Mr. Speaker, and it's unfortunate that they do this. Mr. Speaker, how much time do I have? Still got a few minutes. I'm going to wrap up, Mr. Speaker. And, Mr. Speaker, so getting on with the real facts would have been to, okay, well, we're not appointing the regulator now. Well, let's evaluate it. And that makes sense to me. That makes sense. So let's look at it 5 years from now, and then we'll look at the facts, reevaluate the facts, and see if we need a regulator. But even they turned that out. And we've seen this in committee. Any sort of recommendation, and I've been here for a number of years now, Mr. Speaker, there's been thousands and thousands of recommendations made to improve the bills, to improve upon the bills that are presented. And we've heard from witnesses, experts, people, the stakeholders, pledging, begging this government to make those changes so they're beneficial to the stakeholder, the very people that it's going to affect. And we've seen very, very few, if any at all, amendments being adopted at the committee stages. And Mr. Speaker, I know that wasn't usually the case. Usually members of Parliament were able to bring in amendments to the bills, and we were able to improve upon bills. And that's the work of this Parliament, to improve upon legislation that is brought forward. That is part of my job, bring in the views of my constituents and the very people that are being affected by this, Mr. Speaker. But unfortunately, the Conservatives, they get their marching orders from the Prime Minister's office, and this is it. This is how we're going to go about doing it. And we're seeing that same thing with the bill that's been at the committee stage with the Unfair Elections Act. The reasonable amendments provided the opportunity to improve the bill, but the Conservatives again chose to reject the amendments on a technical issue. Due diligence and good governance requires the review of legislation, particularly in this case where we're dealing with complex legislation that involves multiple levels of government. This is consistent, Mr. Speaker, with the Conservatives' unwillingness to consider amendments that will strengthen the legislation that comes to the floor of this House. It is not the first time we've seen this, and I can guarantee you, Mr. Speaker, it won't be the last. Finally, Mr. Speaker, I just want to point out how refreshing it is to see a bill that represents collaboration efforts of province and federal governments, although it's taken 8 or 9 years to bring it to this stage. But I'm happy that finally Conservatives were able to collaborate with the provinces. But I can give you a couple of examples where they have failed to collaborate, Mr. Speaker. And I want to announce this in this House, that I'm very pleased that the Port Metro Vancouver is up and running. As you know, Port Metro Vancouver is a large facility, one of the largest ports in Vancouver, in Canada, and it employs directly or indirectly 60,000 employees. And we had a strike going on for the last 4 weeks. And, instead of negotiating, let me back up here a little bit here. Just as last week, this dispute was simmering since 2005. The truckers have been bringing their attention to their government's attention, some of the issues they were having locally. Last 8, 9 years. And what has the government been doing? Nothing. They have done nothing over the last 7 years to address these issues. Mr. Speaker, I know I have 1 minute. I'm going to finish this up. So even last week, the Conservative, the Prime Minister went into Vancouver. He's saying, oh, no, this is not our problem. This is a problem for BC. And what the BC government was saying, no, this is not our problem. This is actually a federal government. So a problem that was simmering for 8-9 years, provinces, British Columbian province and federal government couldn't collaborate, figure out whose problem it was, and we lost billions of dollars because of this strike. And I would put this blame squarely on this government, Mr. Speaker, their lack of ability to collaborate with the provinces. Mr. Speaker, again, although this bill could be greatly strengthened, and again, one of the things that's lacking from this bill is the recommendation 29, which calls for an independent regulator. And with that, I know my time is up. I thank you very much.
Questions and comments? The honourable member for Langley.
Well, thank you, Mr. Speaker. I listened with great interest to my friend across the way. I have a couple of questions for him. First of all, has he ever heard of Vince Reddy? And if so, how did he get involved with the dispute at the port? Also, it appears that the NDP is promoting Kijiji. Does any NDP have, do they have any actual interest in there? And did they use Kijiji for the renting of facilities to promote the NDP in ridings that they don't hold? Thank you.
The honourable member, Timmins, James Bay's, rising on a point of order.
Mr. Speaker, we're always told that they have to deal with government business instead of those kind of cheap shots. We're dealing with a serious issue, which is the safety of lives here. So if the man wants to do a clown act, I would prefer that he does it outside and not within the chamber.
First of all, in response to the member from Timmins, James Bay, his reference, I think, to some of the language in his point of order itself, it probably goes beyond what is necessary. Having said that, the honourable member for Surrey North took great breadth in his speech and referenced many issues that arguably are not directly related to C5, wandered afield, and subsequently the question from the member from Langley follows up on two of the points raised by the member from Surrey North, neither one of which would seem to have much to do with the matter that is before the House. So I'm going to go to the member for Surrey North, something very brief, but I would like to remind all honourable members of the matter that is before the House, and that is C5, and both the questions and the answers ought to refer to that. The honourable member for Surrey North.
Thank you, Mr. Speaker. And Mr. Speaker, I know we have quite a bit of leeways in regards to how we speak to the bill, and I tried to bring different aspects to this discussion. And I thank the member for asking that questions in regards to Vince Reddy, Port Metro Vancouver. Vince Reddy is a very respected mediator in Vancouver, and I do respect him. And Mr. Speaker, again, you're getting up, and how much time do I have to answer this question? I'll leave that.
Order. The member for Surrey North is in an awkward position to be trying to answer a question that clearly has nothing to do with the bill. Therefore, I think I'm going to move on. Questions and comments? The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I thank my honourable colleague from Surrey North for his presentation on Bill C5. When we're looking at issues on the offshore, I think we can all agree that this bill does go a long way to improve the regulatory environment for safety. It's a long time coming. But I'd like to ask my colleague from Surrey North if he doesn't agree with me. It would have been preferable, and I think he indicated this in his remarks and could perhaps expand on it, if we had a more independent safety officer in this regime. And that, to me, is the weakness of the bill we have in front of us.
For Surrey North.
Thank you, Mr. Speaker, and I thank the member from Saanich Gulf Islands. Got that correctly. And of course, Mr. Speaker, we have been calling for that. I think it's important to have independent regulators be part of regulation, health and safety hazard issues, and we have actually been advocating for that. And in fact, one of the key recommendations from the Wells inquiry was this establishment of the independent regulator that would oversee this. And again, we had offered an amendment to the bill which had called for review of this after 5 years. Do you think you would look at some of the facts and figures, and that's why I brought in Kijiji earlier on. But unfortunately, this particular government does not look at facts and figures, Mr. Speaker.
Questions and comments. The Honourable Member for Drummond. Thank you, Mr. Speaker. I would like to thank and commend my colleague for his excellent speech. He provided us an excellent overview of this bill, and he also showed us a number of the other aberrations that we have been seeing this week in the House of Commons. And I think that the NDP did an excellent job at report stage in committee. The members who were sitting on the committee did great work. They participated in the discussions. They listened to the testimony. And the NDP moved an amendment, which unfortunately was rejected by the Conservatives. And I don't understand why the Conservatives refused that amendment. It is very simple. It simply calls for every 5 years for the enforcement of the Act, a review be done as to whether an independent safety regulator is required in the offshore industry. So why did the government vote against our reasonable amendment? Perhaps my honourable colleague could explain to me why this happened. A review of the Act is a good idea every 5 years. It seems to me perfectly reasonable. Thank you.
For Surrey North.
Again, Mr. Speaker, I thank my colleague, and he does ask lots of questions. We're seatmates here, but thank you for getting on record to ask me this particular questions. And you know, I can't speculate on what Conservatives think, why they are not wanting an independent safety regulator. And it would make sense to me. It makes sense on this side of the House that you have somebody actually independent regulating health and safety of Canadian workers. Having said that, and the member pointed out that we had, moved an amendment to have this reviewed after 5 years, and that would be the next logical step, which is to look at the facts and figures and see if the current regime is working. If it's not working, then we can take that extra step to provide additional health and safety envelope for our workers, whether they're onshore or offshore. In regards to the amendments, Mr. Speaker, and I'll say it on record again, this government is allergic to facts, and they're allergic to some good ideas, not only from the oppositions. They're allergic to some good amendments, even from the stakeholders, the very stakeholders that many bills are introduced by this government are going to be affecting.
Questions and comments. Honourable Member for Winnipeg North.
Thank you, Mr. Speaker. I do believe that it's important that we recognize that it is great for us to acknowledge the needs, health and safety of workers, in particular our offshore, onshore workers, and not necessarily to confuse that with a very strong federal initiative. In fact, this legislation is before us because of provincial jurisdictions that have already acted on the issue, and now there's more of an obligation of the federal government to bring forward legislation. I have always thought that the government today has not really been proactive in dealing with health and labor type of issues. And maybe the member might want to comment on that, that it's not this government that's necessarily providing the leadership on this, that in fact they're responding to provincial governments and their actions to date. If he might want to add some comments on that.
The Honourable Member for Surrey North.
Mr. Speaker, I thank my colleague for that question. He's actually correct. This legislation has been enacted in Nova Scotia and Newfoundland, and a lot of the regulations and work that's being brought forward in implementation of this act is already being done in Nova Scotia and Newfoundland. And he's absolutely right. This government is not proactive when it comes to health and safety or even worker rights. And we've seen that in the Port Metro Vancouver strike, where last week even the Prime Minister was saying that, well, you know, this is not a federal responsibility, and the province was saying, well, it's not a provincial responsibility. And meanwhile, we had one of the largest ports shut down because of the lack of this government's ability to coordinate and see a simmering dispute that was brewing for 8 years, and they weren't able to figure out whose responsibility was. There were 60,000 jobs related to this facility for over 4 weeks. We had one of the major ports shut down. It was lack of proactive work on this part of the government.
Resuming debate, the honourable member for Victoria.
Well, thank you, Mr. Speaker. Appreciate the opportunity to rise today and to speak on Bill C-5 at third reading stage. I wish to announce from the outset that I will be sharing my time with my colleague, the member for Drummond, and I'd appreciate if you could indicate, Mr. Speaker, when I have a minute left in my opportunity to speak today. I was, of course, from the West Coast, not as familiar with the industry in Newfoundland and Labrador and Nova Scotia that has taken off in the last generation, and was very impressed, therefore, to hear when my colleagues, the member for Dartmouth Cole Harbour and the member for St. John's East, spoke so passionately about just the impact that the offshore oil and gas industry has had in those two jurisdictions, and to remind us as Canadians from coast to coast to coast just how important it is to our national economy. 35% of Canadian light crude industry, light crude oil apparently being generated by that industry, and it's an expanding industry. I had the opportunity, I confess for the first time, to be in St. John's several months ago and to just see the enormous impact that industry has had in that jurisdiction, and I know in Nova Scotia as well, and to just learn how proud the people of that jurisdiction are with respect to the contribution it's made to their economy. So therefore, it becomes even more important that we address the issue of worker safety in that industry. I was shocked to learn that there has been no statutory safety regime in that jurisdiction, in either jurisdiction, for a generation. Essentially, the industry has been operating without any kind of legislated jurisdiction, legislated regime for protection of worker health and safety for a generation, but rather has been relying upon merely draft regulations. And so, as my friend from St. John's East, I thought, pointed out very accurately, the only thing that could be done in the event of a problem was to shut the whole thing down, which, of course, is something that is often something regulators would be very loath to do. So in place of that, we now have a very comprehensive bill before Parliament, finally, a bill that is made in collaboration with the provinces of Nova Scotia and Newfoundland and Labrador, to have a consistent regime to deal with this burgeoning industry. And I think it's for that reason alone, Mr. Speaker, that the official opposition is in entire accord with the need to move on with this legislation. And when I say move on, I point out just the over a decade that it's taken to get us to this place with legislation. And I understand and respect that there has been collaboration, perhaps something that hasn't been done by the government to any great degree, to work closely with the provinces in this regard. And I think that the proof is in the pudding. We now have a regime that the province of Nova Scotia has enacted, at least to which they have given royal assent, and similarly the province of Newfoundland and Labrador in May of last year. So we're getting on with it. They're getting on with it. The workers want us to get on with it. And I see all Canadians would certainly understand the need to enact a regime as comprehensive as this before us. I should say at the outset, Mr. Speaker, that enforcement is really what is critical here. There are a number of important principles in the legislation that have been spoken to by members opposite as well as members from the official opposition. The principles, threefold principles being ones that we would all, I think, subscribe to, that first of all, that offshore occupational health and safety laws must provide workers with the protections at least as good as those for onshore workers. There can be no doubt that that is only fair and appropriate. Secondly, that the protection of the employees regards to right to know, to participate, and to refuse unsafe work, and in doing so to be safe from reprisal. This second principle is one that is, in the last 2 decades, 3 decades, been made a significant part of labor law in this country, and it's about time that the workers of offshore Newfoundland, Labrador, and Nova Scotia enjoyed the same rights. And thirdly, support for an occupational health and safety culture that recognizes shared responsibilities in the workplace. You know, we can talk about laws, we can make laws, we can pass, in this case, scores of pages, and then, of course, many, many scores of regulations under the statute. But unless there's a culture of safety in the workplace, it really amounts to nothing. And, Mr. Speaker, what is also so critical as we examine a regime like this is the extent to which there is enforcement. It was Shakespeare who talked about full of sound and fury and signifying nothing. If this law isn't implemented carefully, responsibly, and with that culture of safety, health and safety that has been referred to, it really will be nothing more than paper. And no one wants it to be that way. No one wants it to be that way when we look back in sadness on the Ocean Ranger disaster or the helicopter crash in 2009 that killed 17 people. Clearly, we're dealing with the importance of regulatory regime, of a robust regulatory regime. That is what we are here to discuss. Mr. Speaker, at a broader level, this is a great example, this legislation, of cooperative federalism at its best. The notion that we can sit down with the provinces who have their own circle of jurisdiction and the federal government, which of course has its jurisdiction. We have these offshore boards, federal, provincial, that have been created. And to work together and produce something like this is one of the things that makes Canada such a great country, our willingness to work together. It's sad that it's taken this long. It doesn't appear to be a priority for this government. Given the delay, it doesn't appear to be the priority one would have expected. But nevertheless, we are here, and we are pleased that we are here to debate such an important piece of legislation. Mr. Speaker, I mentioned the 3 principles that I think are so central to this bill, but I should, of course, salute the work of Mr. Justice Wells, who came up with the recommendation after the helicopter crash, a number of recommendations that have been saluted by people on all sides of this House today. He worked hard, and I think it, however, telling, and we've heard this before in the debate today, that the recommendation that he thought was the most important is not part of this legislation. That is sad, Mr. Speaker. Recommendation 29 in Mr. Justice Wells' report, he says the following, quote, I believe that the recommendation which follows the explanatory note will be the most important in this entire report, close quote. What is that recommendation? That there be an independent and standalone safety regulator be established to regulate safety in the Canada-Newfoundland offshore. And if that weren't considered feasible, Mr. Justice Wells gave an alternative, a fallback, that the government, quote, create a separate autonomous safety division of the board with a separate budget, separate leadership, and an organizational structure designed to deal only with safety measures, close quote. So, Mr. Speaker, the architect, Mr. Justice Wells, who brought this to the attention of the regulators so forcefully, said that the most important thing is an independent, standalone regulator, and the Government of Canada, sadly, has refused to accept that, what Mr. Justice Wells himself characterized as the most important recommendation in the entire report. So obviously we can't be happy with this legislation entirely, notwithstanding that we finally have it, when such an important piece of the puzzle is missing. A piece of the puzzle, Mr. Speaker, that is found in so many of our sister jurisdictions with offshore oil and gas, the British with the North Sea, the Norwegians, Australia, and the United States now. Yet Canada doesn't seem to think we need to go there. If there was anything we understand from regulatory culture, it is the notion of regulatory capture. The need to have an independent board to do the job is something that most people, at least in other jurisdictions, seem to take for granted now. But for reasons that escape me, our government seems to think that is not adequate, even though it had been sought by so many, the provinces, the workers, and the like. So that is something, sadly, that is missing. I should say then, Mr. Speaker, that the bill could be much, much better, but we will support it, and support it proudly because of the fact that the workers are involved. There were consultations, and I just hope that going forward they will continue to be involved. I wish there had been a way to have a 5-year review as sought at the committee, because that has been done so effectively when other Conservative governments were around. This government, of course, doesn't believe in that. But nevertheless, I do think it's critical that we look at that in the future, as this bill will inevitably come forward for amendment, and maybe we can do it better. Maybe we can do what Mr. Justice Wells said we needed to do is the most important feature. Maybe we can do a better job protecting those workers in those dangerous occupations off the shores of Atlantic Canada. Thank you, Mr. Speaker.
Questions and comments? Honourable Member for Vegreville Wainwright.
Yes, thank you very much, Mr. Speaker. You know, Mr. Speaker, I want to commend the member opposite for his presentation today. In fact, he was doing really well until he got to the part about Judge Wells' recommendations. And I say that because we had Judge Wells before a committee on this bill. And that question was asked to him in several different ways about the fact that recommendation 29 was not included in the legislation. And he made it really clear, Mr. Speaker, that in fact the protection that he referred to in recommendation 29 was covered by this bill and covered extremely well. In fact, he said, and this is a quote from the committee, he says, "Someone has worked hard, more than one person I suspect, on this bill. I know that it's been under construction for a number of years. Quite honestly, I think it's a good job, and I think it will help to formalize some of the concepts that people knowledgeable about the industry and the regulatory people have thought about for some time." So, Mr. Speaker, that's his comment, and it was in response to a question about recommendation 29. I'd like to ask the member why he just doesn't take Judge Wells' word for it, that in fact the concerns he expressed in recommendation 29 have been covered in other ways.
The honourable member for Victoria.
I thank the honourable member for his questions, and I agree that Mr. Justice Wells did make those comments before the committee, and I think I understand the context in which they were made. Obviously, it's critical that we get on with this. I think I said that as powerfully as I was able. I think Mr. Justice Wells recognized that as well. Having said that, he never drew back from the specifics of the quotes that I read to the House of Commons just now. He did say that it was the most important feature of his bill. And it's, Mr. Speaker, it's for that reason that the notion of not having a statutory 5-year review seems even more difficult to fathom. Because the Progressive Conservative government under Mr. Mulrooney was, of course, a government that listened to committees, had unanimous reports when 5-year reports came forward. And to me, that's something that this bill desperately needed. And yet the government, of course, since it wasn't their idea, said no.
Questions and comments? The honourable member for Dartmouth Cole Harbour.
Thank you, Mr. Speaker. The member from Victoria asked this particular question earlier today in this debate, and that is about the practice of having in legislation provisions that require legislation to be reviewed after a period of 5 years. I'm familiar of that at the provincial level, more particularly, and I was interested to hear his point that that is also the case at the federal level. I wonder if he could comment. I've had the opportunity to speak about it a bit in terms of the principle, but I wonder if he could elaborate a bit further in terms of the practice as it relates to federal legislation.
Honourable member for Victoria.
Thank my friend for his comment. I think one of the great inventions over the last few years was to use more and more of statutory reviews. I can give 3 examples of which I'm aware. There's one in the Access to Information Act. Secondly, there's one in the Privacy Act. Thirdly, there's one in the Canadian Security Intelligence Act, each of which says there shall be a review by a House of Committee within 5 years or 6 years, whatever, for that statute, to see just whether the experience is in fact what you would expect given what you passed 5 years ago. It seems so sensible. It seems like such a good Canadian idea to sit down, require Parliament to review it to see if there's anything that needs to be fixed. Here we have a statute which is scores of pages long with regulations that will be hundreds of pages in length. Mr. Speaker, it seems ridiculous not to have the benefit of that in this legislation. I don't understand why it couldn't have been done. A member opposite said it was because there's provincial legislation that mirrored it, but that's not an excuse for the federal government within its jurisdiction deciding to review the legislation in a 5-year period.
Resuming debate, the honourable member for Drummond. Thank you, Mr. Speaker. I'm pleased to rise in this debate today to speak about Bill C-5, which is a bill to amend the Canada-Nova Scotia Offshore Petroleum Resources Accord Implementation Act, the Canada-Newfoundland. It's a very long title in any case. It's a very important bill because it has been expected now for some 13 years. So obviously it's one that the NDP was asking for measures that would give us more measures, safety measures for those working in offshore petroleum facilities. Now, when I start to talk about the law, I would like to mention the excellent work that the committee has done on the study of this bill. And I would like to name the excellent NDP colleagues who did such good work studying this bill to ensure that it could move forward and be studied here today. There's the excellent member for Burnaby New Westminster, among others, who did excellent work on this subject. The excellent member from Abitibi-Témiscamingue, the also excellent MP from Edmonton Strathcona, who worked so hard, not only on natural resources, but also on the Environment Committee and is very knowledgeable in that area. The excellent member from St. John's East, and also the MP for St. John's South Mount Pearl, who has worked on this. I mention it because committee work often is not well known by a lot of our constituents, and I discuss often with my constituents in Drummond what the importance of this work is, and the fact that it has to be as objective as possible and not tainted by partisanship. It is work that's done in the interest of the general population, and the NDP's work here is remarkable. I always tell my voters in Drummond, and I've been working on this for almost 3 years now since my election in 2011, and I always try to do this work with my colleagues so that it is as much as possible to the benefit not only of my constituents in Drummond but of all Canadians, so that we have the best bill and that we do the studies that will be the best in terms of the environment, sustainable and development, etc. So the Natural Resources Committee studied C5 in order to improve health and safety of the offshore workers, and particularly in the petroleum and oil and gas sectors. What I have to say, first of all, is that my colleagues' work is very important, and they moved an amendment. The NDP colleagues, as I mentioned, tabled one that was intended to improve the bill by including a provision by urging the ministry, looking at the bill rather, to review it 5 years after its passing. So we have a bill that is an interesting one, and I'll speak a bit of its details later. It does bring improvements to the regime, but there are other things that still can be improved. That's why it's important that we support the bill at this stage. There has to be a review period. With every significant bill, there is a review period. And take, for example, the Canadian Environmental Protection Act. There is a period that is provided within that. We're supposed to be at that stage with that legislation right now, and I don't know where the Conservatives are with that. They've forgotten to do certain things. Sometimes when they review some legislation, they forget what's happening. And pardon my Anglicism, but they scrapped the bill completely. They went from thousands of environmental assessments to some dozen. And because of that, we have significant problems, like the acceptance, for example, of the Enbridge pipeline. That was done without there being any environmental assessments at all. And so that's the same thing that's happening here with C5. We have a bill that will not allow for proper review because they did not accept our amendment asking for a 5-year review. On that note, I would like to mention, Mr. Speaker, that this bill, C5, does correct some shortcomings that have existed for a long time in the legislation and in the powers that are related to health and safety standards, occupational health and safety standards for offshore petroleum work as operations, and this bill is intended also to help with health provisions, and I did say that the NDP would support this. However, the bill does not respect recommendation number 29 of the Commission on the Helicopter Safety Inquiry, rather. And as you know, with the Cougar helicopter crash in the region, people were very concerned. There was an investigation, and that investigation, which was chaired by the Honourable Robert Wells, and C5 doesn't provide for the creation of an independent safety regulator. I mentioned the colleagues earlier who did such excellent work, and I have colleagues who are much more well aware of all of this than I am. They've explained the importance of this to workers and the concerns that we have for their health and safety at work, including the health and safety of the helicopter pilots, as much as the people who are working on the teams. And as a result, I'm sorry that they haven't included this recommendation for the new independent safety regulator, nor another for the creation of an autonomous safety division within the Petroleum Board, because it could have been done, and they could have also included this 5-year review. As I mentioned earlier, they should have provided for this independent offshore board safety division. So I don't know why the Conservatives are so bent on always controlling everything and managing everything from within their own offices, whereas we could have an independent regulatory entity that would ensure that there is better health and safety for our workers. We know that these people are having problems. They do work that is dangerous. These are people who are very courageous, they're professionals, and they do excellent work in their regions. They work hard to take care of their families, but we have to worry about their health, occupational health and safety. So this bill, while it's a step in the right direction, does not allow for that 5-year review, and that it could also have provided for the creation of this independent and standalone regulator. That's unfortunate. While the government is refusing to implement recommendation number 29 from the Wells report, the bill, C5, is a constructive improvement, despite everything else, as I've said, and it is necessary. It's better than the current occupational health and safety regime for offshore workers because it enshrines certain new aspects into the law. And so the NDP is very proud to support C5. We've been asking for this system for years, as I mentioned, and this is a bill that took a long time to land here. In fact, it's been almost 13 years that we've been asking for this bill to move forward and be implemented. And unfortunately, there were tremendous delays. I'd also like to mention that for us, it's very much of concern that out of all this work, it's not done often enough in cooperation with the provincial governments. It's important for us that the federal government respect the provincial counterparts, whether it's in health, and currently I think about the health accords. Unfortunately, the federal government is imposing new ways of doing things in the health sector without the provincial health ministers being involved, and that's a very bad practice. Here, at least, there was an agreement with their provincial counterparts, and it's a good thing that should happen all the time. And I see, Mr. Speaker, that you're telling me that my time is already up, but I'd like to thank you very much, Mr. Speaker, and I'm now ready to answer any questions. Thank you.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Natural Resources.
Thank you very much, Mr. Speaker. I think it bears repeating that both provinces have already given assent to their respective bills to enact these changes, and that they are very patiently waiting for C5 to pass through our Parliament and for this regime to come into force. The member has suggested that amendments were brought forward, and I'm wondering if he understands that by bringing forward amendments of this nature, this would have actually meant a delay in bringing this bill forward, because we would have had to go back to the provinces. It would have left our workers yet again without the extra safety measures that Bill C5 proposes, and I'm wondering if he would like to speak to that.
The Honourable Member for Drummond. Mr. Speaker, as I mentioned at the beginning of my speech, I'm not a specialist on this issue. However, I know excellent members of Parliament who are, and who are the representatives of these regions, and I will give you their names. There's the member for St. John's South Mount Pearl, the member for St. John's East. These are members who defend their communities and who know very well what needs to be done to improve this bill. If they tell me that it's a good amendment and that they had a good agreement with provincial counterparts, and if the federal government would sit down a little more often with those provincial counterparts, they would understand that it's easy, if you take the time to sit down and negotiate with them, that the agreements can easily be arrived at. So my honourable colleagues who sat on the committee are the experts in the field. They've worked very hard, and they know who their counterparts are at the provincial level. I'm happy to support Bill 5 because it was necessary that we have this bill that has been lagging for 13 years.
Questions and comments? The Honourable Member for Winnipeg North.
Mr. Speaker, I think it is important that we recognize that offshore workers do work in very difficult situations. And there is no doubt, it was interesting you had the government member from Saskatoon make reference to the fact that the federal government is now acting on this because of 2 provincial jurisdictions. You know, one of the things that we need to acknowledge, when it does come to occupational health and safety, this government is often found lacking in terms of being proactive. But in regards to this legislation, as the Liberal critic has talked about, is that it is important, it is a step forward, it is something, in fact, we do support. At the end of the day, we want to have working environments for all workers, especially, you know, those in the offshore, when we have the provincial governments that have actually led the way and now are asking for the federal legislation to pass, that we do what we can, acknowledge that, yes, it has fallen short in certain areas, but it is important that ultimately we see the bill pass. This is something in which the workers deserve, and the provinces have been, 2 provinces have been waiting patiently for. I wonder if the member might want to pick up on the fact that this is in fact being driven from a provincial agenda as opposed to the national conservative agenda here in Ottawa.
The Honourable Member for Drummond. Well, I'd like to thank my colleague from Winnipeg North, who clearly explained the situation. Earlier on, my Conservative colleague was mentioning that indeed that it was thanks to her that this bill has moved forward, whereas it's the contrary. We saw the Conservatives time and time again imposing decisions rather than sitting down to work alongside their colleagues from the provinces. When the NDP will be in power, it's absolutely clear and certain that that will be our priority, to sit down with our provincial counterparts and also with our counterparts from the First Nations, to be able to work with them for the good of Canadians. And so you mustn't think that we have the absolute truth, as the Conservatives unfortunately seem to believe. the contrary. We must sit down with our counterparts from the provinces and from the First Nations so that we can move these issues forward. I was saying earlier that in health and in the environment, we have examples of tremendous concern because the Conservatives are imposing decisions rather than working along with their colleagues. Thank you, Mr. Speaker.
The time for government orders has expired. Déclaration de députés, statements by members. The Honourable Member for Edmonton St. Albert.
Thank you, Mr. Speaker. Mr. Speaker, the Trans-Pacific Partnership is a comprehensive 21st century free trade agreement with the objective of resolving trade disputes and promoting regional economic growth. Both Canada and our friends in Taiwan have played active roles in the economic and trade development of the Asia-Pacific region. In fact, Taiwan is Canada's fourth largest export market in Asia. As Canada moves towards formal entrance into the Trans-Pacific Partnership, it becomes evident that Canada would greatly benefit should Taiwan also gain a seat at the table. Given the depth and breadth of Taiwan's trading investment relationships with Asia-Pacific economies, their inclusion, Mr. Speaker, would increase the agreement's international profile as well as its commercial significance. It is in Canada's interest to gain greater access to Taiwanese markets for our exports and also to ensure that Taiwan is not excluded from the benefits of broader regional trade liberalization, which could distort supply chains, creating new barriers to business. Mr. Speaker, Taiwan, like Canada, is a free trading nation, and both would make welcome additions to the Trans-Pacific Partnership. Thank you, Mr. Speaker.
The Honourable Member for Brandon Souris.
Mr. Speaker, I rise to congratulate the recipients of the 131st Brandon Chamber of Commerce Scale of Business Awards held on March the 20th. Small businesses are the backbone of the Canadian economy, and Brandon Souris is no different. Southwestern Manitoba is known for our entrepreneurial spirit. And our local small businesses have a proven record of giving back to the community. I am honored today to publicly congratulate the recipients of this year's awards. Doug Murray is Brandon's Business Person of the Year. Bernie Crisp is the recipient of the Community Service Award. Jeff Crystal is the recipient of the Lifetime Business Builder Award. The PAW Resort and Wellness Center is Brandon's new outstanding business. And Balin Industries is the recipient of the Business Excellence Award. I also want to thank the Brandon Chamber of Commerce for putting on a successful event and to all of the small business owners across the country who work hard day in and day out. On behalf of all members of this House, thank you to all small business persons for everything that you do and for being pillars in our communities.
The Honourable Member for Windsor West.
Mr. Speaker, the Paul Martin Senior Building, a federal asset with heritage designation located in the heart of Windsor's downtown, has been allowed by this government to fall into an unacceptable and unsafe state of disrepair. After deliberately misleading my community through her spokesperson and attacking me personally for raising this issue, the minister has finally come clean, admitting that through her government's lack of stewardship, they have allowed this heritage building to deteriorate to the point where it could seriously injure or kill pedestrians. The government's management of this asset has been publicly referred to as, quote, a story of neglect. Others in my community now consider the Conservative government, quote, a slumlord. And now the Conservatives indicate that demolition of this heritage building is a serious consideration despite the city proposing an affordable way forward that would have significantly enriched our downtown. This is a shameful and abject dereliction of their duty, Mr. Speaker, and I urge the government to go back to the drawing board and work toward a solution that preserves rather than destroys a piece of our community. The Conservatives have created their own very own heritage moment. What they need to do is respect Canadian heritage.
The Honourable Member for Kootenay, Columbia.
Mr. Speaker, a remarkable young Canadian from Kimberley, BC, has shown how you can persevere after a life-changing moment. In March 2004, Josh Stewart attempted a front flip, which ended badly, severing his spinal cord and breaking his neck. Most people would have given up, but not Josh. Faced with paralysis from the waist down, he took the challenge head-on and continued with his skiing career.
Right on.
In just 6 short years, Josh competed at the Vancouver Paralympics, coming away with a silver medal, and most recently a gold and silver medal in Sochi.
Right.
Being named the closing ceremony flag bearing for Canada in Sochi is a testament to his dedication and commitment, not only to his sport, but his lust for life and that never giving up attitude. Au nom de tous les Canadiens.
On behalf of all Canadians, and especially those in Kimberley, British Columbia, congratulations, Josh. You are a true inspiration.
The Honourable Member for Malpeque.
Mr. Speaker, I rise to recognize Marka Rins from Hartsville, PEI, who won silver and bronze medals in biathlon at the 2014 Paralympic Games in Sochi. Mark's competitive spirit and athletic skills are an inspiration to all Canadians. I would also hope we recognize the courage, dedication, hard work, and family support that contributed to Mark's achievements. I remember vividly the day Mark lost his left arm above the elbow in a farming accident at age 7. Courageously, he used his experience to teach others about farm safety and worked with the War Amps as a junior counsellor. Pursuing his love for sport and competition, in fact, he and his whole family competed in biathlon events at Brookvale Ski Park. He achieved the Duke of Edinburgh Gold Award and over the past 4 years earned over 16 medals, including the World Championship. On behalf of this House, we offer our sincerest congratulations to Marka Rins, a true Canadian inspiration.
The honourable member for Kildonan St. Paul.
Mr. Speaker, March 25th was the anniversary of the adoption of an Act for the Abolition in England over 200 years ago that led to the end of the Atlantic slave trade. However, as we are reminded all too often today, slavery thrives not only throughout the globe, but also right here in Canada through sex trafficking and forced labour. I want to take this opportunity to recognize the survivors, police officers, victim support agencies, and countless volunteers all across our nation who are providing support, raising awareness in their communities, and ultimately bringing freedom to trafficked individuals. Many of these unsung heroes dedicate their personal time and finances well beyond their professional roles. Particularly, I would like to thank all those involved in Operation Northern Spotlight, an anti-trafficking initiative involving over 30 police services and 180 officers and support personnel involved across the country. To the police officers, NGOs, and the survivors, thank you for working relentlessly to abolish modern-day slavery in our nation.
Bravo.
The honourable member for Châteauguay-Saint-Constant. Mr. Speaker, instead of trying to negotiate a new agreement, the Conservatives chose to transfer healthcare costs to the provinces and to turn their backs on the healthcare system, which Canadians hold so dear. As a consequence, waiting times will go up and a lack of access to healthcare will result. New Democrats share a vision of a modern, public and appropriately funded healthcare system. We want to make sure that Canadians can get the care they need regardless of where they live. It's also important that they not be prevented from getting good care or prescription drugs for financial reasons. The NDP's approach is based on cooperative federalism, where the federal government plays a role in prevention, where the patient comes first, and where public investment is maximized. An NDP government would support new agreements which would set better health outcome targets. We recognize provincial jurisdiction in the area of health, and by working with the provinces and the territories, the federal government has to adopt measures to allow all Canadians to live with better health. Thank you very much.
Honourable member for West Vancouver, Sunshine Coast, Sea to Sky Country.
Mr. Speaker, today I rise as an MP, but also as a dad. So Shane, Jake, and Maymay, I hope you're listening. Conservative colleagues and I have been meeting on a regular basis to examine issues relating to substance abuse. Our goal is to get the best information available to make our legislators informed and capable. We're dealing with challenging issues such as the effects of cannabis, recovery from drug abuse, prescription drug misuse, and mental health. Informed and capable legislators are the ingredients of good laws responsive to challenging problems. Problems that continue to weaken our youth, divide our families, hurt our health, and hamper our economy. I'm grateful to constituents and other Canadians who've helped with the symposium, such as Lorinda Strang and Anne-Marie McCullough from Bowen Island's Orchard Recovery Centre, Terry and Ginny Dennehy, staunch advocates for mental health, the Canadian Centre on Substance Abuse, and our Ministers of Health and Public Safety, and the MP for Kootenay, who've been avid participants in this discussion. Mr. Speaker, I commend all involved as these issues are so critical for our youth, such as my children and yours, and Canadians of all ages.
Absolutely. The honourable member for New Brunswick Southwest.
Mr. Speaker, unlike the leader of the third party, our Conservative government knows that budgets do not balance themselves. Waiting for someone else to make the tough choices is not what leadership is about. Constituents from across my riding of New Brunswick Southwest were pleased to hear that after making tough, deliberate choices, next year's federal budget will produce a surplus. By holding down government spending, introducing tax relief measures, and lowering Canada's debt to historic levels, we've accomplished this monumental task. The other party said it could not be done. The other party said we are making the wrong choices. Making responsible choices that benefit hard-working taxpayers and their families is what our government has done and will continue to do. Looking ahead, we're preparing another round of tax relief measures. These new tax-saving measures will benefit hard-working taxpayers, their families, and the Canadian economy.
The honourable member for St. John's East.
Thank you, Mr. Speaker. Mr. Speaker, the recent tragedy at L'Île Verte in Quebec brought home painfully the vulnerability to fire of seniors who reside in personal care homes across the country. And it has renewed calls for improvements to safety standards. This week, the Canadian Association of Fire Chiefs have been on Parliament Hill telling us what we can do to make nursing homes and personal care homes safer. And thankfully, there is something we can do, and that is to install sprinkler systems in all personal care homes. The fire chiefs want the National Fire Code amended to make them mandatory. Some jurisdictions have already done so, Newfoundland and Labrador, Ontario recently, and the City of Vancouver, for example. But a change to the National Fire Code, when it comes up for revision in 2015, will make it a national standard, which, if followed, will save lives. Please join me and the fire chiefs in urging the adoption of this important change, which will make our seniors safer and prevent future tragedies.
The honourable member for Provence.
Mr. Speaker, Canadian seniors have played a central part in building this country. They deserve our support to help them enjoy the best quality of life possible. Our government continues to translate that support into grassroots initiatives such as New Horizons for Seniors program. Last week, I announced funding for 11 community seniors group in my riding of Provence. I had the pleasure of congratulating many of these community leaders in person. Groups from areas such as St. Adolphe, Haddishville, St. Agathe, Morris, St. Jean-Baptiste, Piney, St. Anne, Middleborough, La Broquerie, and Paradise Village will all be receiving funding for their projects. Mr. Speaker, since 2006, the New Horizons for Seniors programs has funded more than 13,000 projects in hundreds of communities across Canada. Our Economic Action Plan 2014 proposes an additional $5 million each and every year for the New Horizons program. Our government is committed to ensuring that the golden years of our seniors are truly golden. With programs like New Horizons for Seniors, we will continue to meet the needs of seniors now and into the future.
Well said. The honourable member for Newton North Delta.
Mr. Speaker, the violent crime rates in my riding are high, and despite numerous pleas to the federal government to put more police on our streets, the only thing we've got in return is more broken promises. Seniors in Surrey, specifically Newton, feel especially vulnerable and are very concerned about their own safety. Recently, the phone calls and visits from worried seniors have increased at my riding office. They are worried about growing instances of violence in our area, beatings in broad daylight, mail theft, and vandalism to Canada Post mailboxes. And now, this government wants them to visit those boxes daily alone to collect their mail. Mr. Speaker, I pledge to seniors in my riding and to all my constituents, I will continue to hold this Conservative government to account for its broken promises for more police and safer streets. Seniors and families in Newton North Delta deserve better. We all do.
The honourable member for Vancouver South.
Mr. Speaker, last night, an action plan to end the work stoppage at Port Metro Vancouver was agreed upon by all parties.
Hear, hear.
Our government is pleased that truckers have agreed to get back to work at Port Metro Vancouver. Our economic prosperity, competitiveness, and ability for our products to reach new markets depends on a well-functioning supply chain. This back-to-work agreement demonstrates all parties' mutual interest in returning to work, returning the port to full operation, and getting Canada's economy back on track. Constituents in my riding of Vancouver South can rest easy, knowing that our government understands the importance of opening the Asian markets and the Asia-Pacific Gateway. This underlines that our investment of $1.4 billion in strategic infrastructure projects like the Gateway helps all Canadian businesses. Mr. Speaker, our government will continue to work with all parties to assure the long-term stability and reliability of the port for the sake of Canada's Asia-Pacific Gateway, prosperity for Canadians, and the continued continued growth of our national economy.
Here,
Thank
here.
you.
The honourable member for Sydney Victoria.
Mr. Speaker, I rise today to celebrate the 21st annual Leah Degas Memorial Kids Against Cancer Hockey Tournament, which took place in Sydney Mines Community Centre. This event was renamed in honour of Leah Degas, who lost her battle to cancer when she was only 9 years old. Leah had been involved in the hockey tournament and has served as the official princess in 2005. This year, 12 teams took place to raise money for the Cape Breton Regional Hospital's Pediatrics Fund. Over $60,000 have been raised for the cancer research and programs over the last 20 years. This event could not happen without the support of Leah's family, the many who provided food, Sydney Mines Forum, the North Sydney Minor Hockey Association, the Sydney Mines District Community Centre, and the many contributors. Mr. Speaker, this tournament serves as a tribute to Leah's life and also helps feed families dealing with cancer. I would ask all members to recognize Leah Degas' hockey tournament to fight cancer.
The honourable member for Red Deer.
Mr. Speaker, yesterday our government brought in legislation to address the rail capacity challenges currently affecting Western Canada after an historic crop yield. Our government is taking immediate action to get grain moving faster through legislation and regulations designed to increase supply chain transparency, strengthen contracts between producers and shippers, and help ensure the entire grain handling and transportation system is working at the top of its capacity. The current challenge also affects more than just farmers. A strong supply chain system is essential so that Canadian shippers can remain competitive in domestic, continental, and offshore markets. Alberta Agriculture Minister Verlin Olson said, "We are pleased that the federal government has brought forward the Fair Rail for Grain Farmers Act, which addresses some of our concerns and will help strengthen rail transportation system performance in the immediate and long term." Thank you, Mr. Speaker.
The honourable member for La Pointe de l'Île. Let's be clear. We know that Kijiji is useful to buy used goods, to buy pets, or even to find a drummer for an Iron Maiden cover band. But the Conservatives decided to use this classified ad site for their employment policy. Not impressive. But they have hundreds of experts whom they could call on to give them information about the job situation in Canada. And yet they have turned to a site which sells used fridges. Are they going to develop housing policy based on classified ads for apartments in Montreal? Find a judge on Craigslist? Once the Kijiji episode was made public, you would think the Conservatives would recognize how ridiculous their approach was. But no, the Conservatives defended the use of Kijiji, which shows that they have no idea of the job situation in Canada. Canadians want a government which is serious about creating jobs and not a government which depends on Kijiji. In 2015, the NDP will manage...
The honourable member for Selkirk Interlake.
Mr. Speaker, we all remember the NDP leader's suspicions when he doubted that the pictures proving Osama bin Laden's death existed. He was very clear on that. I don't think from what I've heard that these pictures exist, he said during an appearance on Power and Politics. However, his party soldiers on with the NDP's legacy of adhering to conspiracy theories. The member for Halifax and deputy leader of the NDP is championing the Truther cause on her website, promoting a 9/11 Truth national tour with Richard Gage. He's advertised as coming to Halifax to share his wealth of knowledge on what actually happened on September 11, 2001. What is that truth the member of Halifax is advertising? That the World Trade Center towers were brought down by internal demolition? In other words, it was an inside job by the U.S. government? Mr. Speaker, this tour is shameful and it's disrespectful to the victims of 9/11.
Oral questions. Questions orales. The honourable member for Halifax.
Mr. Speaker, yesterday the Minister of Democratic Reform stated that Harry Neufeld's report showed that the safeguards designed to protect against voter fraud were violated. Except that today, Neufeld stated that the minister had selectively read and quoted his report. Why does the minister continue to claim that Mr. Neufeld concluded that there were cases of fraud, whereas there is no link between vouching and electoral fraud? The Honourable Minister of Democratic Reform.
What I've done all along, which is to accurately and in context quote Mr. Neufield's own report, and I'll do on page 5 right here. Ensuring voter eligibility through the administration of these special exemption procedures is an expected part of an elections officer's duties. Errors that involve a failure to properly administer these procedures are serious. The courts refer to such serious errors as irregularities, which can result in votes being declared invalid. Mr. Speaker, those are serious problems. They remove, when those safeguards are not followed, they increase the risk that the result can be overturned by a judge. And, Mr. Speaker, we're solving that problem through the Fair Elections Act.
The honourable member for Halifax.
So he's selectively quoting from a report to show that he's not selectively quoting from a report. Yeah, I got that one. Makes sense. Mr. Speaker, Harry Neufeld testified that neither the minister nor his staff ever contacted him. Quote, I was waiting for that call, but it never came. He also said that Conservatives are, quote, tilting the playing field in their direction. Well, the minister repeatedly uses Mr. Neufeld's report to support his unfair actions. So why didn't the minister consult the author of that report?
The Honourable Minister of State for Democratic Reform.
Mr. Speaker, obviously, the best way to consult the author is by reading his report, which is what I'm doing right now. And it shows, for example, on vouching, for example, it's obviously risky to allow someone to vote without any documented ID whatsoever. So there are safeguards. You can only vouch for one person, for example. But the only way we verify whether someone vouches for more than one other voter is to keep records of who did the vouching. But according to Mr. Neufeld's report, there were 45,000 instances where there was no record kept of the voter and the voucher. That removes the safeguard. That is unacceptable. The Fair Elections Act will fix that problem.
The honourable member for Halifax.
Just because they keep repeating it doesn't mean it's going to become true. But let's move on to bizarre Conservative comments about their Kijiji economics. So the employment minister is telling economists that they should stop looking at data and about the labour market and instead only listen to him. So can the minister tell us why he thinks economists, the PBO, and StatsCan all have it wrong, but that he and Kijiji, they've got it right?
The Honourable Minister of Employment.
Well, that's delightful, Mr. Speaker. The reality is that the Canadian labour market, all of the labour market information at an aggregate level indicates that we are not facing a general labour shortage, as I've consistently said. However, every business organization in the country, from the Canadian Chamber of Commerce to the Federation of Independent Business Manufacturers and Exporters, the Restaurant Association, the Information Technology Association of Canada, the Canadian Construction Association, all say that there are very significant sectoral shortages, and this is an issue that we should treat very seriously, Mr. Speaker.
Honourable Member for Saint-Lambert. The incompetence of this government's economic team is monumental. So monumental that the little competence it has left is now being sold for 99 cents on Kijiji, of course. Mr. Speaker, after having admonished the economists of this country, now the so-called Minister of Employment has admitted that none of us really know what's going on in the labour market. So if he doesn't know what's going on in the labour market, then what is he basing his decisions and policies on? The Honourable Minister of Employment. If my colleague had followed my comments, Mr. Speaker, she would know that I said clearly that we do not have a global labour shortage in Canada. There is no proof of that in the figures from Statistics Canada, but that being said, all organisms and employers in Canada have indicated that there are labour shortages in certain specialized trades and regions. That is a very serious problem. We do not have enough information on the labour market, so all partners must do a better job on that. The Honourable Member for Saint-Lambert. Apparently the Conservatives still don't have the answer. What are they going to do next? Consult the psychic Jojo Savard? Mr. Speaker, the Parliamentary Budget Officer says that the government is wrong to base its information on Kijiji data. You can't use a classified ad site to prove that there is a specialized labour shortage. How dare the Minister for Employment contradict the Parliamentary Budget Officer concerning the alleged labour shortage when the Minister admits himself that he doesn't know what's going on in the labour market? The Honourable Minister of Employment. Mr. Speaker, I never said any such thing. I said that no one has a perfect knowledge of what is going on in the labor market, but I did say that we know certain things. We know that there is no general labor shortage in the national labor market, but there are certain shortages in specialized trades and in some regions. That is the reality that has been recognized by organizations and employers in Canada. We have to deal with this firmly. We have made unprecedented investments in labour training in Canada. The Honourable Member for Papineau.
Last fall, when the government introduced grain-by-rail legislation, they rejected all proposed amendments by farmers. Their new legislation to address the grain crisis has been described by the Saskatchewan government and many farmers as, quote, deficient and disappointing. This time, when their legislation goes to committee, will the government commit to listening to farmers' good advice and accepting amendments and improvements?
The Honourable Parliamentary Secretary to the Minister of Agriculture.
Mr. Speaker, let me say that yesterday the Minister of Agriculture and the Minister of Transport, under the leadership of our Prime Minister, delivered important legislation that is decisive in the way that it challenges the rail transportation system to deliver grain to the ports. Mr. Speaker, it establishes minimum volume requirements for grain movement, it strengthens contracts between producers and shippers, and it increases interswitching limits to create more rail competition. Mr. Speaker, this is a good piece of legislation for our Canadian farmers, and I ask the opposition to support it.
The Honourable Member for Papineau.
Mr. Speaker, next Tuesday, the annual budget for the Building Canada Infrastructure Fund will be cut by nearly 90%, putting a hard brake on economic growth for the middle class. My question is not for the Infrastructure Minister to rehash budget talking points from 7 years ago. My question is for the Finance Minister. Will he reverse this 90% cut to the government's core infrastructure program?
The Honourable Parliamentary Secretary to the Minister of Infrastructure.
Mr. Speaker, the Liberals seem to have forgotten how the budget and the estimates process works around here. Here are the facts. We have, over the next decade, over $53 billion to invest in infrastructure. This includes the gas tax fund at $2 billion a year. This includes almost $6 billion from the original Building Canada Fund, which we will continue to invest over the coming year. Lastly, the new Building Canada Fund, to which provinces and municipalities will submit invoices, those expenses will be reflected in subsequent estimates, Mr. Speaker.
The Honourable Member for Papineau.
On Tuesday, the funds under the Building Canada Fund will be cut by close to 90%, which will considerably undermine economic growth for the middle class, and major projects like the widening of the Henri IV autoroute. My question does not go to the Minister of Infrastructure, because he would just come back with his old talking points, but it's for the Minister of Finance. Will he reverse the decision to cut the Building Canada Fund, the government's main program, by 90%?
The Honourable Parliamentary Secretary.
Well, thank you very much, Mr. Speaker. And under that $10 billion provincial and territorial infrastructure fund, applications will be accepted starting this Monday, March the 31st, Mr. Speaker, fulfilling our government's commitment. Here are some of the categories that will be eligible, Mr. Speaker. Highways and major roads, public transit, disaster mitigation infrastructure, innovation infrastructure, which our post-secondary sector is particularly pleased about. Mr. Speaker, these investments will improve our quality of life and enhance our economic...
The Honourable Member for Newton North Delta.
Finding himself in a hole, the Minister of Employment and Social Development just keeps on digging. Yesterday, the Minister said, quote, "None of us know exactly what is going on in the labour market of today." Mr. Speaker, Conservatives use this manufactured labour market data to justify major changes to the temporary foreign worker program. So when exactly did the government stop using factual evidence to set labour policies, and when did they start relying on gut feelings and whatever they found on Kijiji?
The Honourable Minister of Employment.
Well, I'm afraid to disappoint the member by saying that we never have, Mr. Speaker. In all of my speeches and comments on the issue of labour market information, I've said the following, that our LMI system is inadequate. We need better information. That the Statistics Canada data does not support the contention of general labour shortages. That if there were general labour shortages, as some business organizations claim, then wage rates would have gone up faster than inflation since the global downturn, and they haven't. However, we cannot ignore the data being supplied by many industry organizations and sector councils, which indicate very acute skill shortages in particular regions and sectors. Those are the facts reflected by the New Democrats who come over here asking me to bring in temporary foreign workers into their ridings every single day.
The honourable member for Newton North Delta.
Mr. Speaker, let me make it clear. First, the minister admitted he doesn't know what's going on in the labour market. Then he said he thinks economists should spend less time actually looking at facts and more time going out for coffee and meeting people. When will the minister cast aside his ideological blinders and accept the factually correct data from economists, experts, and the PBO?
The Honourable Minister of Employment.
Mr. Speaker, I said no such thing. I said yesterday in the interview which he distorts, as I've said every day in this position, that we do not have a general labour shortage in Canada. That if we did, it would be reflected in higher wages, salaries, and benefits, which is not the evidence. And Mr. Speaker, I've stood up in front of business groups and said that if employers want to keep complaining about general skill shortages, then they should be reflecting that by increasing salaries, wages, benefits, and investments in training. And you know what? The president of the BC Federation of Labour stood up and called me an honorary member of the union fraternity for that comment, Mr. Speaker.
The honourable member for Skeena-Bulkley Valley.
There they go with their big union bosses again, Mr. Speaker. So let's get this straight. The minister spends months trying to justify regressive conservative policies by citing labour market data, and then he says explicitly, and here's the quote, "None of us know exactly what's going on in the labour market today." You don't say, Mr. Speaker. My question is for the finance minister. On budget day, his predecessor said that Canada's job vacancy rate was rising at an alarming rise right now. Experts, economists, the Parliamentary Budget Officer, Statistics Canada have all contradicted this claim. Does the new finance minister stand beside the statements of the previous finance minister?
The Honourable Minister of Employment.
What I said, Mr. Speaker, is that everyone involved in the debate on the labour market should have enough humility to recognize that none of us knows exactly what's happening in the labour market, but we do know this, and I'm continuing to quote, I do know this, that there is no general labour shortage in Canada, but all of the evidence suggests that there are some sectoral and regional skills gaps, Mr. Speaker. That's the reality, and I wish the NDP would realize that it's in all of our interests to dig deep on this and to realize that we need a better training and education system that helps to prepare young Canadians for the jobs of the future. That's why I recently led a successful mission to Europe with the employers and unions on exactly that point.
And the honourable member for Skeena-Bulkley Valley.
I see someone else got promoted to the finance portfolio. I welcome my friend from Calgary to the file. It's clear this government uses made-up facts and hides reports to justify their regressive policy. A story in the press today reveals an internal report by Finance Canada on income splitting. The scheme will cost billions, and the vast majority of families, 85%, will see no benefit whatsoever. So when are the Conservatives going to release this vital report to Canadians, and has the Finance Minister even read it?
The Honourable Minister of Finance.
Thank you again for the welcome. As the Prime Minister said, income splitting was a good policy for Canadian seniors, and it will be a good policy for families. Once the budget is balanced, Next year, the government is committed to greater tax relief for Canadian families. And a result of our low tax plan, the average family is paying $3,400 less than it did in previous years. Shamefully, the NDP has voted against each and every one of these measures.
The Honourable Member for Rimouski-Neigette-Témiscouata-les-Basses. Mr. Speaker, this may explain the former Minister of Finance's dithering on income splitting. We know now that his department is in possession of a 300-page report on the fiscal impact of this measure that it has refused to make public. 2 independent studies have already shown that the cost of this measure will be at least $3 billion. Now, things come in threes, so will the Minister of Finance pledge to make public this report on income splitting? The Honourable Minister of Finance. I understand that I have to repeat what I said. Income splitting is a good policy for seniors, and it will be a good policy for Canadian families. Thanks to our low tax plan, Canadian families, the average Canadian family, now pays close to $3,400 less in taxes than in 2013. The Honourable Member. Mr. Speaker, this question is about the report that his department has on income splitting. If it is a good measure, then he should unveil the report. It's that simple. If he doesn't want to make it public, then probably the report must contradict the fact that income splitting is a good measure, and because it mentions that 85% of families will see no benefit from income splitting. So I'm going to ask this question clearly again. When is he going to make public the department's report on income splitting? The Honourable Minister of Finance. I am going to study all reports that were submitted on the topic, but I must say that our government is focusing on what is important for Canadians: jobs and economic growth. The global economy remains fragile, especially in the United States and Europe, but our economic policies have helped protect Canada with 2 million in net new jobs that have been created since July 2009. Those are the facts, and I don't know why the NDP wants to ignore them.
The honourable member for Toronto Danforth.
Thank you, Mr. Speaker. Mr. Speaker, Harry Neufeld's report is misused constantly by the Democratic Reform Minister to justify C-23's flawed measures. Mr. Neufeld testified today that none of the remedies his report proposed have ever been mentioned by the minister, let alone included in the bill. He also said his report is being wrongly interpreted and unfairly invoked by the minister. He said, quote, "At no point in the report do I link vouching with fraudulent voting." So when will the minister stop distorting the Neufeld report?
The Honourable Parliamentary Secretary.
Mr. Speaker, Mr. Neufeld is entitled to author recommendations. He is not entitled to author the law. That is left to parliamentarians. And at no time did I ever claim to agree with his recommendations. I don't agree with them, and that's why they're not in the bill. But I do agree with the facts that are found in the report, which find 50,000 irregularities linked to vouching in the last election. And, Mr. Speaker, we deal with that problem by ending the process of vouching and making the reasonable request that people bring one of 39 forms of identification that will demonstrate their address and their identity.
Honourable Member for Louis Saint Laurent. This morning we had the opportunity to hear Harry Neufeld on Bill C-23, who organized elections in Canada across the world for over 33 years. His report was misused by the minister to justify part of the bill. But he said word for word, the Minister of Democratic Reform has wrongly interpreted his report. He cited a number of examples where his conclusions were wrongly used. How many reports have been wrongly interpreted by the minister?
The Honourable Minister of State.
Okay, Monsieur le Président.
None, Mr. Speaker. Obviously, according to the Neufeld report, there were over 50,000 voting irregularities linked to vouching, And that is why we have decided that this is not a viable practice and that it should not continue. However, Canadians can choose from among 39 forms of identification that they can use to prove their address and their identity. It is not necessary to show photo ID, but there are numerous other options, and we are telling Elections Canada to inform voters of what identity pieces they can use. The Honourable Member. Once again, between the credibility of Harry Neufeld and that of the Minister of Democratic Reform, I think the choice is clear. Mr. Speaker, Harry Neufeld said that Bill C-23 is going to undermine electoral participation because of the minister's obsession with a problem that exists only in his fertile imagination. Neufeld said there is no link between the vouching system and fraudulent voting. He said voters are not the problem. There's starting to be a whole lot of experts who are opposed to the bill. Is the minister going to listen to them? The Honourable Minister of Democratic Reform.
Vote without any form of documented identification whatsoever. There are obvious risks. That's why there are safeguards. Those are the rules that were associated with vouching in the past. One of them is the elections official has to document who voted and who vouched for them. That prevents the voucher from repeating the vouching more than once in violation of the rules. Unfortunately, in 45,000 cases, according to Elections Canada's own report, there was no documentation. And that documentation is necessary. It is in the rules, and failure to provide it is a violation. Mr. Speaker, that is why we're moving the way we are.
The Honourable Member for Wascana.
Mr. Speaker, the grain crisis in Western Canada is 6 months old. By the government's own calculation, the hit on farmers is $8 billion. The legislation tabled yesterday mostly authorizes regulations to be made which are still secret. There's no comprehensive monitoring, no better transparency, no logistical coordination, no railway costing review, no new capacity, no definition of service levels, no way to measure performance, no damages to farmers when services fail. Why was all of that left out? And when will farmers actually get to see these draft regulations?
The Honourable Parliamentary Secretary of the Minister of Agriculture.
Mr. Speaker, I really wish the member had read the legislation that was tabled in the House yesterday, because by reading it, Mr. Speaker, he would see what this legislation actually sets out to accomplish. I mentioned before, Mr. Speaker, that it will increase supply chain transparency. It will strengthen contractual mechanisms between producers and shippers. And, Mr. Speaker, it's going to help to ensure that the entire grain handling and transportation system is working at its peak efficiency. He should support the bill, Mr. Speaker.
Member for Ottawa South.
Monsieur le Président, au cours de la dernière...
Mr. Speaker, over the past week, we've heard from over 500 Canadians concerning the infrastructure needs in their communities. Quebec citizens want to see Route 185 repaired. In Toronto and southwestern Ontario, dozens of people have called for public transit funding. In Winnipeg, water pipes are freezing underground. Everyone wants to know why the government has deliberately postponed infrastructure spending under the Building Canada Fund to well after the next elections. The Honourable Parliamentary Secretary.
Mr. Speaker, and as I indicated, the application process for the provincial and territorial infrastructure component will open this Monday, March the 31st, fulfilling our government's commitment to be ready for this construction season. Significant investments will continue to flow this year and over the next decade. The largest and the longest infrastructure plan in Canada's history, this government has tripled investments in infrastructure since 2006, Mr. Speaker.
The Honourable Member for Ottawa South.
Mr. Speaker, next week the Building Canada Fund will in fact be slashed by almost 90%, and the Conservatives are trying to deny it. Canadians know that it's nothing more than a shell game. It's just a little card trick designed to meet the Prime Minister's arbitrary deficit deadline of an election. It's what you get with a government that's focused on austerity and cuts, not growth and jobs. Why is the government compromising public services, delaying investment, limiting opportunities for economic growth, and hurting middle-class families?
The Honourable Parliamentary Secretary for Infrastructure.
Well, thank you very much, Mr. Speaker. And earlier this week, Mr. Speaker, you had suggested that a question such as this about shell games might be more appropriate in the Ontario legislature, Mr. Speaker. With respect to investments in public infrastructure and in public transit specifically, Mr. Speaker, our government has invested over $5 billion in public transit. Here's what Michael Rocheleau has said. Never before has the federal government invested so much in public transit. This budget provides a solid framework to ensure that this will continue.
The honourable member for Welland.
Mr. Speaker, it's clearer than ever this government doesn't get the seriousness of the grain shipment crisis. We know they're $8 billion short for farmers. They're more than a day late. The Minister's Transport now actually admits this year's crop is not going to get moved before next year's crop. 20 million plus tons on the ground in Saskatchewan, Manitoba and Alberta, and yet the Conservatives' new bill failed to increase the amount they were going to move. No extra grain will get moved beyond what the Order in Council said. Failed to increase fines to make sure that farmers would actually get the money. They've wasted a huge opportunity. Will the minister now go back and really get the legislation right this time? You tried once before, failed miserably. Can you get it right this time?
The honourable parliamentary secretary.
Thank you very much, Mr. Speaker. Clearly, this member does not understand what the legislation is setting out to do. Mr. Speaker, the legislation is tasking the railroad companies to move 1 million metric tons of grain a week from the fields, the Western grain farmer fields, to port. That is almost double what it was just a few weeks ago. Mr. Speaker, this member wants to help Western Canadian grain farmers. He should stand up and he should vote in favour of this legislation.
Honourable member for Betsy-Masconoget. Millions of tons of grain will soon be past its best before date, and the minister continues to tell producers to wait. Mr. Speaker, the Conservatives don't seem to appreciate the scope of the problem. Grain producers are losing billions of dollars, and our trade partners are losing confidence. Businesses across Canada and Quebec are grappling with shortages of grain. No grain, no bread, no croissants. What are we going to eat for breakfast? Why don't they increase the amount of grain that could be shipped? Honourable Parliamentary Secretary.
In this legislation obliges the rail companies to move 1 million metric tons of grain a week. That is an ambitious but realistic target. Mr. Speaker, I would ask this member to consult with stakeholders in the West and that are trying to move their grain. For example, I have a quote here from Greg Cherwick, the chairman of Pulse Canada. This fast-tracked approach allows us to focus our efforts to get to work and to immediately put in place the framework that encourages effective agreements that offer more balanced accountability and ultimately more predictable and reliable service. Mr. Speaker, they need to better understand farmers. They need to stand up and support this legislation.
The honourable member for Rosemont-la-Petite-Patrie. Personal data breaches for 600,000 Canadians, 2,983 cases of personal data breaches at the CRA alone. And what is their solution? Nothing. Mr. Speaker, we have another worrisome case dealing with the theft of a laptop in 2012 containing medical and legal cases or files. The thief is now trying to blackmail the lawyer from the Indian Residential's Adjudication Secretariat, and the Privacy Commissioner now only learned about it this week, 2 years later. What is the blackmailer asking for, and what are the Conservatives going to do? Honourable Parliamentary Secretary.
Mr. Speaker, we agree that Canadians should rightfully expect their personal information to be protected. The CRA has a close working relationship with the Office of the Privacy Commissioner and acts on all her recommendations. I would clarify, because the member has brought it up, that 95% of the reported privacy issues are related to misdirected mail. CRA handles nearly 150 million pieces of mail each year. Therefore, these incidents represent 0.001%. The member opposite knows this and should recognize that it is irresponsible to misrepresent this record.
The honourable member for Timmins James Bay.
Mr. Speaker, that's not what the facts said at all about the fact that data is being lost at CRA. Now, last year, they lost the financial information of 500,000 Canadians. Whoa. Now we find there's over 3,000 cases at CRA, and in only 1% did they even bother to let the Privacy Commissioner know. That lackadaisical attitude towards the financial information of Canadians, it's simply not acceptable. So the Democrats say every time people's data is taken, stolen, or hacked, the Privacy Commissioner needs to be told. Will the government support this common sense solution?
The Honourable Minister of National Revenue.
Mr. Speaker, we do work with the Privacy Commissioner. We do respect the Privacy Commissioner's recommendations. And again, I think the clarification here is very important. When a global figure was given on privacy breaches, 95% of them had to do with misdirected mail. That's 0.001% of 150 million pieces of mail that the CRA deals with each year. This is something that should not be misrepresented, and it is irresponsible to undermine the confidence of Canadians in a system that works, Mr. Speaker.
The Honourable Member for Niagara West, Glanville.
Mr. Speaker, last year our government announced a tentative deal was in the works to sell McDonald House. This sale represents an important step in our government's plan to consolidate Canada's diplomatic presence in London by revitalizing and renovating the historic Canada House in the heart of London, Trafalgar Square. This consolidation will ensure that Canadians will be better served in one centralized location. Can the Minister of Foreign Affairs please update this House on the sale of McDonald House?
The Honourable Minister of Foreign Affairs.
Speaker. Mr. Speaker, I'm very happy to announce the completion of the sale of our High Commission in Mayfair. We have sold it for $565 million. This is great news for hardworking taxpayers. I want to congratulate our High Commissioner, who's worked to help revitalize Canada House in Trafalgar Square, buy the building beside it, have better headquarters, better visuals, better place for clients to come and get support from Canada's mission there. This is good news for the Canadian taxpayer and great news for our diplomats in London.
The Honourable Member for Vancouver East.
Mr. Speaker, once, a long time ago, Conservatives promised Canadians a patient wait times guarantee. But what Canadians got were longer wait times.
Shame.
I don't usually quote them, but the Fraser Institute reported that wait times cost our economy over $1 billion annually.
Whoa.
So why have Conservatives cut $250 million a year that was earmarked for the provinces to help reduce wait times? Why are they giving up on ensuring timely access to medical care? Do they not care anymore?
Hear, hear. The Honourable Minister of Health.
Mr. Speaker, what a lot of think tanks that deal with the issue of public health policy also say, and I know that has been quoted from the Fraser Institute, is that more money is not going to make a difference. When it comes to the inefficiencies in our healthcare system, we are investing record amounts of funding to the provinces and territories. We need to work with them on innovative ideas, better models of care, but Mr. Speaker, more money is not going to make a difference.
The Honourable Member for Chicoutimi-Lefjar. However, more competence would make a difference. Wait times are longer in 2014 than in 2004, the year that the agreements were signed, the accords. The cost is being borne by Canadians who are ill and their families. Monday, the Conservatives are going to make official the reduction in funding for Health Canada. I've asked the question 3 times this week. Why does the government refuse to work with the provinces to help Canadians have access to medical care in a reasonable time? Honourable Minister of Health.
Speaker, I would give more kudos to the provinces than the member opposite does. They are working very hard on a lot of the difficulties faced and the inefficiencies in our health delivery system in the provinces and territories. But, Mr. Speaker, many of them also know they're already at close to 40 to 50% of their budgets for health care. They are looking within their systems for efficiencies. They are looking for innovation, and we're working to support them on that.
Hear, hear. The Honourable Member for Trois-Rivières. Mr. Speaker, when I hear the Conservatives' answers, I feel like I'm hearing the same tone as millions of Canadians saying, your call is important to us, but they don't get any answer. Wait times have been waiting for a long time at EI as well. In 2012, Quebecers waited more than 39 days rather than 28 just for their application to be processed. That's not even to have a check. It's just to get an answer. Does the minister realize that his cutbacks to services and benefits is really hurting Canadians? The Honourable Minister. Mr. Speaker, I don't think that such things should be said because it's not fair. I confirmed yesterday that 69% of applicants for EI benefits receive their benefits within the 28-day time frame. We must do better, and we will. My parliamentary secretary is carrying out a study on how we can improve the efficiency of our operations to better serve Canadians.
Hey, Mr. Speaker, yesterday the minister, in response to one of my questions, he said that EI claimants receive a check within 28 days, and yet his own government has admitted that applications aren't completed within the standard processing times. In fact, since 2011, almost 1.4 million Canadians waited more than 28 days for a decision on their claim. Mr. Speaker, why is this okay with the minister? Why is it okay for Canadians to wait nearly 7 weeks for a check?
The Honourable Minister of Social Development.
Mr. Speaker, try as he might, he'll never be able to shout as loud as the member from Katie Bathurst. Mr. Speaker, in point of fact, I'm not satisfied with the service. We have to do better. The service standard we aim for is for 80% of EI applicants to get their first check within 28 days. Right now we're at 69%. We need to do better. I have my parliamentary secretary leading a study with Service Canada and my department of how we can improve operational efficiency to meet that 80% benchmark.
Honourable member for Charlottetown.
Mr. Speaker, can the government explain how, in an alleged period of austerity that since 2006 the government has spent more than $482 million, almost $500 million, on outside lawyers? Lots of cuts to public servants, cuts to social programs, cuts to EI, cuts to veterans, cuts to railway safety, cuts to health care for retired workers, cuts to infrastructure, but lots of money for legal fees. How can the government defend such outrageous expenditure while real people suffer?
The Honourable Parliamentary Secretary to the Minister of Justice.
Mr. Speaker, it's worth noting that while the government at any given time is involved in some 50,000 litigation cases, about 85% of those are not initiated by us. I would also note for the honourable member's case, last year we were successful in nearly 75% of those cases. Wow. We have instituted several efficiencies in the Department of Justice, and they're already having an effect. The number of hours of litigation files decreased by 2% last year. We remain committed to defending the rights of Canadians and to ensuring that hard-earned tax dollars are efficiently spent effectively, Mr. Speaker.
The honourable member for Etobicoke North.
Speaker, yesterday the Minister of Immigration refused to rule out the ridiculous idea of imposing language requirements on the spousal sponsorship program when questioned by my colleague from Markham Unionville. Aside from criminality or age, the state should not impose conditions on who Canadians can marry and bring to this country. This harmful policy will only serve to keep families apart. Will the minister now clearly commit to not imposing this draconian requirement?
Simple question.
The Honourable Minister of Immigration.
No, Mr. Speaker, we have no intention of imposing language requirements for spouses. But we will continue to study these issues, to hear from Canadians, and it's irresponsible of the Liberal Party, we hear this almost every day from them, to hear back about a comment at a roundtable and then suddenly fearmonger with Canadians about an important issue. What we're trying to do here, Mr. Speaker, is protect women from violence in the immigration system. Do the Liberals have any idea what the issues are on that front? And will the member opposite agree that there are barbaric practices that should be called just that, which their leader still refuses to do?
The honourable member for Portneuf-Jacques-Cartier. Honourable member for Portneuf-Jacques-Cartier. Mr. Speaker, we learned this morning that the Canadian forces had no psychologists on the ground in Afghanistan. The soldiers had to go to the American Army for psychological help. It was therefore impossible for Francophones to consult a psychologist in their mother tongue. While on mission, soldiers face incredible stress levels. Psychological help in their own language is essential to prevent post-traumatic stress. Can the Minister of National Defense explain to us why no psychological aid was available in French in Afghanistan? Minister of National Defense.
That unprecedented investments and commitment were made to our men and women in uniform in Afghanistan, Mr. Speaker. We hired more health care workers, unprecedented investment, Mr. Speaker. And I can assure the honourable member, all members of the House, that the well-being of our men and women in uniform will continue to be a priority with this government.
The honourable member for Portneuf-Jacques-Cartier. It's shameful. Respecting official languages is not an option, it's the law. If psychological help is not available at the moment where soldiers need it, it can have very serious consequences. The men and women who serve their countries deserve respect and services. National Defense itself recognized that relying on the Americans was not a long-term solution and that it posed cultural and linguistic challenges. Despite all of that, they didn't do anything while there were urgent needs. What does the minister intend to do concretely to ensure that this shameful situation never occurs again? The Honourable Minister of National Defence.
National Defence and those who work within the department and within our armed forces are absolutely committed to making sure that the men and women who needed help in Afghanistan and within the armed forces get it as soon as possible, Mr. Speaker. There have been unprecedented investments and efforts in this area, and that will continue under this government, Mr. Speaker.
The honourable member for Wild Rose.
Mr. Speaker, my question is for the Minister of State for Democratic Reform regarding the Fair Elections Act and how it will protect taxpayers from partisan abuse of their tax dollars. This is very important to all Canadian taxpayers, as there have recently been alarming reports about possible violations of the Elections Act by sitting NDP MPs. Can the Minister please explain how the Fair Elections Act will protect taxpayers from these kinds of abuses that we've seen from the NDP?
Great question.
The Honourable Minister of State for Democratic Reform.
Mr. Speaker, of course, this is not the first time the NDP has broken the law. They accepted $340,000 in illegal union money, which is an offence under the Elections Act. And I think they thought they could get away with it again when they employed parliamentary resources, which may ultimately have pushed them over the spending limit in key by-elections, another offence under the Act. Additionally, Mr. Speaker, the Fair Elections Act will create new and tougher financial penalties for parties that exceed their spending limit, and that will hopefully root out some of the abuses for which the NDP has become so well known.
The honourable member for Malpeque.
Mr. Speaker, the Minister of Public Safety has a responsibility to ensure Canada's laws are maintained. However, Blacklock's reported this morning that the Canada Border Services Agency issued a directive entitled Export Program Examination Priorities, stating in part that, due to the limited number of resources available for export examinations, outbound smuggling of narcotics shall not be undertaken. End of quote. The Minister must accept responsibility for this directive. Why is the Minister not only condoning but actually authorizing the illegal movement of narcotics across the border?
The Honourable Minister of Public Safety.
Well, Mr. Speaker, I welcome the question from the member. You know, I'm proud to inform the member that we have increased indeed the number of border service officers so that they can provide a better service. They can make sure that our frontier is open for trade and commerce and closed for any illegal activity. And I'll be welcome to get back to the member on that particular point. Thank you.
Honourable Member for Hochelaga. Mr. Speaker, the renewal of the Homelessness Partnership Strategies budget comes into effect next Tuesday. It took 1 year before they announced the new criteria. Obviously, this delayed the negotiation process, and now this is going to result in interruptions in service. Organizations that help the homeless are laying off their employees and dismantling services to the most vulnerable citizens. Can the Minister tell us how many organizations will be affected and what he's going to do to correct the situation?
Honourable Minister of State for Social Development.
Thank you very much, Mr. Speaker. Well, that member is absolutely wrong. We are very proud of our renewed homelessness partnering strategy with the focus on housing first. And in fact, Mr. Speaker, Canada is leading the way when it comes to helping those who are homeless. Mr. Speaker, we are known now throughout the world for what we are doing because of the At-Home Chez Soi pilot project, and from that, the Housing First initiative. Mr. Speaker, we're looking forward to working with community entities and with the communities who know best where these funds can be directed. Mr. Speaker, our government takes real action to help those who are vulnerable.
The honourable member for Yellowhead.
Well, Mr. Speaker, last year was a record year on the prairies for the harvest, almost 50% higher than the average, which was amazing. Grain prices internationally were also very high, so the commodity price was high, so it should have been a wonderful news for the prairie farmers. Unfortunately, we have a bottleneck with the railways. The minister actually briefed the opposition on what we're going to do to fix it, and next time I'm going to ask him to use bigger pictures and smaller or less print so that they can really get it. So I'd ask the parliamentary secretary if he would stand and explain one more time to the opposition in this House exactly what we're going to do for prairie farmers.
The honourable parliamentary secretary and the Minister of Agriculture.
Thank you very much, Mr. Speaker. I'd like to thank the member from Yellowhead for his excellent question, but also for his involvement in the implementation of practical solutions. Mr. Speaker, Canadian farmers rely on the rail system to get their crops to market in a predictable and timely manner, and that's why our government is taking concrete action to get grain moving faster. Yesterday, we introduced decisive legislation, Mr. Speaker, to establish minimum volume requirements for the movement of grain, to strengthen contractual mechanisms between producers and shippers, and to increase interswitching limits to create more rail competition and efficiency. Mr. Speaker, I know my colleague supports this legislation. I ask the opposition members to get on the side of farmers to move this legislation quickly.
The honourable member for Squamish.
Mr. Speaker, I recently met with armoured car drivers who highlighted the dangerous working conditions that they deal with every day. Reductions in crews and a lack of appropriate training and support are threatening the safety of these workers and the public. We've sadly seen this in recent deaths and injuries in armoured car robberies and public shootouts in Edmonton, Toronto and Longueuil. So far, the Minister of Public Safety has remained silent when this is clearly his responsibility. Will the Minister now agree to a national task force to investigate the deteriorating working conditions for armoured car drivers before another tragedy takes place?
Great idea. The Honourable Minister of Public Safety.
Mr. Speaker, you know, what's important in life is to understand what our responsibilities are. And if my colleague wants to deal with that issue, well, I invite him to speak to the provinces because it's under their jurisdiction. Thank you.
Member for Saanich Gulf Islands.
Mr. Speaker, this is a question about math and red herrings. Yesterday, the minister said our greenhouse gases would be 130 megatons less than what they would have been under the Liberals. Now, that is actually a number picked out of the air that's known as the business-as-usual target. Here's the math. The Copenhagen pledge made by this Prime Minister, no previous Prime Minister, was to reduce 17% below 2005 levels by 2020. Environment Canada now says by 2020 emission levels will be virtually unchanged. The question, is Canada still committed to the Copenhagen target? And secondly, why does this minister seem to believe that business as usual is government under some other party?
The Honourable Minister of the Environment.
Mr. Speaker, our government is taking action to address climate change. Since 2006, we have invested more than $10 billion in green infrastructure, energy efficiency, adaptation, cleaner technology and cleaner fuels. Thanks to our actions, again, carbon emissions will go down by 130 megatons from what they would have been under the Liberal government. And we are accomplishing this without the Liberal and NDP carbon tax, which would raise the price of everything. Thank you, Mr. Speaker.
That concludes question period for today. The Chair has a notice of point of order for the Honourable Member for Timmins James Bay. Yes? Okay. The Honourable Member for Timmins James Bay.
Mr. Speaker, yes, during question period, the Minister of CRA stated in the House that we were being irresponsible by misrepresenting facts. I'd like to be here to table some documents from her own department that is actually based on the question, because, Mr. Speaker, if we are asking questions in the House based on information, it's not fair to accuse people of misrepresenting hence lines. So I'd like to table the documents.
Does the Honourable Member have the unanimous consent of the House to table? There's no consent. It's another point of order. The Honourable Member for Malpeque is rising on a point of order.
Mr. Speaker, I have here the document I referred to in question period by CBSA. The Minister obviously seems to be unaware of that document. Could I gain unanimous consent to table it in both official languages?
Does the Honourable Member for Malpeque have the unanimous consent of the House to table these documents? No. There isn't. Is this a point of order as well? Hi. The Honourable Member for St. Paul's.
Mr. Speaker, on Tuesday, the Minister of Health misled this House by stating that the Public Health Agency had come into force under this government. I offered her 3 times to correct herself, and I am asking her to stand in this.
It seems like a point of debate. I didn't hear and ask, like others, to table documents. So I don't think there's a point of order. Now I see the Honourable Minister of Health is rising on a point of order.
Mr. Speaker, for peace on this end of the House, I am the Public Health Agency of Canada was created in 2004. The remarks I made was just to be proud of the fact that it was the Conservative Party of Canada that brought it into being as a legal entity and passed the Public Health Agency of Canada Act.
These are I think these types of points would be much better raised as questions in question periods, and then these types of responses can be made as responses during question period, but not through points of order or the seeking of consent to table documents. But anyway, the Honourable Opposition House Leader will have his inaugural Thursday question.
Merci beaucoup. Thank you very much. Thank you very much, Mr. Speaker. I'm pleased to take on the role of House Leader. And of course, Mr. Speaker, I'm delighted to be working with you and the clerk and the government House Leader, and of course the third party's House Leader. You have to show great respect for parliamentary tradition, so that I hope in the months to come respect will be shown, because it's so important to people, to Canadians. They want to see a smooth-running Parliament that respects traditions.
Few days on the job, I could see when you look at this current government, they don't seem to have a lot of respect for parliamentary functions. And unfortunately, this week we had coming up to now the 60th time with closure or time allocation, stopping debate. Now, Mr. Speaker, some Conservatives are proud of that, but the reality is last week we had the Supreme Court reject 2 bills from this government. So ramming this legislation through, Mr. Speaker, doesn't mean that it's better legislation. It means that it's worse legislation. And as we see from the Supreme Court, we've now had 2 rejections of legislation brought forward by this government. Now, we have a Budget Implementation Act that's on notice. And my question to the government House Leader is the following. Will there be any legislative mistakes tabled next week in the Budget Implementation Act? And have they actually checked this bill against the Constitution, which should be governing our actions in the House of Commons? Thank you very much.
The Honourable Government House Leader.
Thank you very much, Mr. Speaker. And I first want to say in here what I had said on Twitter last week, and that is I'd like to thank the Honourable Member for Skeena-Bulkley Valley for the working relationship that we enjoyed over the last couple of years, and I wish him well with his new critic responsibilities. Now let me thank the Honourable Member for Burnaby New Westminster for his first Thursday question. I welcome the Honourable Member to his new role as the House Leader for the Official Opposition. I have been told by my staff that he is the 10th House Leader from across the aisle that I've had the pleasure of working with. Now, while I am confident that his predecessor has briefed him on our government's approach to facilitating a hard-working, productive and orderly House of Commons, Mr. Speaker, I see that he has already fallen into one of the grievous errors of his predecessor, and I would encourage him, for a whole bunch of reasons, I would encourage him to look at some detail, at this House of Commons rules and procedures. For example, he was concerned with time allocation and referred to it again as limiting debate. Yet when he reviews the rules, as I know he's going to, I know he will do that with some enthusiasm in the near term, he will notice citation 533 of Beauchesne's Parliamentary Rules and Forms, 6th edition, which reminds us that, quote, time allocation is a device for planning the use of time during the various stages of consideration of a bill rather than bringing the debate to an immediate conclusion, end quote. And that is what we have always tried to do here, schedule debates so that we can make decisions, have fair and adequate debate, but actually give members of Parliament an opportunity to decide questions. It is not to curtail debate, it is to schedule and facilitate decisions being made. And I hope that he will have regard for those rules, something that had escaped his predecessor. But I should say I do look forward to working with him on our business in the future. And that said, I hope that he won't take personal offense to this. But in our scheduling of these matters, we will continue to work off of the Gregorian calendar, not the Julian calendar. Aujourd'hui, nous allons poursuivre.
Today we will continue the third reading debate on Bill C-5, the Offshore Health and Safety Act. Tomorrow we'll start second reading debate on Vanessa's Law, Bill C-17, the Protecting Canadians from Unsafe Drugs Act. On Monday, Mr. Speaker, we'll see the third day of second reading debate on Bill C-20, the Canada-Honduras Economic Growth and Prosperity Act.
Tuesday, April 1st, shall be the first allotted day. It being April 1st, after all, I assume that the NDP will ask us to debate one of their economic policies. Finally, starting on Wednesday, we will debate our spring budget implementation bill to enact many of the important measures contained in Economic Action Plan 2014, our low-tax plan for Canadians as we make further progress on balancing the budget in 2015. I might also add that Bill C-30 is now before this House regarding the grain situation. There have been very positive discussions among the parties to date, and I hope that they will lead further to a position where we might be able to have that bill pass through at least second reading on a fairly constructive basis. I hope those discussions will yield fruit, in which case there might be some change to the schedule I have presented to the House today. Thank you very much, Mr. Speaker.
I have the honour to inform the House that messages have been received from the Senate informing this House that the Senate has passed the following bills. C-28, loi portant
C-28, an act to grant certain votes.
To Her Majesty certain sums of money for the Federal Public Administration for the financial year ending March 31st, 2015. Je suis maintenant prêt.
I'm now ready to rule on the question of privilege raised on March 24th, 2014 by the Honourable Member for Notre-Dame-de-Grâce-Lachine regarding recent advertisements issued by the Honourable Member for Westmount Ville-Marie.
Raising the question, as well as the Honourable House Leader for the official opposition, the Honourable Members for Beausejour and for Westmount Ville-Marie for their interventions on this matter. Le 24 mars.
On March 24th, the Honourable Member for Notre-Dame-de-Grâce-Lachine explained that recently advertisements were published in local newspapers by the Honourable Member for Westmount Ville-Marie, inviting readers to meet with him at a public discussion of their concerns. She noted that the invitation covered not only his riding of Westmount Ville-Marie, but also her riding of Notre-Dame-de-Grâce-Lachine and the riding of Montreal West. The member went on to contend that this invitation was an implicit attempt by the member for Westmount Ville-Marie to present himself as the Member of Parliament for Notre-Dame-de-Grâce and Montreal West, and that the advertisement interfered with her work as a Member of Parliament in her riding. Furthermore, she argued that she viewed the advertisement as a means to target future voters, which breaches House rules prohibiting the use of House resources for election purposes.
In response, the member for Westmount Ville-Marie questioned the member's claim that he had misrepresented himself to others, noting that, in fact, the newspaper in question, the NDG Free Press, is distributed in both ridings, and he had very clearly indicated in the advertisement which riding he represents. He also held that, since their ridings are adjacent and therefore share common preoccupations, it was entirely acceptable to invite all citizens to discuss common priorities. As all members know, to declare a matter to be a prima facie case of privilege, it is essential to demonstrate precisely how a member has been prevented from fulfilling his or her parliamentary duties. Ainsi, quand le mention dans l'ouvrage d'O'Brien et Bosque.
O'Brien and Bosque states at page 109 that, and I quote, In order to find a prima facie breach of privilege, the Speaker must be satisfied that there is evidence to support the member's claim that he or she has been impeded in the performance of his or her parliamentary functions and that the matter is directly related to a proceeding in Parliament, unquote.
A Speaker Milliken ruling from 2004 has been touted as a relevant precedent in this case. On closer examination, however, members will find that Speaker Milliken's decision in that case hinged on an issue of false misrepresentation. Dans l'affaire qui nous occupe.
In this case, however, I have carefully reviewed the advertisement in question, and I see that the advertisement makes it perfectly clear that the invitation is being issued by the member for Westmount-Ville-Marie. Indeed, the member for Notre-Dame-de-Grâce-Lachine herself acknowledged that the member for Westmount-Ville-Marie did not actually misrepresent himself as the member for Notre-Dame-de-Grâce-Lachine. She also stated that, and I quote, working on community relations in one's own riding and outside of it is certainly part of a political representative's job, unquote. Members, and indeed all Canadians, will recognize the truth and significance of that statement, as did the member for Westmount-Ville-Marie when he stated that, quote, the interests of our constituents should be our common priority, unquote.
You will know that it is not at all unusual for members not only to communicate with, but also to visit the constituents of their colleagues. For example, just a few weeks ago, her colleague, the member for Welland, happened to visit the town of Raymore in my own constituency of Regina Capel, where he participated in a town hall meeting with local citizens. This speaks to members' attempts to work within, beyond, and across riding boundaries for the greater good. It therefore does not seem reasonable to suggest that merely placing an advertisement inviting readers, some of whom happen to live in a different constituency, to meet a member of Parliament is infringing the rules and somehow ought to constitute a matter of privilege. La présidence n'a...
The Chair could not find any evidence to suggest that any misrepresentations were made, any truths distorted, or any potential confusion created in the minds of voters. And absent such evidence, I cannot conclude that the ability of the member for Notre-Dame-de-Grâce-Lachine has somehow been infringed upon. For these reasons, I cannot conclude that this matter constitutes a prima facie question of privilege.
Attention. Orders of the day, order du jour.
Government bills, Commons, resuming debate at third reading of Bill C5, Offshore Health and Safety Act.
The Honourable Member for Newton North Delta.
Thank you, Mr. Speaker. It's my pleasure today to rise and speak on Bill C5, an act to amend the Canada-Newfoundland Atlantic Accord Implementation Act, the Canada-Nova Scotia Offshore Petroleum Resources and Implementation Act, and other acts, and to provide for certain other measures. When we hear titles like this bill, a very long title as I've just read out, often we're left wondering, what is this bill really about? Well, this bill is actually, I would say, a culmination of a number of attempts to bring about some changes to address safety for workers who work in offshore situations. Rights to refuse unsafe work. Most of us in Canada who work on land just take that for granted. And we shouldn't, because the right to refuse unsafe work has been fought for by workers for many, many years. And we have the labour movement to thank for the advocacy that they have done in this area. And as we have begun to know more and more about occupational health and safety, we know that it's a shared responsibility and that employees have to be integrally involved in developing policies and practices, and then enforcement has to be there as well. So we are pleased that this bill at least begins to address that and gives offshore workers the right to refuse unsafe work. And this result of this piece of legislation has resulted from, I would say, cooperation and collaboration between the partners. And by that, I'm talking about our Atlantic provinces and also by the labour movement as well. And this is where labour movements in Newfoundland, Labrador, and Nova Scotia all worked closely together to make sure that there was protective regimes were being put in place for offshore workers in the oil and gas industry. And for me, it was kind of mind-boggling that this had not existed already, because you would say a worker is a worker. So if a worker is covered when their feet are planted on the ground, why would they not be covered if they're Canadian workers working in offshore situations? And of course, we've had a number of tragic disasters. And those tragic disasters has made us, as a society and as different levels of government and working people, take a look at where our legislation is, where our framework is to protect those who go to work. Offshore workers are like workers everywhere else. They get up in the morning, some of them get up in the evening, they go to work, and they go to work to make a living. And there is every expectation on the part of that worker and the families that they leave at home that they're going to be returning home safely. And I am pleased to see that now our offshore workers, once this legislation is enacted, will have that right to refuse unsafe work. And I am also pleased to state right here in this House that, when we're looking at legislation like this, I'm reminded of the legislation we were debating last night, C-525. And I can actually see direct links there. In C-525, we see a not-so-secretive attack on organized labor or on the ability of workers to organize. And it has taken workers in the offshore industry years and years to get rights that other people have had. And having been a teacher for most of my life, and as a teacher I know how hard it was to get the occupational health and safety framework implemented into the school system and for teachers as workers as well. And I'm also reminded, that there is a kind of, often a disdain by my colleagues across the way for working people who have chosen to be part of a collective called a union. And I'm very proud of the achievements of the union movement. When you go back to the 19th century, Mr. Speaker, and the reason why the unions were founded, it was to provide some balance. It's because workers' lives were in danger. It's when hands were being caught in machines and amputated. It was when young children were being sent into the mines and terrible accidents were occurring. And when people were being forced to work incredibly long hours. It was at that time, out of desperation, that workers decided that singly they could not bring about change, that if they wanted to bring about meaningful change, they had to hold hands and become a collective. And that kind of advocacy for the rights of workers, for a right to a decent living, for the right to work in safe workplaces and to ensure the maximum safety, all those things have been, the union movement is still advocating for today. Not just for themselves, because once they achieve those, it's for all Canadians. And, Mr. Speaker, I know that you would want each and every worker who lives in Canada to have that occupational health and safety protection and the right to refuse unsafe work. And because if we do not have that, that leaves us in a very, very vulnerable position. You know, when I look at this legislation, the overall responsibility for the implementation and carrying out a lot of this legislation is actually put in the hands of the operator. And, you know, I was really pleased to hear that the government had paid some attention, I had hoped, to Recommendation 29 of the Canada, Newfoundland and Labrador Public Inquiry into Offshore Helicopter Safety that was conducted by Honourable Robert Wells. And that inquiry spent a lot of time listening to experts. And as much as I know that my colleagues across the way have an allergy to data science and informed decision and listening to experts, I was quite impressed by the recommendation being put forward by Honourable Wells. And what it really brought home to me is once again that here we are, once again, passing a piece of legislation. Yes, it's a step in the right direction, and yes, it enshrines that right to refuse unsafe work. But at the same time, we're not writing legislation for yesterday. We should be writing legislation that is current today and for tomorrow and for next few years. And as far as Honourable Robert Wells was concerned, he actually puts forward what I would say a fairly reasonable 1-2 option. The best case scenario and the one that would be acceptable if the best case scenario is not taken up by government. And what Honourable Robert Wells wrote was, in Recommendation 19 in June 2010, I believe that the recommendation which follows this explanatory note will be the most important in this entire report. And Recommendation 29 demands a new, independent and standalone safety regulator be established to regulate safety in the CNL offshore. That seems fairly clear. Independent, standalone safety regulator. And then Justice Wells, because he knows what parliamentarians can be like, he wanted to give people a choice, not an ultimatum, not it's this or nothing. He came up with the second option. And what he said is that the alternative option was that the government create a separate autonomous safety division of C-NLOPB with a separate budget, separate leadership, and an organizational structure designed to deal only with safety matters, and establish an advisory board composed of mature, that is often questionable, and experienced persons fully representative of the community and who are unconnected with the oil industry, and ensure that the safety division would have the mandate and ability to engage either on staff or as consultants, expert advisors to assist it in its regulatory tasks. The report explains further that the safety regulator should be separate and independent from all other components of offshore regulation and should stand alone, with safety being its only regulatory task. And, you know, as I said, Mr. Speaker, you know, with a government that has an allergy to data, science, and informed decision-making, what I would say is that this legislation fails to meet either of those standards set out in that particular report. And a report, by the way, that wasn't written overnight, that was well researched, and you know, as I said earlier, it's quite a shame that it didn't get included in here. And I know that we're supporting this piece of legislation because it is moving in the right direction. It is moving in the right direction. But once again, I'm going to make a plea to my colleagues across the way that when this hits, that they amend this report, even now, and change it, and maybe take the time so that it has some life beyond, rather than just providing the absolute minimum in this, though I will say that that is better than nothing. And we, as the NDP, are very, very committed to saying that when we form government, we will continue to work with Nova Scotia and Newfoundland and Labrador, and even before we form government, to further strengthen worker health and safety by working towards the creation of an independent, standalone safety regulator, because that's the right thing to do. But, when I talk about allergy to data and also not listening to the experts, I live in a beautiful riding of Newton North Delta, Mr. Speaker, and unfortunately for us, in my riding, we've had a very high number of homicides, and also some that have really touched members in my community. And once again, when they look at the numbers and see how under-policed we are compared to ridings that surround us, talking about facts and science, it just makes sense that we absolutely need that extra policing on our streets right now. And I have a growing number of members who are becoming very, very disillusioned and saying, how much more information, facts, experiences do we have to share with the decision makers for them to realize that we have a community that needs that support and that additional policing that is required. And, when we're talking about offshore on the East Coast, it also brings home to me that, we have this beautiful geography. We're a country that expands. We don't say from coast to coast. We say from coast to coast to coast. And I can tell you on the West Coast, we're just as concerned about our safety offshore as we are about worker safety on land as well. But we're also very, very concerned about our environment and about the impact on environment of offshore exploration and how we have to make sure that we have rigorous environmental protections in place. And, being a port city, Vancouver, we, of course, recently have experienced for almost a month a work stoppage that had quite an impact on my community. I had businessmen after businessmen coming to tell me about the impact, but I also, Mr. Speaker, actually, I met with the truckers who were also telling me about the impact on them of those terrific wait periods that existed for them, that in 2005, where they could do 5 runs, now they could only do maybe 2, and if they were lucky, they could do 3, and how their income level had gone down, but their expenses had gone way, way up. And just as it has taken the federal government so long to act on this piece of legislation, in a similar way, we saw the federal government, I would say, remiss from not facilitating negotiations, I would say, long before the strike started, because every party realized where the issues were. And it was the government that could have facilitated a much earlier resolution, a negotiated settlement, to ensure that we did not have the economic impacts on both the business community, the transloading companies, as well as the drivers and their families. And I will tell you this, earlier today I heard about the wheat that is backlogging up, and I can tell you in my riding and in my area, we ran out of storage space. And now I'm very, very concerned with those people who are the transloading companies who move lentils and chickpeas and all the legumes as well as all the wheat, because they're going to be facing some extraordinary challenges in the near future. And I do want to congratulate the parties, the truckers and the transloading companies and the port for the resolution to the strike that should never have taken place if the federal government had played an active role right at the beginning. And let me say this, Mr. Speaker, that workers, whether it's health and safety issue, or whether it's other working conditions, or whether it's just the ability to make a decent living, whether it's just that ability to be able to feed their families, have found that there is power in them working together and being part of a collective. And I will say that legislation in this House, we do pass bills that go into law. But I will say this, unless there is enforcement, those just remain words in paper. So my plea to the colleagues across the other side is, please ensure that with the moves we've made in the right direction for worker safety in the offshore industry, especially for Canada, Newfoundland Atlantic Accord and the Canada-Nova Scotia Offshore Petroleum Resource Fund Accord, that we at least ensure that we have implementation measures in place that are not just we're asking you to. Because for implementation to happen, there has to be real enforcement, and real enforcement has to have real consequences for those that do not ensure that these safety measures are in place. And, you know, being a teacher, Mr. Speaker, I have to add this as well. An important part of occupational health and safety is education. And that is education of workers. And I believe that no occupation health and safety culture is complete without employers and workers receiving a thorough education, and both of them working collaboratively, though ultimately the power lies in the hands of the employer to ensure those conditions. And all the worker has is the right to be able to refuse unsafe work, but that enforcement and that education are critical components of any successful occupational health and safety program. And I know, having worked with a very successful one in BC, that how empowering that educational component can be. And I'm certainly hoping that the operators who've been charged with these responsibilities will develop an educational program as well as look at real enforcement. Thank you, Mr. Speaker.
Questions and comments. Questions et commentaires. The honourable member for Winnipeg North.
Thank you, Mr. Speaker. And I really tweaked when the member made reference to grain, because in the prairies we're really sensitive nowadays on the whole issue of grain and transportation of grain. In fact, I would have loved to have seen us debating Bill C-30 today. I know my colleague and Liberal Party critic from agriculture wants to see that bill get to committee, where we can hear from our farmers and other stakeholders. But anyway, having said that, it's important to recognize, the Liberal Party has long been very supportive of taking efforts that would ensure protective measures regarding occupational health and safety. We understand and appreciate that this is something that is more so being driven from our provinces than it is, in fact, from Ottawa. We recognize how important it is that we have those industries, offshore industries. They provide all sorts of opportunities, economic opportunities, and so much more in terms of even wealth for all Canadians. So there's a lot that's happening out in the East Coast, and you don't have to be an Eastern member of Parliament to really have that appreciation for what's taking place out East. I'm very happy to see the prosperity and so forth. Having said that, it is important that we do have labour laws and health and occupational, or I should say occupational health and safety measures enshrined, and this is in fact what this legislation is going to be doing. It has fallen short to a certain degree, but it is a strong move or a step forward, and we do give the government credit for that. And I'm wondering if the member might want to comment as to what she believes would have given more strength to the legislation that we're going to be passing.
The honourable member for Newton North Delta.
I want to thank my colleague for his question, and as a teacher, I always rewarded good behaviour, always believed in positive reinforcement. And I think when you do have a bill that takes a move in the right direction, I've always stood up in this House and said, that's good. But if the bill doesn't quite hit the finish line, then I think it's our responsibility to point that out as well. And, I quoted from the panel earlier to say it was an independent board that was needed. But here is a quote from the Newfoundland Federation of Labour. In our opinion, an independent, proactive and vigilant safety and environmental authority would begin to restore the faith of workers in the role of a regulator in protecting and acting to improve safety in the offshore oil industry. And there, that captures it. It's that independence that is required.
Questions and comments. The honourable member for St. John's East.
Thank you, Mr. Speaker. And I commend the member on her speech. As someone who is familiar with the labour movement, being president of the BC Teachers Federation, I wonder would you comment on the fact that it's taken so long to get to the point where, after 13 years of discussions, we finally have this bill, and only now do workers offshore have the same rights as anyone else to refuse unsafe work and to participate in workplace committees and have an enforceable code for safety violations?
Good question. Member for Newton North Delta.
I want to thank my hard-working colleague for his question, and I've always admired the work he has done both in the House, and I hear glorious accolades for him from his constituents as well. And from my teaching perspective, I think 13 years to get to this point is really slow. It's really slow, right? However, we have got here. Now, if we were in continuous progress, we've got to the halfway mark, but we still have a long way to go. But I also want to say that I actually was flabbergasted that we haven't done this a long time ago. But the other thing I have to say is I have seen this government since I've been a parliamentarian of a bill they want to railroad through this House, as they did with C-525, which was a union-busting bill, so to speak. They actually managed to ram that through with only about 2.5 hours of witness testimony and with an hour of clause by clause, and then even changed the orders in order to have it debated last night so that they could push it through. So it's really about will. I'm glad to see that they have that will today to be debating this, but it's long overdue. But you know what? Even if it's long overdue, I'm glad they've got to this point.
Questions and comments. The honourable member for Ancaster, Dundas, Flamborough, Westdale.
Thank you for recognizing me. And I just, based on the last question and answer, I just have a simple question. If the member just allows the debate to collapse, we can go right to a vote and we can make sure that this gets through. That's all we need to have happen, and we can make it legislation.
Honourable member for Newton North Delta.
I want to thank the member across the way for a question, because I've been waiting for a question like that for a long time. I actually believe in parliamentary democracy. I actually believe in debate, where we listen to each other and we sometimes actually can persuade the other to change their mind on something. I believe in a process where a bill goes through all its legitimate stages with the right to amend and to discuss and debate and hear testimony. Unlike my colleagues across the way who yesterday sat silent while they ran through a bill that was an attack on working people. They sat silent for the whole debate. Not even the mover of the motion had the courtesy to stand up and speak on that bill. That's not parliamentary democracy. That's something else.
Questions et commentaires. La députée de
Questions and comments. The Honourable Member for Hochelaga. Well, thank you, Mr. Speaker. It's clear, listening to my colleague, said that she is really speaking in favor of people surrounding her. We've heard her positions. And in her remarks, she talked about some problems and improvements that could, in fact, be made to the bill. She talked about an independent regulatory body. There were some other suggestions made at committee. For example, a mandatory examination of a mandatory 5-year review of the legislation. And there was mention made of witnesses who supported that position. It was also the position of Justice Wells. Now, would he agree with my colleague with the including a mandatory 5-year review?
Delta.
You know, when I see a bill before us that I feel is already lacking, that doesn't have that independence and that kind of a separation, I think 5 years is too long. I think this bill is in need of review even before it has been acclaimed. So because I fundamentally believe that and actually support what was recommended by the panel in the report, I think 5 years is too long a time to wait to review this piece of legislation. As I said, you know, in 13 years, we've managed to get to about a C. In order to get the A grade, we need to make sure we have that independent regulation of this of offshore safety. So for me, 5 years is far too long.
Some comments. Questions et commentaires. Reprise de débat. L'honorable député.
Resuming debate. The Honourable Member for Notre-Dame-de-Grâce-Lachine. Well, thank you very much, Mr. Speaker. I'd like to say that I'll be sharing my time with the Honourable Member for Brossard-La-Prairie. As you know, the NDP is vigilant when it comes to the safety of Canadians at work. Bill C-5 is a step in the right direction with respect to offshore workers, but unfortunately, it includes some flaws, and that is what my remarks will focus on here today. The debate on amendments to the Implementation Act for the Canada-Newfoundland Agreement, as well as the Canada-Nova Scotia Agreement on petroleum resources, was adopted in 1999 following the death of an offshore worker off Nova Scotia. Measures took force in 2001, and this issue came back, in fact, in 2010 following the report by the Honourable Robert Wells. On March 12, 2009, a helicopter went down off the coast of Newfoundland and Labrador, causing several deaths. It left no survivors. Following that accident, an investigation was commissioned and a report produced by Justice Wells. In the view of Justice Wells, the most important part of it was Section 29, which called for the creation of a separate and autonomous safety division of this recommendation. In fact, identifies the first shortcoming of this bill, the fact that despite the support from the government, it doesn't meet what is required. It has been criticized by the Minister of Newfoundland and Labrador. Justice Wells said that if this measure isn't adopted, he has put forth the 3 recommendations: that the government create a separate and autonomous safety division of the CNLOPB, as I was saying, CNLOPB, with a separate budget, separate leadership, and an organizational structure designed to deal only with safety matters. The second recommendation is to establish and to support the full-time leadership and staff of the Safety Division, an advisory board composed of mature and experienced persons with fully representative of the community, and thirdly, that it ensure that the Safety Division would have a mandate and ability to encourage, either on staff or as consultants, expert advisors to assist it in its regulatory tasks. Now, again, with respect to the implementation of this recommendation, we proposed a recommendation that would require the minister to report to Parliament within 5 years on the application and implementation of this bill. Now, the reply would appear to be that the government is seeking to resolve this issue as quickly as possible, despite the fact that negotiations have been underway since 2009, and even if a review of its bill would be very beneficial for workers. Now let's talk about the relationship between the government, the federal government, and provincial governments. The Conservative government is not sufficiently collaborating with the governments of the provinces, despite the fact that they must have the agreement of the federal government to amend their legislation with respect to workers' safety, offshore workers' safety. An NDP federal government would work in close cooperation with the provinces to ensure the safety of these issues, and has stated so in 2001. There were negotiations between the federal government and Nova Scotia and Newfoundland and Labrador. That was when they began. This situation is another situation where the Conservative government isn't listening to claims from the province. In 2001, negotiations started on this issue, and this bill still hasn't come into force. What excuse did the Conservatives have for lagging behind on this issue? They say that it could have been done before they came to power. In 8 years, how is it that they haven't found enough time to take any action? I could have put this question to the Liberals. They could have dealt with the issue starting in 1999. We can't lose any more time. We must resolve this issue. It's high time to act. After having listened to all debate, Shell and BP are preparing to drill off the shores of Nova Scotia, and I'm sure that there will be another disaster. Everyone would like to be reassured with respect to the safety, the health and safety of these offshore workers. I'd also like to remind this House that Bill C-5, in my view, is a step in the right direction to protect workers. In fact, this bill will give workers an opportunity to refuse to carry out a duty if they feel that it is unsafe to do so. It will also protect workers who blow a whistle on an unsafe situation and ensure there is no retaliation. This is an important measure for offshore workers. I would repeat, however, that it would be better tailored to the situation if it implemented Justice Wells's recommendation number 29, or at least agreed to a 5-year review of this bill with respect to the creation of an autonomous safety division, if it also enhanced safety in the offshore region. The NDP realizes that Bill C-5 is a step in the right direction, but it deplores the fact that it has taken so long to reach this stage. We deplore the lack of collaboration between the federal government and with the government of Nova Scotia and Newfoundland and Labrador. And we also deplore the fact that the government is ignoring Justice Wells's recommendation 29. Now, before wrapping up, I would like to add that before being a member of Parliament, I took classes in human resources management, on occupational health and safety of workers as well. And I would point out that this is a very important aspect when someone reports for duty on the job. Many studies show that people work better when they go to work and know that they're working in a safe environment. People are happier to go to work, happier to do their jobs, and they work more effectively. So that aspect is essential. A Conservative member earlier asked why, in fact, we are taking this time to discuss the issue. Why wouldn't just sit down and allow the debate to collapse so that we could go to a vote? Well, I think it's very important, Mr. Speaker, to have this opportunity to rise in the House and to explain our opinion and our views on this bill. We know that the Conservatives are continue to try to muzzle us, to fast-track the issues, to push them through quickly. But part of our duties as parliamentarians involves taking a stand in the House, speaking to bills, identifying the pros and cons, and this is the vehicle that I have to reach out to my constituents as well, to tell them that, or to tell them about the speeches that I've made in the House on this issue as well. Now, these are important issues. Even if my riding is in Montreal, in Quebec, in Notre-Dame-de-Grâce-la-Chine, we're quite far from the area that is affected mostly by this bill, but these are issues that are important to all Canadians. I think it's important to take the time to speak about them, to talk about these important issues. And I'd like to reiterate the fact that I agree with the bill. I don't think it goes far enough, but it is an improvement, a constructive improvement. We will be supporting it, and we are happy to do so. Thank you.
Questions and comments. The Honourable Member for Brossard-La Prairie. Thank you, Mr. Speaker. I'd like to congratulate my colleague on her excellent speech. This is an issue that I get the feeling she really cares about, and I'd like to also highlight the fact that it's important to discuss this. I'd like a comment from my colleague about why it took 12 years for this bill to be introduced by the Conservative government and even before under the Liberals. Why has it taken so long? Maybe my colleague has some idea, or what's her opinion about the fact that it's taken so long when we're talking about something so important as worker rights to a healthy and safe workplace. The Honourable Member for Notre-Dame-de-Grâce-la-Chine. Thank you, Mr. Speaker. I'd like to thank my colleague for his question. I can't really read the Conservatives' minds. I don't know why they didn't move faster. They obviously have their own agenda, and they want to ram that agenda through. Since 2006, if you just look at this Parliament, this is the 41st session, the 41st Parliament. So we were elected a few years ago, and obviously the most important bills to the Conservatives came first. They pushed things through that mattered most to them on their agenda. Now it's a bit later. Maybe they decided to rush their priorities through first, and now they're just dealing with the leftovers. I think it's a bit of a shame because we're talking about worker safety. It's really important. Why didn't they do this sooner? I think it's regrettable that it's taken 12 years because, as I said, it's very important for a worker to feel that they're safe and secure in the workplace. But it's not just the Conservatives. As we know, it's taken 12 years. The Liberals were in power before them, and it's just sad. It's sad because I think the NDP is the best party to defend workers, their health and safety. And here we see there's yet another government that doesn't make a priority out of this. Questions and comments. The Honourable Member for Hochelaga. Thank you, Mr. Speaker. At the Transport Committee this morning, we were studying the safety management system when it came to the transportation of dangerous goods by rail. And we had witnesses, metal workers, who said that Transport Canada's not doing its job. They're not enforcing the rules. So there are rules, but they're not being enforced. They give companies all kinds of leeway, and that leads to things like what we saw in Lac Mégantic. My colleague mentioned an independent regulatory body. Would that help solve some of these problems? The Honourable Member for Notre-Dame-de-Grâce-la-Chine. Thank you very much, and I'd like to thank my colleague, who's doing an excellent job on her committee, the Transport Committee. They're doing a very important review on the transportation of dangerous goods. I'm not sure who said that Transport Canada wasn't enforcing the rules, but we've certainly seen the result. I think an independent regulatory body to enforce the rules is essential, but the Conservatives are much bigger on self-regulation. For example, with drugs, the pharmaceutical companies We wanted something binding, but they said, no, we just have there's a voluntary compliance code in that industry. I don't think self-regulation is the way to go. I think we need an independent regulatory body. And that's another good reason to have a review after 5 years. Because if there is no independent regulatory body or oversight body, well, I think it's important to see what's going on 5 years down the road and see whether there is a need for such a body. But I believe that people act in good faith. But sometimes there's oversights, there's shortcomings, there's things that fall through the cracks. And that's what you need an independent body for, to make sure that none of these things happen or are neglected. But that's not in this bill, so that's one other problem with this bill. It doesn't go far enough. These are just half measures, and there may be consequences. But despite that, we're going to support it because there are some good things in here for workers, but it simply doesn't go far enough. It's my duty, pursuant to Standing Order 38, to inform the House that the question to be raised tonight at the time of adjournment is as follows. The Honourable Member for Alfred Pellant, regarding public safety. Resuming debate, the Honourable Member for Brossard-La Prairie. Thank you very much, Mr. Speaker. I rise today to state my opinion on Bill C-5, the Canada-Newfoundland Atlantic Accord Implementation Act, and the Canada-Nova Scotia Offshore Petroleum Resources Accord Implementation Act. It's a long title, but what this bill does is it makes up for certain shortcomings that have been around for a long time in order to protect workers. And we're talking about oil rig workers, offshore oil rig workers. The reason I say that this is long awaited is because we've been waiting for over 12 years. These shortcomings have been noticed. We've been aware of them for 12 years. And what I find regrettable is that it's taken so long, both for the Liberals back in the day and for the Conservatives since then. Why has it taken them so long to protect the workers' rights to a safe workplace? But this bill is, though long overdue, a step in the right direction. A lot of cooperation between federal and provincial governments was necessary. So once again, I do recognize that the federal government did manage to discuss and cooperate with the provinces on this issue. I'm going to talk later about what could have been done better, but this is at least a step in the right direction. Unfortunately, this doesn't happen often enough. In my riding, there's the issue of the Champlain Bridge, and we see there that the federal government refuses to cooperate with the provincial government. So they say if it's not a toll bridge, there will be no new bridge. So it's a hard and fast position. When you talk to the provincial government and the municipalities, they're against that plan. And the NDP is against the requirement that the replacement bridge be a toll bridge. This is important, Mr. Speaker, because I intend to demonstrate that at times the federal government does manage to work together with the provincial government. So I don't understand why they don't do that routinely. Why don't they do that all the time? Why don't they work with their provincial counterparts to make progress for the sake of Canadians? Because here we have a step in the right direction, but as my colleagues mentioned, the NDP wants to help, wants to make constructive suggestions, and one of the main issues has to do with recommendation number 29. There was an inquiry after an accident, a tragic accident. There were a number of deaths. It happened off the coast of St. John's. what we saw after in the report, one of the main recommendations of Mr. Wells was that there should have been an independent body to oversee, and what the recommendation said was 29 required the creation of a new independent body to regulate. It's a very important recommendation which was put forward after the inquiry was conducted. They felt the need for the creation of such a body. Creating this kind of body, there's no accident. It's not a novelty. We have this kind of independent oversight body in other places, in the UK, Norway, Australia, and the US. In the US, it's called the Bureau for Safety and Enforcement. So a recommendation was made following a major inquiry, and a solution was proposed, and we just don't know why the government refuses to accept that recommendation, make that change, which is practical and beneficial and could certainly help. And this simply reminds us that this government has a tendency to say, yeah, we'll study the issue. But here, recommendations on, for example, the DOT 111 railway cars, for years it's been known that those were dangerous, and this government's done nothing. Before the Conservatives, there were the Liberals, so we're talking 20 years ago. Now the Conservatives, they're still doing nothing to replace these old DOT 111 railway cars. And this is what bothers me. There was a tragedy in the case of C5. It was an accident, offshore accident near St. John's. And in the DOT 111 case, it's of course the 47 deaths in the tragedy at Lac Mégantic. So yet again, we have a recent recommendation saying that DOT 111 cars are problematic, and those were involved in this accident, but we see inaction from the government. In this case, as my colleague said, it has taken 12 years for the government to act. In the DOT 111 case, it's been over 20 years, and they still haven't done anything. Yesterday, I asked the minister the question, what's the calendar? No answer. Well, a vague answer that said there's still no time frame. So, but we know this can be done in a few years if the government has the will to do something about it. If they have a bit of confidence and a bit of leadership, political leadership, that would be awfully nice to see for a change. Coming back to C5, as I explained, Mr. Speaker, this is a step in the right direction, and that's why at this stage we're supporting it. But once again, this is something we see all too often. We'll make recommendations at committee, we'll discuss the bill, but unfortunately, the government, as we all know, has a majority. They have a majority on committee. And I've sat on a lot of committees. They reject virtually every recommendation coming from opposition parties, be it the official opposition or the third party. They simply don't listen to the other parties. And that's unfortunate because in this case, it's quite concrete. This isn't something we just made up in the official opposition. It's something that comes from a report after an inquiry and experts who studied a problem. I'm not an expert, but I rely on what experts have done and said. So they looked into the situation, they came up with a proposal, and what's more, they say quite candidly that this is clearly the most important recommendation. And what does the government do? They simply push it aside. And why? We really don't understand on this side of the House. It's unfathomable. The reason for creating an independent body, an arm's-length body, is we're talking about safety regulation here. It's very important. And once again, Mr. Speaker, I'm sorry to constantly be drawing parallels with Transport Canada, but that's an area that's more familiar to me and my work. So once again, we hear that the government has received recommendations and has done nothing about them. Once again, there were experts who appeared and talked about the problems, and unfortunately, I'm guessing that the government's attitude is going to be the same. They're going to say these are nice recommendations, but we're simply going to push them aside. That's not what we're going to do. We're not going to follow through on those recommendations. With rail safety, it's such a clear, flagrant example. There was a tragedy, 47 deaths in Lac Mégantic. Then there was a report from the Transportation Safety Board, and they made 3 recommendations. It's not complete yet because they're still investigating, but unfortunately the government has done nothing about it, and it's really sad. It's really regrettable because we're talking about saving lives. We're talking about workplace health and safety in this case here. We're talking about helping people, but unfortunately, despite the recommendations from experts, the government is turning a deaf ear to their recommendations. So just by way of conclusion, I would congratulate the government for at least, after 12 years of foot dragging, they're doing something that is somewhat positive. But what's unfortunate is that they could have done better and they should have done better. Thank you, Mr. Speaker. Questions and comments?
North.
Mr. Speaker, I know that I've had the opportunity to ask a number of questions related to the bill. The member intrigued me when he made reference to the DOT 111 railway cars, and made reference to the fact that we're talking about 20 years. The question that I have for him is related to an area in which he says that he's quite knowledgeable on, and that is, when did the NDP recognize the DOT 111 cars were not worthy enough to be on the rail line, and how long does he believe they should be allowed to continue to be used by rail line companies?
The Honourable Member for Brossard-La Prairie. It's interesting. Well, thank you for the question. I think it's interesting that he's asking me this question when it was the shortcoming of the Liberal government of the day that did nothing that's to blame. When the Conservatives and the Liberals passed the buck back and forth, it's quite something to see. But to get back on topic, I appreciate the question. The Transport Minister said that 10 years, where did that number come from? The United States. The CN yesterday came out and said that they'd be replacing all their DOT 111s. Irving Oil said that they'd be doing it within a year. Today at committee, DOT 111 manufacturer appeared and said that there were about 80,000 cars to be switched. Unfortunately, I haven't met with all the stakeholders personally, but what I would like the government to do with all the information and all the power the minister has is to come up with a time frame, a calendar. After discussing all of these things, come up with a report that, despite the report on the DOT 111 railway cars, the minister still has no time frame, no calendar. I think it's time to act, and it's time to draw up some sort of a calendar for that. Questions and comments? The Honourable Member for Gatineau. Mr. Speaker, thank you. And I really appreciated my colleague's speech, my colleague from Brossard-La Prairie. Thank you, Brossard-La Prairie. And I wanted to ask him the following question, because I'm still trying to get my head around why this bill was tabled and studied in committee, and the NDP proposed an amendment the last time round, requiring the minister to report to Parliament within 5 years on the implementation of the Act, to report specifically on the need for an independent oversight body. Why? How is it? Because I've thought long and hard about this, and I can't figure it out. Could he perhaps help me out here?
The Honourable Member for Brassard-La Prairie. Thank you, Mr. Speaker, and I'd like to thank my colleague for her question and also for all the work she herself has done. Now, her question is very specific and very relevant because it also gives me an opportunity to speak about how this legislation will be dealt with over the next few years. Now, what I was told was that the Conservative members sitting on that committee weren't even interested, actually, in discussing this. And it appears there's actually just no interest. Unfortunately, every time the opposition brings forward amendments, and I've sat on several committees, so I've seen this myself. I've seen it perfectly clearly. I've seen that they really don't care. So even if the amendments are supported by experts, even if we're told that these amendments will help, out of pure partisanship, the Conservatives decide that these amendments aren't any good. And it just shows that we've got an old, used-up Conservative government and it's time for change. Resuming debate. The Honourable Member for Portneuf-Jacques-Cartier. Thank you very much, Mr. Speaker. Today, I'm going to join a voice of my other colleagues within the NDP. They seem to be the only ones speaking to this. I'd like to point out that we will be supporting this bill, and I will be sharing my time with the member for Gatineau. So, Bill C5, we feel, is very important because it corrects major problems and shortcomings within the legislation and within the decision-making process for occupational health and safety regulations within the offshore petroleum sector. Now, what does that mean? Well, when Bill C5 is passed, it will put occupational health and safety in legislation. That health and safety will be enshrined, and the minister will be given overall responsibility for occupational health and safety, and the minister also will be responsible for the implementation and coordination of all necessary measures to ensure workers' safety. On their side, workers will be able to refuse to undertake any work if they have reasonable grounds to believe that that work is unsafe. So that's a very important measure for workers, because their occupational health and safety should be paramount. These same workers will be protected from reprisals if they feel there is an unsafe environment and they refuse to work. Now, Bill C5 is a necessary and constructive improvement over the occupational health and safety regime within the offshore sector, and that is why the NDP is proud to support it. Protecting workers has always been and continues to be a priority for the NDP, regardless of the area they work in. Whether we're talking about workers in offshore areas, in land areas, they are all important. They all deserve the same protection. And provinces feel the same at the time. The NDP government in Nova Scotia was very supportive of this, and in Newfoundland and Labrador, a lot of work has been done on this. The province has worked very hard on this to have a regime, and the NDP has been very instrumental in moving this debate forward. Now, the NDP federal party, of course, will support the work that's done by the provinces, and we're pleased to see these improvements that will be implemented once the bill is passed. What changes are we talking about? Well, First of all, these changes have been asked for over 10 years. In Nova Scotia, Newfoundland, Labrador, we're waiting for these changes, and it was time for the federal government to consider these issues. And I think that regardless of what one may feel about offshore petroleum resources, these are very important issues, and they may become very important issues in Quebec as well. Regardless of what one may think about offshore petroleum work. Now, the NDP wants to acknowledge the work that has been done between the federal and provincial levels and that has led to the bill that is before us today. This shows an openness to discussion and collaboration that I think is quite surprising on the part of the Conservatives, who have usually been very close-minded and intransigent. But hopefully they're going to really enjoy this new approach, and they're going to continue on with that. Let's be positive. One can always hope that this way of doing things, that means cooperating with the provinces, is going to continue rather than confrontation over the next several issues that they'll be working on with them. These days, health is an important issue, a topical issue. We've been talking about, for example, training. There are all kinds of issues that are coming forward. However, the Conservatives just seem to want to bully the provinces. They just tell the provinces, do what we want you to do, and that's it. Otherwise, we won't support you. However, I'm going to continue encouraging them to work like this, and through you, Mr. Speaker, I'm going to tell the Conservatives to keep this open-mindedness with the provinces. Now, we have a bill before us, and it's important to point out that it's not a panacea. It's not going to solve all our problems. The NDP has repeatedly, and the provinces have repeatedly made requests for an independent safety regulator in the offshore area. Now, this was a measure that originally was proposed by the Honourable Robert Wells in his 2010 report. And he said, I believe that the recommendation which follows this explanatory note will be the most important in this entire report. He was referring to recommendation 29. That says there should be a new independent and standalone safety regulator that be established to regulate safety in the Canada-Newfoundland offshore. And this is a very important recommendation because there would be one independent standalone safety regulator that would be responsible for safety regulations. Now, this inquiry, of course, followed on the heels of a terrible disaster and led to the debate of an independent safety regulator. We in the NDP feel that this is extremely important. Unfortunately, it's not in the current bill. Earlier, I listened to my colleagues' speeches. I heard to the Liberals and the Conservative speeches as well. And I heard people say that we should be passing this bill right away so that we don't lose any more time. Well, I'm wondering where they were 12 years ago when the negotiations began. The Liberal and Conservative governments seemed to make light of this and didn't do anything. Now, I would just like us to vote. Of course, I would like us to be able to vote quickly. I would like us to be able to move quickly. However, there are many experts who testified before the committee, and they testified to the fact that an independent regulator was important and that we had to take necessary measures to protect the safety of our workers in offshore areas. Unfortunately, nothing was done for a long time. Newfoundland and Labrador members have said how unfortunate it is that there isn't going to be an independent regulator. And within the NDP, we will do everything we can to work with the provinces in order to establish an independent, standalone safety regulator. We feel this is a priority. The current government and past governments, Liberal governments, don't appear to think that this is a priority, but in 2015, a new Democratic government is going to get practical results and solutions for workers who work in offshore areas. We feel that this is very important. Earlier on, my colleague from Brossard-La Prairie was referring to an amendment that had been put forward by the NDP within committee in an attempt to improve the bill. They felt that there should be a provision in the bill that allowed for a review after 5 years on how effective that legislation had been and if there was any room for improvement, possibly by creating a standalone independent safety regulator, as Mr. Wells had suggested. But that didn't happen. Now, I'm not going to say there was bad faith on the part of the Conservatives. However, I can't find another reason. So I suppose there was bad faith on the part of the government, and that amendment was turned down. So we have a bill that does have some shortcomings in it, and yet, yes, it is a step forward for our workers. And because we want enhanced protection for workers in these offshore areas, the NDP will be supporting this bill. It's unfortunate, as I was saying earlier on, Mr. Speaker, that we haven't been able to resolve all the problems that were clearly pointed out by provinces and by experts. These were problems that we saw. We saw through actually the unfortunate deaths of so many workers over the past years. It appears that there is no will on the part of the current government to have a standalone regulator. Unfortunately. However, we need better measures enshrined within our legislation, and that is a step forward. There is increasing interest in offshore resources, and these are measures that should have been taken a long time ago. We now have them, and the NDP is very proud to be able to support these enhanced measures. I just want to repeat again how proud I am of the work that was undertaken by new Democratic members of Parliament and members of legislative assemblies in Newfoundland and Labrador, who all worked very, very hard. And they can all be proud of the work that they've done. Thank you, Mr. Speaker. Questions or comments? The Honourable Member for Laurentides-Labelle. Thank you very much, Mr. Speaker. I've been listening to the debate, and I don't know if my colleague agrees with me, but it appears to me that the government's priority is to not talk too much and simply vote as quickly as it can, just in case people start realizing that the main recommendation of Justice Wells was cast aside. There are workers who will be working on these platforms, offshore platforms, and there's always a risk that they won't come back. You know, when you don't want to do something, you drag things out. You take your time, you do a half-baked job, you do it at the last minute. I'd like to know what my colleague thinks of that. That's my impression anyway. The member for Portneuf-Jacques-Cartier. Thank you very much, Mr. Speaker, and I'd like to thank my colleague for Laurentides-Labelle for his question. Perhaps the Conservatives were hoping that they could just get this passed really, really quickly without saying much so that people wouldn't notice too much. But thanks to the work of the NDP here, they won't have succeeded in that. People will be aware of what was done and what wasn't done, and elected members within the provinces also will have noticed that that recommendation is sorely lacking in the bill that we have before us today. So this is a problem, but the NDP members took the time to stand up in this House, speak to this, and shed light on this problem, contrary to the Conservative and Liberal members who simply decided to abstain from debate. We have been able to shed light on this problem, and you can be certain that in 2015 an NDP government is going to tackle this issue and will work in collaboration with the provinces as should have been done from the very beginning. Thank you.
Questions and comments? The Honourable Member for St. John's East.
Thank you, Mr. Speaker, and I thank the Honourable Member for Portneuf-Jacques-Cartier for her speech. And I wonder if she would care to comment on the fact that the minister responsible for this bill, the Minister of Labour, was asked 3 times this morning why the government refused to accept an amendment to review this provision for an independent safety board in 5 years' time, as was proposed by the NDP, and we didn't get an answer. There was no explanation given as to why that review wouldn't be permitted and put into legislation. I wonder if would you care to comment on that.
Député de Portneuf-Jacques-Cartier.
The Honourable Member for Portneuf-Jacques-Cartier. Well, I think it's very disappointing to hear that. The responsible minister should be able to answer these questions. If amendments are turned down, there has to be proper grounds for that. And if they can't even justify that, well, then there is a problem. It's simply an arbitrary decision on the part of the minister. And it's not a decision that is made in the best interest of the workers. So I myself would like to have an opportunity to ask that question of the minister and get an answer. But I don't think I can be too hopeful about that. It's important for us to, it would be important for us, rather, to understand why that decision was made. If there are any problems, then we're going to have to come back to Parliament. We'll have to debate again. We'll have to try once again to convince members opposite of the need to review the legislation and improve it. And then we have to start the whole legislative process all over again. So I really think that it's disappointing that the NDP's amendment wasn't passed as it should have been. Questions and comments? The Honourable Member for Sherbrooke. Thank you, Mr. Speaker, and I'd like to thank my colleague for her excellent speech. I have a question, a general question for her about today's bill. What is the NDP's record on occupational health and safety, not only for offshore workers, but everywhere where workers are? What is the NDP's position on occupational health and safety? The Honourable Member. Well, I'd like to thank my colleague for Sherbrooke for asking me a very relevant question, because that gives me an opportunity to come back to something I only referred to briefly in my speech, and that is the importance that the NDP attaches to the protection of workers' rights. This has always been a priority for our party, and the Conservatives are always pointing the finger at us for defending the rights of workers. However, it's absolutely essential that we do that. Without protective measures that guarantee occupational health and safety for our workers, we will end up with injuries, absenteeism, abuse, and yes, potential abuse on the part of employers even. All these are very important factors that we have to keep in mind, and then unfortunately, these factors seem to be constantly disregarded by the Conservative government. So workers have to be properly defended within the House of Commons, and if they want that, well, they'll have to choose the NDP in 2015. Thank you.
I have the honour to inform the House that a communication has been received, which is as follows. This is dated March 27th, today. Mr. Speaker, I have the honour to inform you that Mr. Stephen Wallace, Secretary to the Governor-General, in his capacity as a Deputy of the Governor-General, signified royal assent by written declaration to the bills listed in the schedule to this letter on the 27th day of March 2014 at 4:03 p.m. And that's signed by the Deputy Speaker. And the bills assented to as of this day include an act for granting to Her Majesty certain sums of money for the federal public administration for the financial year ending March 31st, 2014, otherwise known as Bill C-28, and an act for granting to Her Majesty certain sums of money for the federal public administration for the financial year ending March 31st, 2015, as in Bill C-29.
And it is my honour to inform the House of Commons that a message, and the message that follows, was received. Mr. Speaker, I have the honour of letting you know that Mr. Stephen Wallace, as Secretary of the Governor-General, as interim Secretary of the Governor-General, gave royal assent, written royal assent, to the bills listed in the schedule of the following letter, of the present letter, on March 27th at 4:03. Mr. Speaker, signed Patricia Jaton. The bills that received royal assent on Thursday, the 27th of March 2014, were a bill allocating funds for the public administration during the year ending the 30th of March 2014, C-28, and an act granting public administrative finances for the fiscal year ending March 31st, 2015, Bill C-29. Resuming debate. The Honourable Member for Gatineau. Thank you, Mr. Speaker. And publicly, I want to state once again that I'm very impressed by your French, and the people in Quebec really appreciate listening to you. Now, on C5, it gives me great pleasure to rise in this House and speak to C5. It always gives me great pleasure to rise in this House when I have an opportunity to do so. And the more often I can do that, Mr. Speaker, the more often I have an opportunity to express the perspective of those who elected me, the better. I didn't just come here just to rubber stamp government bills, Mr. Speaker. That wasn't the promise that I made to my constituents. So I'm going to start out by congratulating my colleagues from the NDP who worked so hard on this bill. And when I look at the interest on the side of the Conservative and Liberal benches, one would think that this was just a teeny little bill. However, it's a 70-page bill, and this is an extremely important bill. But it's a very complex bill.
Now, Mr. Speaker, the reason why we are so opposed to the government using time allocation motions is because once you hit 60, well, we can't be told that's part of the normal procedure. It might be useful once or twice, but no, not 60. Now, Mr. Speaker, when we hear that if we are going to be voting in favor of something, we should immediately move the bill on to the next stage. But no, it is our role as elected officials. We have to have this opportunity to speak to these bills. It's also our responsibility as the official opposition to do the work that sometimes the government refuses to do. And that is required. Now, as I said, as I often say, Mr. Speaker, the government's majority is not a strong one. It was elected by 39% of the population, so 61% of the population would like to hear another point of view, not just theirs. Now, Mr. Speaker, to say that we should simply rubber stamp these pieces of legislation, and in fact it isn't surprising to hear that from the government, because yesterday in another context, but one that applies to this context today, my colleague, the member for Chicoutimi-Le put a question to the Minister of Justice regarding another time allocation motion. And, he was criticizing us, and my colleague said, we have been working for 2 years on this issue, and I haven't had an opportunity to speak to it. But because of the time allocation, I won't have an opportunity to speak to it. And he asked the minister if the minister wasn't interested in hearing from him. The minister was frank, and he said, and I quote, from start to finish, without doing like the Minister of Democratic Reform with his wacky off-the-wall quotes that are leave a lot of aspects out. He said, frankly, no, I do not particularly want to hear the member's point of view. Well, that says it all, Mr. Speaker. I spent the night digesting that, Mr. Speaker, and thinking about it. As a woman from Gatineau, the member for Gatineau, elected by the people of my riding in 2011, I want to rise and proudly talk about Bill C-5, because Bill C-5 isn't just a government issue. It isn't something that is only something that interests the Minister of Labour. No, it is of interest to everyone in this House, because it is our duty. There's nothing that angers me more, Mr. Speaker, than to see or be faced with decisions like the cases that we've heard, Nadeau and others from various courts, stating that we haven't done a good job of our work. I'd like to draw the attention of the House to the fact that it is our duty to do this job. I'd like to refer to the Welland decision that was brought down with respect to conditional release, with respect to the retroactive nature, where Justice Wagner said in paragraph 67, and I hope that everyone will realize, and this will be on record, but the judge said, now this isn't part of the decision, but it's very worrisome, and he said that the level of debate is such that I have doubts with respect to the constitutionality of the Act. It was a very acrimonious debate. Now, what that says, and what that teaches me, or tells me, Mr. Speaker, is that it's important to look at the role we have here. We have an important role here. We must stand up and speak. Now, the Conservative government like to use terms, say things that are said, use a bit of artistic license, a little bit of ambiguity in order to imply certain things. And the people down at the other end of the House do that as well. And that shows, in fact, just how important our job is here. It tells us that what is said here one day could be reviewed by the courts, could be analyzed in terms of with respect to action that we take or legislation that we adopt. We have a procedure. And as the Speaker of the House, you have to use and enforce the procedure, ensure that everything is done properly and with decorum. But we also have an obligation to ensure that the legislation that we adopt here, when they leave this place and are put in place, come into force, and will be used by the legal system and for Canadians, we need to be fully aware of what we are doing. Now, this is the first day of debate, Mr. Speaker, on Bill C-5, and I hear members opposite saying that it's shameful to see that the MDP wants to stand up and speak to this issue when it deals with the safety of people working offshore in jobs that are sometimes very difficult. And I salute them for the work that they do for the benefit of Canadians. So, wanting to take a look at this bill, to speak to this bill, and to do our job as the opposition, to tell the people watching the debate and people who are interested in Bill C-5, here is what happened at second reading, here's what was said at second reading, what happened at committee, here's what was proposed at committee, rejected outright by the Conservatives at committee, more often than not, because that's the way it happens when we introduce amendments at committee. The amendments weren't accepted, so the bill comes back to the House at third reading, at report stage, and then third reading. If we want to support the bill, that's one thing. However, we do at the same time want to say we need caution. I don't want to have to say one day that I remained seated when there was an important issue that perhaps it would have been important to hear an amendment with respect to action that they were considering. When we realize for a government that says it's a law and order government, that it's on the side of victims, well, there are victims who are workers. Workers who, through the work that they do, may well find themselves in a very dangerous situation. So all measures that deal with their safety in resolving a dramatic situations like what happened off the shores of Newfoundland and Labrador, well, I think that warrants close consideration. The amendment put forth by the NDP was an amendment that was reasonable in the circumstances. In member statements, the one member talked about L'Île Verte, about a meeting with the firefighters, and they talked about the importance of sprinklers in seniors' residences, etc. We can't wait until a dramatic incident occurs to take action. So, Mr. Speaker, when it's my duty to rise, I need to rise because it's our duty. And I say shame to those people who want to simply rubber stamp legislation for the government. Questions and comments. The Honourable Member for Brome-Missisquoi. Well, thank you very much, Mr. Speaker. I would like to thank the member for Gatineau for her very passionate speech, a very convincing speech. I congratulate her for speaking on behalf of her constituents, for the hard work that she does, while remaining very humble. I have a question for her. Why did the previous Liberal government and the current Conservative government not put in place a governance structure which was clearer and more transparent? Thank you, Mr. Speaker. The Honourable Member for Gatineau. Well, Mr. Speaker, I would say that that's often the $64,000 question, because many times the right way of doing things is very clear, but it may be more complex or complicated. Being forced to listen to what others have to say on a subject, well, yes, it does take a little more time, and sometimes they think that they know everything, and they are on a track towards something and they don't want to be sidetracked, if you will. There's nothing wrong with saying that we made a mistake. It seems to me that that's in good faith. I don't have problems with admitting to a mistake. If we repeat the same mistakes time and time again, then that's a problem. But there's nothing wrong with listening to other people and to their views. And so transparency isn't just a word or an expression that we use when we sit on the opposition benches. No, it refers back to respect for our constituents and Canadians. It's also part of our duty. It's part of something that must be carried onto government benches as well. Working in cooperation on transparent decisions. We make important decisions for people, Mr. Speaker. We're not here for ourselves. We're here for the people who elected us. Questions and comments? The Honourable Member for Saint-Lambert. Thank you, Mr. Speaker. I'd like to thank my colleague and thank her for her excellent remarks. She reminded us that Bill C-5 is a constructive improvement in terms of the current occupational health and safety system for these workers, and that it's important to ensure that these people are protected while on the job. She also mentioned the refusal by the government to consider the reasonable amendment that we put forth, which dealt with the mandatory 5-year review of the Act. Can she explain to us what the consequences of rejecting that proposal will be? The Honourable Member for Gatineau. Well, I think the future will tell us what the consequences of that are, but being careful, and this is perhaps the key theme of my remarks, and this is a friendly remark to the members opposite, perhaps they should start counting the numbers of times they've been slapped in the face recently. Perhaps they should take a few steps back and put in place some of those kinds of mechanisms that make it possible to review legislation. It's more than high time to do so. more than high time because some people were asleep at the switch doesn't mean they should just be doing something quickly and pushing it through. I'm talking about being cautious, and that's what the amendment dealt with. It was something that would enable us to have a review. Now, under the criminal code, we're looking at an issue regarding official languages because the legislator was good, made a good decision, and they call for or put in place, in fact, a mechanism for review. There's absolutely nothing wrong with that, especially when it comes to workers' safety. Workers isn't a bad word, Mr. Speaker. These are people who go out to work every day. We, too, are workers. For some people, their jobs are more dangerous than it is for others. So protecting those people is something that is just as important as protecting all victims in our society, Mr. Speaker. Resuming debate. The Honourable Member for Rivière-du-Nord.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. In my short experience here as a politician, I've learned quickly that when the government wants to move quickly, and more quickly, it's because maybe there are some issues it doesn't want us to focus on. Now, with respect to these two boards and the issue of offshore development is something that's of a great interest to me. Because I've always imagined a situation where a group of workers get in a helicopter, go out into the middle of the Gulf or off the coast of Newfoundland in very difficult at times atmospheric conditions. They land on an oil platform and they go there to work, where the waves are 30 meters high. For most people, it's even impossible to imagine what that must be like, but that is a reality for many workers who work in this offshore environment. Now, the image of a platform also makes me think of a kind of a floating prison where you work very hard, 12, 14, 16 hours a day under a great amount of pressure, because oftentimes the companies that are operating these platforms are subcontractors, and concern with safety isn't their main concern. At present in Canada, we're in the midst of a black gold rush, and there's not enough concern with respect to the environmental consequences. Oftentimes, the human conditions for the workers there are neglected. So, Mr. Speaker, these drilling platforms aren't standardized. There are many different types. Some of them are floating platforms. Some of them are modular. Some are semi-submerged, partially submerged. Others have function or are built on barges, etc. There are a number of different facilities used for offshore drilling, and the workers on those platforms face different types of conditions. The hoses, for example, might be located in different places from one platform to the other. And I'd like to point out that I'll be sharing my time with the member for Rosemont-la-Petite-Patrie. So if there's a worker who goes out onto the platform, they need to know what type of platform it is, what kind of pressure they will face, what the risks, the health and safety risks they'll face, because it is a dangerous job. So I'd like to go back to the bill as such, which is an attempt to deal with a shortcoming in the agreement. And it's taken over 14 years to deal with this. Within the bill, the government wants to incorporate the occupational health and safety measures. Now, on this side of the House, we're pleased with that, but there is something we'd like to caution the House about. Specialists and people who've analyzed disasters or injuries incurred by these workers proposed setting up an independent body to focus exclusively on safety for workers. Other countries have done this, Norway, for example, Australia, the UK, but we're not at that point here.
I won't quote Robert Wells again from his report when he recommended the creation of an independent body. But I went to read the actual text of the Act, and I looked at the mandate of the type of body provided for in this Act, and I looked at their mandate, and it says that they have the mandate when it comes to managing offshore issues. It talks about exploration licenses, drilling decisions, production decisions, work permits, investigations and infractions, tax issues, insurance issues, tax agreements, payments. It even goes so far as to cover royalties and transfer payments. So that's the mandate, and we'd like to see worker safety included in the mandate. The board was created to regulate oil drilling, but there's no mention in the board's mandate of the human dimension. It's left out completely. And those issues haven't been dealt with for years. When workers arrive on the rig, they're in a no man's land of worker rights. So we'd like the board to take on that role. We'd like that to be part of their mandate. Worker health and safety. So that's why this needs to be discussed. When you act hastily in creating a mandate, you don't cover off all your bases. The offshore work is very dangerous. It's the most dangerous profession in the world. There are so many accidents. There have been huge disasters, explosions on oil rigs. There's been a number of them in the past 20 years. It started in the 70s. There were 120 deaths on a rig in Alexander. The Alpha rig in 2009. There was the helicopter accident here at home. 7 people died. In 2010, we saw what happened in the Gulf of Mexico. 11 people died. There were also victims in Russia recently in 2011. In offshore in Louisiana and off the coast of Africa, 6 deaths. In the North Sea, 2013, 4 people were killed when a helicopter crashed. The same type of thing that happened here in Canada. And this legislation, this is why we're supporting it, will also cover the transportation of workers. It's important for them to be covered at that point too. So this is all that to say that this is very dangerous work, but what we also notice is that there are a lot of incidents on oil rigs in Canada. A number of hazardous materials are used. There are burns. There are leaks. There are back injuries, and you need medical assistance, but you're offshore. So a body to deal with workplace health and safety issues on rigs, an oversight body. This is what we want. We want to make sure that workers don't get injured, or if they do get injured, they can come back to their families in one piece. And the oversight of all of this would have been better if there were an independent body tasked with that. Now, these projects, there's more and more of them. There have been 200 exploratory drilling projects in Nova Scotia, 113 in Newfoundland. So on that note, Mr. Speaker, thank you for your patience, and I would be happy to answer some questions from my colleagues. Questions and comments? The Honourable Member for Hochelaga. Thank you, Mr. Speaker. My colleague has clearly demonstrated how important this bill is. It's taken 12 years, and today we're the only ones standing up to speak to this bill and ask questions. What message does that send to workers and Canadians in general? The Honourable Member for Rivière-du-Nord. Well, that's what I was thinking before I made my speech. They've moved with such great haste, and because of that, there's things they don't want us to talk about. And one of those things is protecting workers better. Their real motive is to promote the efficiency of that industry while leaving aside the human dimension. But we in the NDP are the representatives of the people, of the human dimension of people. We want to protect people.
The Honourable Member for Winnipeg North.
Yes, Mr. Speaker, the question is in fact factually incorrect. The NDP are not the only ones that have been standing inside the House today talking about this bill, and nor does the NDP own any sort of moral high road dealing with labor-related issues. At the end of the day, Mr. Speaker, I have indicated on several occasions today that the Liberal Party is very has put a high priority in terms of even the passage of this bill. We understand and appreciate the operating difficulties that many offshore workers have on a daily basis, that we believe that it's necessary, that it should be ongoing to improve occupational health and safety issues. That, in fact, it's the provincial governments that are pushing forward this particular bill that we have before us today. That there's a huge demand from labour, concerned individuals, different stakeholders that would ultimately want to see the legislation pass. This is legislation that has fallen short in certain areas, but I would assure the member that posed the question that the NDP are not the only ones that care about labour and issues surrounding occupational health and safety, and the record will clearly demonstrate that. My question to the member is, in his opinion, where does he believe that this legislation has actually fallen short? Does he believe that it should be held up to continue to improve the legislation?
The Honourable Member for Rivière-du-Nord. Thank you for your question, but the only problem with the Liberal Party is that they were in power for a long time, and this issue has been on the political agenda since 2001. It's just like the bilingual officers of Parliament. This year, the NDP managed to get legislation through that would require officers of Parliament to be bilingual. The Liberals were in power for I don't know how long, 20, 25 years. How is it that they never thought of or managed, did they not imagine that it was essential for those officers to be bilingual? In 2001, if I'm not mistaken, they were still in power when those negotiations were undertaken. They didn't settle this quickly, nor did the Conservatives. The issue of championing worker rights, Canadian workers, men and women in Canada and Quebec, can only rely on the NDP. Resuming debate, the Honourable Member for Rosemont-La Petite Patrie. Thank you very much, Mr. Speaker. I'm very pleased to rise in the House to speak to Bill C-5, which of course does have shortcomings. Some of my colleagues have already highlighted some of them, but in spite of that, it does seem to enjoy some consensus, some support from unions and so on in Nova Scotia and Newfoundland. I'm from a union background, and as the NDP official opposition critic for Labour, I think every step forward, everything that's done to improve the situation of workers, to help them be protected, to protect their health, to work in safe places, all of these measures have to be encouraged and passed. And that is why we in the NDP recognize that C5, despite its shortcomings and weaknesses, is nevertheless a step in the right direction. And we're going to put aside partisanship here. This is March 27th. In a month and a day, it'll be the International Day of Mourning. On April 28th, every year, we commemorate the lives of workers who have been killed at work. It's an important day. It's symbolized by a little bird, the canary, which was used in mines. A canary in a coal mine was used to indicate whether oxygen was lacking. If the canary died, that was a warning, and people got out of the mine quick. I was fortunate enough last year to visit the Springdale mine in Nova Scotia, and I have to admit that there's a reason why the first unions in Canada were formed in mines in Nova Scotia, where people had to work underground on their knees with little hammers. When there was an explosion, if they didn't die from an explosion, they died from they called the Black Death, from the dust, coal dust in their lungs. So that really wasn't so long ago, a little over 100 years ago. So I think we need to continue to work on behalf of offshore oil rig workers to make sure that their work is as safe as possible, because on April 28th we commemorate the lives lost, workers who've lost their lives at work. And it's more people than you might think. In 1993, there were 58 deaths in the workplace. In 2004, 928. In 2005, 1,097 deaths. That's almost 1,100 people in 1 year alone who went to work in the morning and never came home. It's unacceptable. And as lawmakers, we should do everything in our power to set up regulatory and legislative frameworks that prevent that from ever happening again. When 1,100 people die in the workplace in a single year, when you consider that the average person works some 230 days a year, that means 5 people dying each day in the workplace, each work day. They never should have lost their lives just trying to earn a living. So workers on offshore rigs deserve our support. They deserve our support at the current stage for Bill C-5. It's based on 3 principles, which the NDP shares. Health and safety legislation should protect workers offshore oil rig workers at this point. This is a matter of fairness. People working on the land already enjoy certain protections. Offshore oil rig workers should too. Now, it's harder to help someone who's injured offshore than someone who's injured a 10-minute drive from, say, 3 hospitals. But it shouldn't be an excuse. If you work further away from hospitals, it doesn't mean you shouldn't get the kind of medical attention that you need if there's an accident. So workers need protection. There needs to be a culture of workplace health and safety. There needs to be shared responsibilities. The worker obviously has a responsibility to be careful. The employer has a responsibility to avoid dangerous situations, and the government has a responsibility to pass legislation that will require everyone to act responsibly so that when people go to work in the morning, they have every chance of coming home in the evening. That's very important. Unfortunately, this bill is long overdue. We've been discussing this for 12 years. We're glad that progress is finally being made, even though it's at a snail's pace. This should have happened a lot sooner, both when on the Conservatives' watch and on the Liberals' watch. We have a government here today who's tabling this bill. Better late than never. Been a bit of a wait. But they've worked together with 2 provincial governments to try to improve workplace health and safety for offshore oil rig workers. But at the same time, they're undermining protections in their own realm with C4. The definition of workplace danger has been changed so that workers in federal jurisdiction no longer have the right to refuse dangerous work. If a worker's told to work somewhere and they think it's dangerous, if they're afraid they'll get injured, they're supposed to be able to opt out. But in a Budget Implementation Act, the Canada Labour Code was amended to change the definition of the word danger. Now it has to be a serious and immediate threat. Immediate threat means if you're working with asbestos and 20 years down the road you might get cancer, that's not considered immediate. So you can't refuse to do the job. It has to be a serious threat as well. And there's no definition of what serious threat means. There was no consultation with people in the field, be it workers, employers, unions. They just pulled it out of a hat. At committee, we ask questions. What's serious? If I lose a finger, is that serious? Relatively serious? How serious? Which body part that you get injured or lose is considered enough to be serious? We asked, what's the study behind this? Is there a problem with the current definition? We were told that 90% of cases where workers refused on the basis of health and safety were unjustified. We asked to see the documentation. There was none. They based their estimate on internal discussions behind closed doors. That's really compelling. Internal discussions. We said, well, they said, well, we've heard that these claims are unjustified, unwarranted. There might be some abuse, so we're going to tighten the screws. But by tightening the screws, they're putting the lives and safety of workers under federal jurisdiction in jeopardy. And we think it's a shame that on the one hand, the government's moving forward to improve health and safety for offshore oil workers, but on the other hand, for thousands of people, they're compromising their workplace health and safety protections. Even if there's some abuse, even in 80% if there was abuse, that means that in 20%, the refusals were warranted, were justified, and I think that's a shame. If there's any question, there should be an inspector that comes and looks into it. We shouldn't take risks with workers' health and safety. So the NDP will be supporting C5, but I think that recommendation number 29 from the Honourable Robert Wells. He said, "I believe that the recommendation which follows this explanatory report will be the most important in this entire report." Recommendation 29 requires a separate and independent safety regulator to be created, both for Newfoundland and Nova Scotia. And another option, if it couldn't be incorporated into the respective boards, was to have a separate and independent safety regulator, and to have an advisory board with expert advice and so on that would be completely standalone. So, we're dealing with a bill that does make some progress in terms of the regulation, and for once it's in cooperation with the provinces, but there's a missing piece, and that is an independent body, an arm's-length body, to oversee the steps taken. A truly independent body with no connection to government or the industry. We thought that was essential. We think it's a real shame that that wasn't included in C5, but that won't prevent us from supporting it at this stage, but we will be proposing amendments at committee. Thank you, Mr. Speaker.
Questions or comments? The Honourable Member.
Setter.
I'd just like to reinforce the point that both provinces have already given royal assent to their respective bills to enact these changes. The member opposite talked about delays, and I'm asking him to stop the delay now. That we've been waiting patiently, the provinces have been waiting patiently for Bill C5 to pass through our Parliament, so this new regime that will protect workers can come into force. So will the members opposite now allow for this legislation to finally come into force so workers don't have to wait another day without the extra safety measures that Bill C5 will bring to them?
The Honourable Member for Rosemont La Petite Patrie. Thank you, Mr. Speaker.
Monsieur le Président, je remercie ma collègue pour la question.
Mr. Speaker, I'm going to thank my colleague for the question, but I do believe actually the Conservative government has been in power since 2006, and it's now 2014. So I don't think it's really the NDP's fault if this bill hasn't come forward any sooner. If the Conservative government had been serious about it, it would have worked a lot faster to help all workers, and I don't think it was a priority for the Conservative government. And of course, it's not the first time that we see the Conservative governments attacking the rights of people, the rights of union organizations, medium class, the middle class, for example. They're constantly doing that, and I don't think it's the NDP's fault if they haven't dealt with occupational health and safety. Questions and comments? The Honourable Member for Gatineau. Thank you very much, Mr. Speaker. Yes, well, I'm not sure if the member opposite actually listened to my speech, but here we are at third reading. And I'd like to say that I agree with my colleague who just spoke. There have been many situations like this one, whether it be in the area of protection of rights or justice. We were dealing, for example, with Supreme Court rulings and C4. There were two provisions. So I'd like to know what my colleague would say to this. Now, the Minister of Transport is to recommend regulations about safety. There is a lot of material that deals with safety. We know the Conservative government often tries to shirk its responsibilities. What would my colleague say? Well, thank you, Mr. Speaker. It's not because the Conservative government dragged its feet and brought the bill here too late that we shouldn't be taking the time to debate it intelligently. We need to do things properly. So if we have a big bill, whether it's a 300-page bill or otherwise, we need to put the work into it and figure out where it would require improvements. Now, I can understand why the Conservative government wouldn't want to debate this, because it doesn't like to debate. I mean, how many gag orders have there been? 58 since 2012. Maybe there's going to be a 59th. I don't know. Will there be another one? Oh, have we already? I didn't realize, actually. We're already past 60. Maybe we'll end up with 100. Anyway, Mr. Speaker, we think it's important to take the time to discuss, debate, and improve
Time for one short question and response.
The Honourable Member for Brome-Missisquoi. Thank you very much, Mr. Speaker. And I'd like to thank my colleague from Rosemont-La Prairie for his impassioned speech. And I'd like to ask him why the former Liberal government and the current Conservative government is not setting the right priorities in the right places. In other words, workers and occupational health and safety. The former Liberal government and the current Conservative government really tends to focus on profits for big companies and deregulation as well, and the kind of deregulation that led to a tragedy like the one in Lac Mégantic. The Honourable Member for Rosemont, La Petite Patrie. I'd like to thank my colleague for Brome-Missisquoi for his question. Yes, here we have people working in the interests of others, but and it's certainly not the workers. And we have another group working for big oil companies and banks. They've made billions, $34 billion worth of profit. So $34 billion of profit. Well, we're 34 million people in Canada. So each person here in Canada, each senior, each baby should get owes about $1,000 each to the banks, and that's not unacceptable. We're going to work for these people.
Before we go to resuming debate, I see the Honourable Government House Leader is rising on a point.
Thank you very much, Mr. Speaker. I'd like to advise that agreements could not be reached under the provisions of Standing Order 78.1 or 78.2 with respect to the second reading stages of Bill C-22, an act respecting Canada's offshore oil and gas operations, enacting the Nuclear Liability and Compensation Act, repealing the Nuclear Liability Act, and making consequential amendments to other acts, and Bill C-24, an act to amend the Citizenship Act and to make consequential amendments to other acts. Under the provisions of Standing Order 78.3, I give notice that a Minister of the Crown will propose at the next sitting motions to allot a specific number of days or hours for the consideration and disposal of proceedings at the said stages of the said bills.
I'm sure the House appreciates the notice given. And now resuming debate. I'm going to acknowledge the Honourable Member for Sherbrooke. We have about 3 minutes left for comments, and the rest of that time will come back when we resume debate. The Honourable Member for Sherbrooke. Thank you very much, Mr. Chairman. I'm very pleased to rise today, even if I do only have 3 minutes. I will try and be as brief and precise as possible and as clear as possible in the time that I've been granted. I'm very interested in this bill. I'm sure all my colleagues are interested in this bill, although we haven't really heard much from colleagues within the other parties. But the protection of workers is something that often comes up in my discussions with others. It's very important for me. It's important for the people of Sherbrooke. The protection of workers will always be a priority with us. And I'd been speaking with my colleague from Rivière-du-Nord about this, and we were talking about workers who work in offshore conditions and about how difficult that work can be. We are talking about conditions that are very difficult to imagine. We don't see that on land, but these are very dangerous conditions when you're working in offshore areas, hundreds of kilometers offshore. Simply getting to the drilling platforms is already quite a feat. It's dangerous in itself. And then once you're there, you're working in dangerous conditions on the platform. It's dangerous also because of the weather. It can be extremely dangerous. And so it's absolutely essential that we have legislation like the legislation before us today that it overall is positive despite certain shortcomings that my colleagues have already referred to. So I think this is a very important bill. And it's a bill that's the result of exceptional work on the part of various provinces who've been able to agree together on the content of this. It did take a while. Since 2001, work has been ongoing. Now in 2014, we have something. The process was very long. Sometimes discussions with provinces aren't necessarily easy. It's not easy always to reach agreement, especially when there are several provinces involved. But this took 13 years, and I think that was a bit long to end up with a bill. So I'm not certain that this was a priority for the government. They seem to say it is, but I see that I'm going to be interrupted any minute now. And so I'm going to stop now so that I don't anger you, Mr. Speaker.
La députée de Sherbrooke.
The honourable member for Sherbrooke will have 17 minutes when a debate is resumed on this motion. It being 5:30 p.m., the House will now consider private members' business on the order of the day. Private members' business, second reading of Bill C-539, Promotion of Local Foods Act, in the name of Ms. Quach.
Madame Quach, appuyée par
Ms. Quach, seconded by Ms. Brosseau, moves that Bill C-539, an act to promote local foods, be now read a second time and referred to the Standing Committee on Agriculture and Agri-Food. Debate. The honourable member.
C'est beau pour les malous.
The honourable member for Beauharnois-Salaberry. Thank you very much, Mr. Speaker. And thank you so much. I'm so pleased to rise today to be able to finally speak to my bill on local foods. This is a bill that I have been working on for a good 2 years with help from throughout the country, with contributions from throughout the country, from producers, from many people who have truly inspired me. And my own leader, Jack Layton, my first leader actually, Jack Layton, really inspired me. And I worked for a long time with the member for British Columbia, and we worked on this pan-Canadian strategy that didn't exist, and I hope now it's going to exist. I was also supported by other members, the member for Masquinongé and the member for Welland as well. Why is it so important for the NDP to support producers and support local food? Well, our producers work the land. They produce the food that meets one of our essential fundamental needs, and that is to be able to eat 3 times a day. So it's fundamental. And producers, agricultural producers, are rarely acknowledged for all the work that they do. This is very demanding work. This is work that requires considerable time, energy, and investment. And yet they do it with passion. They do this with their own hands. And it should be supported on a daily basis by the federal government, as provincial governments do, and as municipal governments should also do. Now, I became aware of this, that is to say, the lack of support for producers, because my riding is mainly rural and agricultural. So I have 29 out of 31 municipalities that are rural in my riding. And one of the first things that I did when I was elected as a member of parliament was to go and meet local people, local stakeholders, and so, of course, I met many producers. And I learned about this circuit in Quebec that people can follow to discover local businesses and local producers. So whether you go to restaurants or hotels or to farms, you can do a sort of stop-by-stop circuit throughout various ridings and learn about and even taste products, whether they be produce, whether it be meat, whether it be wine. And so it's then that I started becoming more and more aware of how important it was to acknowledge the work of these people. And I also became aware of the importance of buying locally when I realized that I myself didn't even know which products came from nearby and which didn't. I didn't know that I could find, whether or not I could find local produce in my own grocery store. So there are many things that I discovered by having conversations with producers and by having conversations with citizens, people of my own age, older people, young people. And I started asking them questions. Where do you think the food that we eat comes from? And many children said, well, it comes from the grocery store. Well, it doesn't come from the grocery store. There are people who've worked hard to raise either the food or the animals before it gets to the grocery store and before it gets to our plates. So it's funny, but at the same time it's a little sad because it speaks to how little information that we actually have. And I would like to see this bill become legislation so that producers can really become acknowledged. When you go to the grocery store, more and more people now try and find what the origins of the food they're eating. For example, does the apple that I'm buying come from Chile or does it come from my riding? Has the apple traveled 10 kilometers or has it traveled 30 kilometers or 10,000? It's not just an economic impact that this choice has. It's also a health impact. There's produce that meet certain standards that are produced here, and there's produce that comes from elsewhere that meets different standards. But there's also the whole environmental perspective that's important. So buying locally means buying produce or meat that has been produced by people who are nearby. It may seem like a very simple thing, but there are many barriers to purchasing locally. It's very difficult for producers to have contact with consumers. Now, there's the cost of transportation, for example. Before fruit and vegetables come out of the orchard or they come from the farm, well, they have to be loaded into a truck or a boat or whatever, and that costs money. They also have to be labeled. That costs money. There are problems with transportation networks as well. There are several organizations that have started setting up public markets, public drop-off points, so that people can buy, for example, baskets of local fresh produce. But there's a lack of awareness amongst the public. And one of our realities here is that we have a long winter. And therefore, producers can't necessarily provide constant supply throughout the year to big grocery chains, and therefore it makes it more difficult for them to have access to that market. We need to think about that. And the federal government also needs to make more of an effort in awareness raising in order to make sure that people know what is growing here, what is growing in their region, when it's growing, and also so that consumers can know during the winter what one can still buy. So even if those farms aren't necessarily operating, it's good to know what can be purchased. So there's a lot of information that our public needs. There are people who've been writing me, emailing me, that I've been having discussions with over Facebook. And I'm being told that they would like to be able to encourage and support producers, but they don't know where to begin. They don't know who to contact or where to go. Now, groceries are making more and more of an effort, or grocery stores, rather, are making more and more of an effort. But there still is a lot of work to do. There could be places, for example, in public markets, in convenience stores. There could be more areas where producers could bring and sell their produce. Because currently, it's not straightforward. It's very difficult, for example, for seniors to go to points that are further removed in order to be able to purchase local food. So it would be nice if they had some sort of drop-off point in their area where they could buy that meat and produce. Seniors are vulnerable, their health is vulnerable, and they should be eating fresh, healthy produce. But they often tell me that they don't, because of the reasons I mentioned and because it's expensive. Now, is it normal that 2 liters of Pepsi cost less than, for example, 1 liter of fresh juice? So actually, a junk food is a lot less expensive than a healthy food. And when healthy food is local food, why is it that it's still more expensive? We need to intervene. We need to support everyone to eat well, and for producers to be able to provide that access to their produce. Now, despite these barriers that I've described, more and more Canadians are buying locally, and they want to encourage their local producers. Why? Because it's good for their health, and because producers have a huge contribution to make. Producers actually contribute 8% of GDP each year. That's 1 job out of 8 in Canada. That's the equivalent of $101 billion per year. So just imagine if each and every person were to take $5 each when they do their groceries to buy locally. That's money that goes local. And a local producer actually in our area said if you simply take $5 within your groceries, $5 worth of your groceries, and you spend it locally, that allows a producer actually to make a living and not simply survive. And it also creates more opportunities for consumers.
And we know that since 2006, some 8,000 farms have had to stop their operations because of problems, and they are having trouble finding farmers of the future as well, because the ground is very dry, it's an arid continent. Now, we need to do something with the situation. The federal government needs to take action to help farmers and producers. Now, I could continue saying that this bill is a result of 2 series of consultations with producers, distributors, and people who've worked on food policy across the country. Now, I could talk about the consultations. I don't want to mention everyone, but I consulted nationally and locally with the Canadian Federation of Agriculture. It has our support. The UPA, the Coalition for Food, several retailers, the large grocery chains, and many members of the general public who've responded to the call and said, yes, it is very important. My bill has 2 parts. It requires the federal government to establish a pan-Canadian strategy in conjunction with the provinces. We want the federal minister to sit down with his provincial and territorial counterparts, and also with the farmers and distributors, to have all of these people around the same table to discuss a common definition of local. All of the provinces have a bit of a different definition of what that means. We're also calling for the setting up of a tribunal or a forum where they can exchange best practices, because each province focuses on certain aspects, but producers aren't necessarily aware of what could be done and what's effective. So it would make them aware of tools available to them. So it's important for people to have an opportunity to sit down and to have these discussions. Secondly, we would call on the government to set the example by establishing a local supply chain for its federal institutions, agencies, federal hospitals, prisons, etc. 28,000 cafeterias that could provide an opening or make a larger, or more room, in fact, for producers, and that too would make a huge difference. So I hope we'll make it that far and do that, because it's part, if you will, of clear political will by the government. Producers need assistance overcoming a number of challenges. First of all, labor is very difficult to come by, because agriculture is difficult manual labor, working over specific periods of time, and so we need to make a distinction there. And if we don't buy local, then who will? We really need to focus on these aspects. In Canada, there are already more than 2,300 local initiatives that to which the government could contribute to promote them and to help spread them to the rest of Canada. This is important. For us, it's important that the federal government do its share as well to encourage farmers to be innovative. Things are difficult at present because they're having such trouble simply surviving in many cases. For them, producers to be able to continue to making changes to reducing our environmental footprint as well, we need to support them in their work. And I think that this kind of national strategy would be very worthwhile. So I hope that all members will support me and vote in favor of this bill. Thank you.
Questions and comments? The Honourable Member for Sydney Victoria.
Mr. Speaker, and I really appreciate the member for coming forward with this bill. It's a very good bill. As a farmer and a big proponent of local produce, I think it's a very good bill. I have some questions. I realize that the minister has to engage and has to talk to his provincial counterparts, which is very important. But in order for this bill to succeed, I mean, we have to be talking to all institutions, but especially the grocery stores. I mean, we have only 2 or 3 chain stores in this country, and almost 80% of people buy their products from them. So I'd like to ask the member, what is she going to do, or what does she suggest that the minister do, or this government should do, to put things in place that we're going to make sure that the grocery stores follow suit and they're involved with the process to make sure that her bill is successful?
The Honourable Member for Bourg-en-Bresse-Salaberry. Well, thank you very much, Mr. Speaker, and I'd like to thank my colleague for his question. This will require the government to sit down with provincial counterparts, with distributors as well, and there are already several buy local policies in place in the large stores, chains, grocery chains. They're looking for more opportunities to sit down with us to establish better practices, to help enhance the marketing of local products as well. Now, producers are very keen to sit down with these people. They're very impatient to do so. Now, I spoke to the Canadian Federation of Agriculture, to the UPA, to many other people in the field who are simply waiting for an opportunity like this, to have a meeting, for it to take place so that we can move forward on the issue and put in place some guidelines, some clearer guidelines, because there isn't anything in that regard at present. So they're eager to get down to work on this. Questions and comments? The Honourable Parliamentary Secretary to the Minister of Agriculture.
I'd like to bring to the members' notice that there is such a thing as an agreement on internal trade, and that AIT, or an agreement on internal trade, applies to all food procurement that exceeds $25,000, and it requires that the federal government not discriminate against Canadian suppliers. So I'm wondering if you could comment on how her bill would conflict with the agreement on internal trade. Thank you.
The Honourable Member for Beauharnois-Salaberry. Well, thank you very much, Mr. Speaker. As the member just said, there are some thresholds established for amounts over $25,000. Now, I asked a question to Public Works and Government Services Canada, and there are several contracts that have been awarded for food products by the government. In 2012-2013, there were 9 contracts awarded for a total of $112,000, slightly above that amount. So that isn't, they haven't hit the maximum. So there are 9 contracts under that $25,000 amount. So I think we could increase the number of contracts under $25,000 because that will respect the $25,000 threshold. So I think that we can continue along those lines. There are many governments in the world that are currently doing that. Several governments in the U.S., the EU, other non-EU countries, Nova Scotia, or Scotland rather, and I don't understand why Canada wouldn't help its producers. Questions and comments? The Honourable Member for Saint-Lambert. Well, thank you very much, Mr. Speaker. First of all, I'd like to congratulate my colleague for her bill. On her bill, in fact, it is an excellent initiative. Now, she alluded to a number of different things. She talked about health, public health. As she mentioned, we are in a time where there's a lot of junk food being consumed, and we're seeing the impact of poor eating habits on young people and others as well. I think it's important to point that out here in the House. I'd like to ask her about her bill and about some of the aspects it contains. I'd like her to talk about the economic benefits and the importance of these products, agricultural products. Now, people are increasingly moving to the cities. I'd like her to tell us how this bill will focus on the economic components of rural areas for producers. The Honourable Member for Beauharnois-Salaberry, a short reply, please. Thank you, Mr. Speaker, and I'd like to thank my colleague for her question. And this bill, through the federal contracts, this will help to make local products more readily available and also help producers. This will help small family farms, for example, and it will have a product to help to create product for the markets and the stores, etc. This will contribute to the health of Canadians as well by trying to distribute more healthy products through the system.
The Honourable Parliamentary Secretary to the Minister of Agriculture.
Bon, merci, Monsieur le Président.
Thank you very much, Mr. Speaker, and I'd like to thank the member for Beauharnois-Salaberry for raising this important subject of locally grown food. Canada, I'd like to say, is an extremely fortunate nation. We have vast dynamic industry that can meet the needs of local, national, and international customers. We have an agricultural sector that provides jobs to 1 out of every 8 Canadians and contributes to the health of our economy. As a Canadian, we can certainly say that we're very lucky.
The government recognizes the good intentions of this bill.
However, in a practical light, we question if Canadians would truly support legislation that would only add a layer of bureaucracy to the local food movement, a movement that is already succeeding in many regions across Canada. Do we really want to add red tape, regulations, and complications to our farmers' markets, community gardens, and co-ops? And do we want to compromise the livelihoods of farmers who depend on international markets to sell their crops? And the answer is no, Mr. Speaker. Across different levels of government in Canada, there is already strong support for locally grown food. Our approach at the federal level is to focus on national efforts to increase consumer awareness and knowledge of Canadian agriculture. For example, through funding initiatives like the Farmers Markets of Canada, a national organization representing farmers markets across the country. While our government wholeheartedly supports the purchasing of locally grown food by citizens and residents, we recognize that provincial governments have a key role to play in defining what local foods are. And we will continue to work with interested provinces because we are committed to keeping the playing field fair by not favoring one farmer over another or one region over another. Together, we want to break down the internal barriers to trade in this country. The bottom line, Mr. Speaker, is our government will ensure that farmers who market locally have the same opportunities as farmers who export to world markets. And in fact, Mr. Speaker, many farmers do both. So while the idea of a pan-Canadian strategy on local foods is well-meaning, we must remember that trade accounts for a large portion of our farmers' sales. Canadian farmers export to 189 countries around the world. Our agriculture and food exports have been on a growth curve for a number of years. For 2013, all signs point to another record of close to $50 billion. However, Mr. Speaker, trade is a two-way street. That's why we have to be very careful about federal policies that legislate local foods and about rules related to government procurement as advocated in this bill. We can't expect our trading partners to play by the rules if we aren't prepared to do so as well. Canada has made a commitment to follow the non-discriminatory rules contained in various multilateral and bilateral trade agreements. For example, the North American Free Trade Agreement requires Canada to treat suppliers of our trading partners no differently from local suppliers. The problem with this bill is that the proposed measures could be inconsistent with Canada's international commitments, and this would send the wrong message to our trading partners. Our government understands the need to respect our international and interprovincial trade obligations because we need to keep markets open for Canadian agricultural products. Mr. Speaker, our government understands that trade is important, and we understand the needs of farmers. And that's why through our cost-shared programs under Growing Forward 2, we are empowering the provinces and territories to support locally grown food through market development initiatives in their jurisdictions. Our commitment to farmers and our investments in science are helping to ensure that Canada's food comes from the best farming practices right across the country. For example, in Quebec, our researchers are currently working on helping farmers meet the emerging demands for foods with probiotic benefits. In Atlantic Canada, we're developing more varieties of value-added crops such as short-season soybeans. New varieties like these could increase farm revenues by an estimated $100 million. In British Columbia, field and lab studies are helping to minimize the environmental impact of nitrates in surface and groundwater. Groundbreaking research is helping to protect the environment while maintaining optimum crop production. Work is also underway to build upon the challenges of producing food in the north, and this means developing traits that can thrive in colder climates and creating new economic opportunities all the time. In Yukon, for example, our investments are helping farmers to sell their products by promoting local food production and increasing public awareness of Yukon-grown food. Our government has also partnered with the province of British Columbia to deliver a pilot project that will give ranchers the opportunity to process and market their beef locally. This will bring more dollars into their business while boosting the local economy and respecting our international trade obligations. Monsieur le Président, les gouvernements provinciaux.
Mr. Speaker, the provincial and territorial governments have a direct role to play in initiatives designed to support, promote, and to market local food products. Many provinces are putting in place strategies for local production, namely Ontario, which has recently adopted an act dealing with local food products.
The need to draw up a national strategy was not a major issue at federal, provincial, territorial meetings. In truth, a cross-Canada strategy could be seen as federal interference in provincial or municipal affairs. Bill C-539 would also undermine Canada's credibility internationally. It's to be expected that if we don't enforce the rules, our trade partners will. That's why we have to be very careful when it comes to policies that promote local food production or restrict government procurement, as this bill advocates. The North American Free Trade Agreement, as well as other international trade agreements, require Canada to treat providers from its partner countries the same way as we treat local providers. At the same time, we are ensuring that our trade partners follow the rules. We also, given all of the above, we respectfully refuse to support Bill C-539. Thank you.
Please.
Resuming debate.
Resuming debate, the honourable member for Sydney, Victoria.
Mr. Speaker, and it's, I guess I'm not shocked that the Conservatives are against this bill. I mean, well, I am shocked, Mr. Speaker, because what better bill could we have for farmers and for consumers in this country? I mean, and for the parliamentary secretary to say, you know, well, we're doing this, and you know, I'm not saying that some of the initiatives for local produce is not good of what the government's doing, but I think we can't be just cherry-picking certain areas. I think what we're looking at in this bill, and if I can state from the honourable member over here, is that we're looking for more of a Canadian strategy and working with the provinces. And I really, what gets me is when the Conservatives are saying, well, other countries might get angry with us or might call it a bit of a barrier. And I just have some articles here out of the U.S., and here's some of the programs the United States has. And one of the programs first comes up is, it's called Know Your Farmer and Know Your Food Initiative. And this is right out of the United States. One of these trade partners are going to have a big problem with us promoting local food. And it says in 2009, USDA launched the Know Your Farmer, Know Your Food Initiative, an agency-wide effort to create new economic opportunities by better connecting consumers with local producers. As part of the initiative, several funding efforts and programs were announced to assist farmers, help consumers access nutritional food, support rural community development. Well, America's going to be really mad at us for this one. And here's another program here that the USDA has in the United States. It's called an Agriculture Marketing Service Program. USDA's Agriculture Marketing Service Administration's several grant programs supporting local food initiatives across the country. The Federal State Marketing Improvement Program provides matching funds to the state agencies to assist in exploring new market opportunities for food and agriculture products and encouraging research to improve the performance of food marketing systems. In 2009, 8 out of 23 grants were awarded to projects supporting local foods, such as the funding from the Colorado Market Maker. So that's how I'm just going to start off. And I know they're getting a little wound up there, Mr. Speaker. If you can keep them quiet down a bit, and maybe they're surprised that I'm supporting an NDP private member's bill. But you know what? When the bill is good, we have to support it. And I think, you know, and I'm surprised with the members over there. I know they know it's a good bill. It's pretty bad. This must have came out of the PMO, or I don't know where it came from. But let's not get into that, because what does the bill ask for? I mean, it asks for improving access to high quality and fresh products, reducing greenhouse gas emissions. Well, I don't know if the Conservatives are for that, but that's what it's in there. The bill recommends a pan-Canadian local food strategy, constitutes a local food program, and it also wants to have local foods bought at institutions. Now, but I think, that being said, let's just talk about the institutions, because as a farmer, and I've sold to them before, and I think what needs to happen here, if this bill is going to be successful, the government has to help farmers develop products that are, you know, that the right size packaging, the labeling, you know, distribution systems. So it takes quite a bit to pull this off. So, and I think it's very important that they work with the provinces to make this happen, especially if you're going to have local products going into the federal institutions of any sort. Another great avenue is that's taking off not only in our country. I was in New Zealand, Australia. You know, farm markets. And farm markets, and I got a brochure here from the Canadian Farm Market Association, and they're talking about $3 billion of revenue. Now, the Farmers Market of Canada is a national organization dedicated to furthering the valuability of growth and prosperity for the Canadian farmers' markets. In 2008, the Farm Market commissioned a national study to help the Agriculture and Agri-Food Canada to take the pulse of farmers' market industry in the 10 provinces and measure its importance to Canadians and Canadian consumers. Now, one of the most important findings was the value consumers place on being able to buy food directly from the farmer who has produced it. Well, 92% of the shoppers related its importance, and 62% said it was extremely important. Now, the farm markets, as many of you know, it's hard for them to stay open year-round. I mean, and I'd like to talk a little bit about the one we have in Cape Breton. You know, the one in Cape Breton we have, it's called Cape Breton Farmers Market, and it's a non-profit cooperative that's been in operation for almost 30 years, and it's evolving. It started as an outdoor seasonal market, and now it's an indoor a market which attracts thousands of visitors weekly from all over our island. And I'm proud to say, Mr. Speaker, my dad and I were some of the first vendors 30 years ago. We sold eggs and chicken and fresh produce there, and now look at it. But what I'm bringing the attention of our own farmers market, which are thousands across this country, and I think we have to help. I think this private member's bill will help those farmers markets, and we have to have more resources for those small farmers. If they're making jams or jellies, if they're value-added products, they're going to need some sort of help there. But I think this could all stem from this private member's bill, and I think when you look at our food security, you know, we talk about oil security, but food security is so important. We have a big country. Look at this year alone, like how the food, you know, how propane was disrupted by rail, how the grain was disrupted. How important it is to have more local food. Now, we can't have all, you know, we don't expect that we have the same food year-round locally. I mean, we like to have berries this time of the year. They might have to come from Chile or whatever. But I think it's important that when we have those foods locally, that the farmers have the opportunity and to be able to sell it locally, and that not only that, that the people, the stores, will have the opportunity to buy it. There's a couple things here, like there's 28 million shoppers that visit farm markets. The average purchase price per shopper at a vendor is $32. The average small farmer at these farm markets generates 1 to 5 jobs. The numbers are pretty big when you look at those farm markets. But I think we also have to look, and I mentioned it before in my question, is the grocery store business. And recently I visited a store in Boston, and it was called Bread and Circus. And when you went in the store, if you picked up a bag of carrots and you swiped it, not only told you the price, up on the screen it would tell you exactly the farmer that grew it and the people working on the farm, how they distribute it, if you bought a head of cauliflower. And it was an example that I think that we should encourage our own stores to do, where, you know, anybody, you take a younger person, a child that's in a grocery store, you know, they'd like to know exactly where the products are from. And I think once they know more, I think it's the advantage of not only the consumer, of course, but the farmer and the grocery stores. But this bill, it's only the start, Mr. Speaker, and I think we have to have a Canadian approach. And I know the Conservatives get kind of, you know, they get squirrely when you talk about a national strategy about anything. A national strategy, oh my, we can't have a national strategy. No. But you know what? I think. No, but Mr. Speaker, I think this is something we should be bringing up probably at our Agriculture Committee. We should be looking at it. And I think, you know, every member in this House must have a local farmers market in their own community. How much time do I have, Mr. Speaker? 2 minutes. Oh, I got 2 minutes.
Not enough.
Not enough time. Think of all the products. Think if you're in the Okanaga Valley, and I see the member up there right now, and it's not just fresh produce. We're talking about wines. You talk about new types of wines in Annapolis Valley now. a farmer's market in Annapolis Valley. You go into liquor stores now. So it's more than just food. I mean, you take it, the wine industry, how much potential is there if we label it right, if the store shelves in the grocery stores or in the liquor stores have it labeled right. And I think, you know, this bill is more than just for farmers. I think it can also help people who, for local fish. Our local fish, we're from the East Coast, beautiful fish. And I think it's important, though, we have to look at the kilometers on it and how far away local means. But I know in Cape Breton, where we have people come visiting us from right across this country, and many of my members, even the Conservatives, come visit my riding, and they didn't want to leave, but they for various reasons. But you know, when they visit, and whether it's going to a restaurant or going to a farmer's market, they want to taste the local food. And whether it's produce, or whether it's fish. And I think, but we have to do more than just this bill. We have to have the resources there for farmers to be able to produce the right type of products for the grocery stores. And, you know, what's also very important, Mr. Speaker, is safety. And I think a lot of small farmers sometimes can't afford all the tools that they need for biosecurity and safety of food. And I think we have to help them, because they'll expand and they'll produce more food. So thank you for the time, Mr. Speaker, and I also commend the member for her bill. And I wish the Conservatives will come to their senses, and when the time comes to vote for this bill. It's very important for farmers.
Reprise de débat. Resuming debate, the Honourable Member for Berthier-Masquinongé. Thank you, Mr. Speaker. I'm really proud to rise today in the House to support my colleague's bill. I'd sincerely like to congratulate her on all her work, all her dedication. And it's important to have this debate today because we have a lack of vision in Canada right now in terms of agriculture and buying local. So this bill would call on the federal government to implement a pan-Canadian local food strategy and require the development of a policy to encourage government institutions to purchase those foods. The main goal is to promote local foods and to encourage Canadian farmers. When I meet with people in my community at farmers markets in the summertime, they talk to me about their growing interest in local products. When I do the groceries, I also look for local products because I want to support what's produced here. When I purchase locally, I feel like I know where the food's coming from and like I'm encouraging local farmers, and I get great satisfaction from that. It's also something that I try to share with the family and especially my son. In Canada, there are a number of initiatives, including Farm to Cafeteria, which is a not-for-profit organization in BC that has been working for 10 years to create and support local purchasing projects by local projects in public and private institutions. Most supermarkets already have buy local policies to promote local products. In addition, the number of farmers markets is growing, and their presence in urban settings plays an essential role in promoting local produce. For example, Metro supermarkets have a buy local policy, and their initiative has been a huge success. I worked together, for example, with Chef Justine to do a vegetarian chili demonstration at one of the farmers markets in my riding. There's also Goûter la Naudière. This brings together producer groups in the La Naudière region, and so that consumers can easily get to know them and recognize them, and I think that's great. Buying local doesn't just encourage regional sales, but it's also a way to reduce greenhouse gas emissions. It's a way to consume fresh produce because the produce hasn't traveled great distances through warehouses, trucks, and refrigerators, and so on. It supports the local economy and keeps both direct and indirect jobs here for Canadians. It allows consumers to discover the whole vast range of products that are being grown and processed here at home. These are good reasons why I strongly believe the federal government should work with the municipalities, provinces, and territories to help farmers and consumers find the products they want without having to travel far. The provinces are well ahead of the federal government when it comes to promoting buy local. Many provinces have already devised programs to support the marketing of local products in cooperation with industry. Ontario, Terre Nourricière, Aliments du Québec, Buy BC, these are the oldest and best known. Unfortunately, there's no federal policy to promote buying locally. But the federal framework, Growing Forward 2, provides for shared funding for various agricultural programs. In 2013, Quebec set up a program partially funded by the federal government, which encourages buying local. The program's called Proximity. This buy local policy encourages hospitals and other institutions to buy local. I think federal institutions have a role to play in local produce, and I'd love to be able to eat local here at the cafeteria in Parliament, because eating local, it's good for your health. The government of Canada has to set an example. Two examples come to mind. Last summer, the National Assembly in Quebec decided to get into this business. They replaced their flower beds with vegetable gardens, and they put in beehives on the roof to produce honey. This was an ambitious project which is unparalleled elsewhere in the world. With 2,000 square feet of crops and 130 varieties, these gardens were used to serve customers at the National Assembly's restaurant, and any surplus was given to charity. According to the research, the Quebec National Assembly was the first parliament to go that far in terms of growing local. A long time ago in the United States, Eleanor Roosevelt, during the Second World War, launched a similar project with the White House's gardens. This initiative had fallen into disuse, but Michelle Obama resuscitated it. And these are very inspiring examples, the Quebec National Assembly and the White House. And it seems to me like a country like Canada should have the means to support this kind of initiative, to be at the leading edge and to set a good example. I believe in the importance of creating farm networks with retailers so that Canadian produce makes it onto the shelves of our grocery stores. This bill is in keeping with the NDP's commitment to promote sustainable development. Buy local means reducing transportation and at the same time greenhouse gas emissions, which contribute to global warming. It's crucial to cooperate with producers in order to promote a better understanding of these issues and to increase transparency around what food winds up on people's tables. I'd like to raise an important issue for consumers, and that is price. We know that in Canada, our food is relatively inexpensive. On February 7th, we celebrated the day on which the average Canadian had earned enough money to pay for their groceries for the entire year. There's often a myth that local food is more expensive than imported food. A study was done to see if this was in fact true, and the researchers found that when it comes to seasonal produce, they're usually the same price and sometimes even cheaper. This means that buying local is beneficial to the consumer both in the short and long term. Not only does the consumer get local products cheaper, or at least affordably, the consumer is investing in the community. In some cases, local produce may be a bit more expensive. As the assistant critic for agriculture, I try to find ways to support and promote things that will help farmers through direct sales. This is advantageous both to the consumer and the farmer. we're often talking about initiatives and social undertakings. The farming industry as a whole can benefit from things that will reduce obstacles to the purchase of their goods. A number of stakeholders have told me that they'd like to see us do more along the lines of this bill, and they want to see more leadership coming from this government. I think this bill, coming from my colleague, is a step in that direction, and that's why I support it and congratulate my colleague on her initiative. We've already heard some positive feedback from the Liberals, so we're just waiting for the other side of the House to chime in, and I would encourage them to listen a little more closely. And once again, congratulations to my colleague.
Resuming debate, the honourable member for Lambton, Kent, Middlesex.
Thank you, Mr. Speaker, and I pleased to rise today and for the Honourable Minister of Agriculture to underline, quite honestly, our government's commitment to a number of things, but first of all, to protect the livelihoods of farmers who depend on international markets to sell their crops, and to share our support for the purchasing of local grown foods by citizens and residents of this great country of Canada. Buying local, quite honestly, is an excellent way for consumers to enjoy safe and delicious and high-quality foods that Canadian farmers produce. It's a great way to support our hard-working family farmers. Closer to home, the better. However, Speaker, it is also important to note that there are clear roles for federal, provincial, and territorial governments. And in this respect, and that's a primary reason why our government cannot support this bill. Provincial governments, for example, have a key role to play in defining what local food is. Federally, our government's approach to locally grown foods focused on national efforts to increase consumer awareness and knowledge of Canadian agriculture and agri-food, not unlike what my colleague from across the way was talking about. We're also mindful of Canada's growth and growing ethnic diversity and consumer interest in specialty foods imported from countries like Asia, Africa, and Europe. Equally important are Canada's commitment to under various multilateral trade agreements. Canada is obliged not to discriminate, I should say, against food imports from our international trade partners. This is critical when you consider that almost 50% of Canada's agriculture production is exported. Canadian farmers and processors, we depend on trade, and they benefit directly from increased access to international markets. Our government understands this. Our Prime Minister, our Minister of International Trade, and in fact our government are pursuing the most aggressive trade agenda in Canadian history, and that is to help the agriculture industry continue to grow and to continue to prosper. Canadian farmers are amongst the best in the world, and the impact on agriculture and our economy cannot be overstated. As a whole, the sector employs 1 in 8 Canadians and represents 8% of our gross domestic product. 2012 Canadian agriculture and agri-food sales totaled, that is for export sales, totaled nearly $44 billion. Our government's goal always has been to set the right conditions for farmers and processors to compete and then be successful. One important way we're doing that is through Growing Forward 2. Nobody seems to mention that, but it is a significant tool that is agreed to by all the provinces and territories. And it's Canada's new agriculture policy framework. GF2 is what it's called, is driving innovation and long-term growth in Canada's farmers and processors. In addition to a generous suite of business risk management programs, federal, provincial, and territorial governments are investing more than $3 billion over 5 years to support innovation, competitiveness, and, yes, market development. This includes nearly a 50% increase to those provinces and to the territories for program delivery. GF2 gives provinces and territories the flexibility, Mr. Speaker, that they need to invest to meet local needs. It gives them the tools to ensure farmers can remain competitive and capture new and existing markets, which include, of course, markets for local food. For instance, in Quebec, $5 million in GF2 funding has been targeted to developing local markets. The initiative is called Program Promaxite and encourages farmers to take advantage of the business opportunities that, yes, local markets provide. In Ontario, the province is funding a new initiative that is to support the expansion of the Eat Local Sudbury Co-op. The co-op aims to deliver local grown food throughout northeastern Ontario, which is great news for farmers and consumers across the region. Also under the GF2, the Yukon, for example, and we don't often think about the Yukon as local foods and growing in agriculture, but they're using funds to get a wider variety of farm products into farmers' markets and restaurants and onto store shelves. An example in New Brunswick, market development, product enhancement, and diversification programs, again under the GF2, supports farmers' efforts to capture new markets, be it local, national, or global. These are just some of the examples how, going forward too, investments are helping to grow local markets for farmers across this great country. Mr. Speaker, the provinces and territories are getting local food initiatives off the ground. The wheels are in motion, and imposing a pan-Canadian strategy for local food would very well bring any progress they've been making just about to a screeching halt. Going forward, too, is that vehicle in an exciting step forward and is serving the agriculture industry well. Its strong focus on innovation, market development, and competitive will position Canadian farmers and food processors for growth and prosperity in the years to come. With its built-in flexibility, Going Forward too supports the diversity of markets available to farmers today. The world's population is on the rise. There is an increasing demand globally for high-quality and sustainable food supply, and our global customers appreciate quality and consistency of Canada's food and agribusiness products. Opportunities for our farmers and processors, they continue to grow, Mr. Speaker, and we need to be ready to seize those opportunities. We must keep expanding our customer base, ensuring more of our great Canadian foods reach more consumers across Canada, and those including in local markets, but also around the world. In short, we must produce locally and think globally. At the federal level, our job is to look at the big picture and the longer term. We're committed to ensuring farmers and the entire sector have the tools and resources that they need to stay ahead of the never-changing demands that consumers want. That's what we are making strategic investments through the Going Forward too in the new agri-innovation, agri-marketing, and agri-competitiveness programs. For instance, through the agri-innovation, we're investing to help turn traditional crops like mushrooms, and grapes, and flax, and buckwheat into new revenue streams for farmers. Through agri-marketing, we're helping to develop and enhance new markets for Canadian-grown oats, livestock, and grains. And these are just a few of the examples, Mr. Speaker, of the great things happening to support our farmers thanks to the flexibility of the Going Forward 2 program. Again, our government recognizes the value of local markets. They're an important part of the big picture. Federally, our goal and our role is to ensure our farmers, processors, and our exporters are strong today and that they remain ahead of the competition well into the future. This has been our focus from day one, and it's not negotiable. So I invite my honourable colleagues to continue to acknowledge the roles that governments play in supporting farmers' participation in all markets, those markets whether they're local, national, or global. Let's also continue to support the great local initiatives taking place in the provinces and territories thanks to the flexibility afforded by the Going Forward 2 program. And Mr. Speaker, let's continue on the path we have in place, one that's based on consultations with farmers themselves, because that is what Going Forward 2 is about. Mr. Speaker, respecting the voice of farmers and processors and promoting our great Canadian agriculture industry here at home and around the world. Thank you very much.
Order. The time provided for the consideration of private members' business has now expired, and the order is dropped to the bottom of the order precedence on the order paper. In accordance with Standing Order 38, a motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn. The
Honourable Member for Alfred Pellon on public safety. Thank you very much, Mr. Speaker. Mr. Speaker, on November 28th last, I asked a question about our correctional system that is facing major problems regarding the rehabilitation of Canadian inmates. The question was about the report of the correctional investigator, Howard Sapers. The report showed that a large number of visible minority inmates, for example, Aboriginal inmates, were being released from prisons without having had access to programs or the rehabilitation that they absolutely needed. The minister claimed at the time that there was nothing to fear and that current programs were perfectly sufficient. Well, I do not agree, Mr. Speaker. This Conservative government continues to ignore the harmful effects of its Safe Streets and Communities Act. In establishing mandatory minimum sentences and harsher sentences for young people, the Conservatives have created a real crisis. Prison populations, has dramatically spiked. This is an acknowledged and documented fact. Aboriginal inmates and visible minority inmates are overrepresented in Canadian prisons. Amongst Aboriginal communities, the inmate population has increased by 46%, and they now represent 1/4 of all inmates, even though they only represent 4% of the Canadian population. For Aboriginal women, the numbers are even more dramatic. There has been an increase of 80%. In fact, approximately 1/3 of incarcerated women are Aboriginal, even though they only represent 5% of women in this country. Amongst visible minorities, the situation is also quite worrisome. The inmate population of blacks, of those with Hispanic, Asian, or Indian origin has increased more than 75%. The population in prisons of Afro-Canadians has increased by 90% since 2003. In his damning report, Mr. Sapers gave details about this cultural transformation within our prison system and suggested that the federal government establish a correctional policy that was easier to understand and more adapted to these groups in order to foster their rehabilitation. For example, by introducing programs that were tailored to their cultural needs, by hiring multilingual staff, and by placing ethnic liaison agents in Canadian institutions. Despite the urgency of the situation, the minister was scornful regarding these recommendations. He obviously needs a little reminder. Rehabilitation is one of the two main objectives of incarceration. If this government is truly committed to making our streets and our communities safer, then it has to reduce the risk of reoffending. Our priority should be to make sure that we have a correctional system that can deliver effective rehabilitation programs. Aboriginal peoples and visible minorities have the right to programs that are tailored to their needs, that take into account their identity and their community reality. It's not by further isolating them that we are going to guarantee their reintegration back into civilian life. On the contrary, the lack of action on the part of the Conservative government condemns them all too often to a botched social reintegration and to reoffending. These individuals are left to them. If these individuals are left to themselves, they will end up with the same problems that brought them before the courts in the first place. And this is a waste of public funds, Mr. Speaker. Now that the minister has had several months to digest the numbers in Mr. Howard Sapers' report, does he understand the extent of this crisis? Thank you, Mr. Speaker.
The Honourable Parliamentary Secretary to the Minister of Public Safety.
Thank you, Mr. Speaker. Mr. Speaker, unlike the NDP, who time after time raised the issue of increasing rights for prisoners, our Conservative government is primarily concerned with the rights of victims. The NDP has in fact voted against giving victims more information about criminals convicted of victimizing them, ending early parole for white-collar fraudsters like Earl Jones, and, Mr. Speaker, even they opposed and voted against my own private member's bill that stopped prisoners from making frivolous complaints. And might I add, despite the objections and the adamant opposition of the NDP, I am proud to say that my bill had received royal assent in 2013. Since a member from Alfred Palan has asked what our government does to ensure the correctional system actually corrects criminal behaviour, I am more than happy to tell her. The Correctional Service of Canada offers a wide range of interventions to convicted criminals sentenced to federal time and has long been recognized as an international leader in the development and delivery of correctional programs. Indeed, evidence consistently demonstrates that our programs contribute in a very significant way to making sure that when criminals are released from prison, they don't come back. This is evidenced by a lower likelihood of recidivism. Our correctional programs enhance public safety results for Canadians by making criminals accountable for their behaviour and by teaching skills that can be used to help them become contributing members to Canadian society, and in some cases, Mr. Speaker, often for the very first times in their lives. Additionally, those criminals who have been identified as requiring specific correctional programs, such as mental health and drug services, will be afforded access to these programs throughout their sentence. To this end, the Correctional Service of Canada began piloting the Integrated Correctional Program model in January 2010, which was designed to enhance program efficiencies, program effectiveness, and public safety results by combining the most effective aspects of existing interventions with the most promising innovations in the area of correctional programming. Our government is very pleased that our measures to combat crime are working. Recidivism is down. Crime rates are also down. I call on that member to stop opposing us on all of these measures and to get on board with making our communities safer. Thank you, Mr. Speaker.
The honourable member for Alfred Pellan. Thank you very much, Mr. Speaker. And it is with pleasure that I will respond to the Parliamentary Secretary. She mentioned victims' rights. Well, Mr. Speaker, victims' rights actually happen through proper rehabilitation. If we want to make sure that there are going to be less and less victims, then we have to make sure that the carceral system, the prison system, is compliant with measures that guarantee rehabilitation so that public safety is increased. Mr. Speaker, the Ombudsman for Victims even confirmed this, Ms. Sue O'Sullivan. She said that if reintegration programs are cut for inmates, then the safety of our communities itself is at risk. Mr. Speaker, it's not by cutting reintegration programs that we're going to make our communities safer, and I'm sure that the Parliamentary Secretary agrees with that.
Honourable Parliamentary Secretary.
Thank you, Mr. Speaker. I'm not sure if the member opposite had missed what I said in my first remarks, but recidivism is down, crime rate is down. Apparently something is working. But, Mr. Speaker, again, I can go on and talk about all of the common sense measures to tackle crime that the NDP has voted against. They voted against repealing the so-called faint hope clause, which gave early parole to convicted killers. They voted against ending house arrest for serious and violent crimes. House arrest, Mr. Speaker. They even voted against cracking down on drug dealers who target our children. Time after time, when they have the opportunity to choose between the rights of victims and the rights of criminals, sadly, Mr. Speaker, they have chosen the latter. Despite the objections from the NDP, Canadians know and they can trust that our Conservative government will continue to work to combat crime, continue to support the victims on crime, in order to keep our streets and communities safe. Thank you, Mr. Speaker.
The motion to adjourn the House is now deemed to have been adopted. Accordingly, this House stands adjourned until tomorrow at 10 a.m. pursuant to Standing Order 24-1.